If you count the 2 years of articles, that would make 18 years at the sidebar.
And how were your briefing patterns like? I remember attending some of the BLA meetings, and when we complained about colleagues not giving us briefs, they would laugh at us. We were complaining that they were giving almost all the briefs to some of them, almost all the briefs to our white counterparts. They would laugh at us and say, "Oh, yalamba." How did you brief people?
CJ, I did my articles at a law firm that was not very far from the High Court. And when I set up practice, I set up my practice 2 blocks away from the High Court for the simple reason that I realized quite very early in my legal career that if you practice next to the seat of the High Court, you would be capacitated, equipped in what you would call correspondence work. I did a lot of correspondence work, and that shaped my knowledge and legal skills substantively and procedurally. As far as briefing, CJ, I took a conscious decision back then that a brief from my office would not go to anybody but our Black practitioners who have struggled in the same fashion as I have. And I made it sure, CJ, at the time, that I should brief them on virtually everything. And CJ, because the women advocates were few, the likes of Advocate Isemenya and the others, and the former DCJ, they would send me a list of newly appointed or admitted women advocates. Then I would brief them. CJ, if you recall back then, to prepare particulars of claim, you would charge as counsel somewhere in the region of 60 Rand or 70 Rand or 80. And if I had given a junior counsel about 10 briefs from my office, I mean, it's about 70 Rands, it's quite 700 Rands, it's quite a lot of money then.
No, it was.
And unfortunately, CJ, I could not have the opportunity to brief you because you had to take off to Mafikeng. But the others I had.
Well, for what it is worth, Judge President Lambo did give me a brief, although I was in Mafikeng.
Oh.
And for how many years were you a High Court judge? In Gauteng?
I would say about from 9 years.
Well, we've had some challenges regarding reserved judgments in the Gauteng High Court. Did you have similar challenges at some stage of taking longer than is desirable to deliver judgments?
CJ, I was in the fortunate position that when I joined the bench, I was what they would refer to me as the last born of that division. So I tap a lot on the experience of senior judges, and I make it my business to trouble them and also ask them how over the years they have managed not to have reserved judgments. CJ, I may put it this way. A reserved judgment lives with you. Whatever you do, wherever you go, it's there. And I would liken it to and something that is unfulfilled, something that is an expectation that ought to come through. So once you have it, unfortunately, CJ, you can't rest. So I I delivered my judgment promptly.
Well, all manner of reasons were advanced by some for not being able to do so. Previous disadvantage and so on. All right, let me put it this way. How would you advise a newly appointed Gauteng division judge to ensure that they don't stay as long as a year, 2 years, or more with a reserve judgment? What is it that they must be careful not to do? What is it that they must be alive to in order to live up to the expectation
CJ,
of the litigation?
I think the answer is simple. Scorn yourself delights. I'm an insomniac, CJ. I don't sleep. I sleep very few hours. So all my hours are for reading and writing those judgments. And the advice I would give to them, which I have given to them over the years, is after each and every hearing, go to your chambers, put the books away, write what you think transpired in court on that day. And once you can maintain and master that discipline, you already at the end of that day, you have something that you can work on. It could include evaluation, assessment, and summary of the witnesses. By the time you get to write the main judgment, you are half the way there. And CJ, I know it has been raised that because we come from previously disadvantaged communities, we may not be having the necessary experience to adequately prepare and deliver judgments promptly. I think, CJ, it requires self-discipline. Let's knuckle down and do our work. It will happen. I would go as while I was in Joburg and inducting new judges, I would go as far as inquiring from them about the status of their reserve judgments, because I know it can be problematic. If you can, in that division in Johannesburg, if at any stage you can be carrying about 4 judgments, I was told you're not coping. So you have to avoid to have more than 4 judgments per term.
I don't want you to say anything that could jeopardize your relationship with colleagues. I don't want you to say anything controversial, but I would want you, as circumspectly as I believe you're capable of doing, to tell us how you managed to navigate your way around the challenges at the SCA. The challenges, I mean, and you don't have to touch on it, I mean, notwithstanding the number of complaints we have had at this forum about the so-called top 6 and how the so-called top 6 relates to junior judges and other judges. How did you manage to find your way around that space and be as comfortable as I understand you to have been ever since you got there?
CJ, for all my life, I've been an activist. And for me, I have never allowed anybody to trample on my toes, my head, and everything else. The advantage that I had when I went to the SCA is I had judgments which I wrote whilst at the High Court in Johannesburg. And those judgments preceded me in the sense that they were up there for appeal. And when I went there, the colleagues had a fair idea of who was coming to act. But I knew then, because I've been following the history of the SCA. CJ, just to digress a bit, I may say something just to indicate why I'm saying I have been an activist and also a judicial activist. Very early in my judicial career at the Gauteng High Court, we realized quite painfully that the SCA was not truly and properly representative. The only African judges were J.P. Mlambo, President Maya, the late Deputy President Mutiani, and Bati. The numbers troubled us. And because it troubled us, we were not prepared to be supine. And we took a concrete resolution that during one of the interviews of the JSC, because you would have to go to the SCA per invitation as in other courts. Then we had 2 or 3 judges, the late Justice Pusielo, Justice Seriti, and Justice Shongwe. We deployed them to the interviews. And so that when they were asked, why haven't you applied? Why have you applied? You have not acted. And they said, nobody has called us. And as a result of that agitation, the doors were flung open. And the likes of us had that opportunity to go and act. Otherwise, if we had sat back, one never knows what would have happened. Now, coming to your question, CJ, about the top 6. Yes, it is true. We had those problems, and we experienced those problems quite painfully. I witnessed, I heard, I experienced, and it was painful, CJ, when colleagues, especially junior colleagues like us and me, were subjected to unfair criticisms, unfair differentiation, unfair treatment by the senior colleagues. That troubled me a lot. And at any and every given opportunity that I heard, those top 6, they know very well that I raised issues with them, much to their chagrin, and I did not care whether they liked me or they did not like me. And that helped in a way. But they continued until when President Maya took over as deputy. We had a lot of meetings. And especially because at this forum, we were chastised as a court for not treating junior colleagues properly. And that worried us. And remember, CJ, I had been in that court since 2015. I acted for the whole year in 2014. The following year, I got appointed. And I know, and some members of the top 6 were opposed to my appointment at the SCA. But unfortunately for them, this body saw it fit not to consider their views misplaced as they were, and endorsed my appointment. So what President Maya did, which is commendable, we firstly had what you'd call your sensitivity training. The top 6 boycotted it. Then that first meeting, it was like we're preaching to the converted. And the problems, the wound kept on festering and festering. And then we realized we were not resolving this. And then we had another one in 2019. CJ, at that time, you'd recall, I was acting in your court. I specifically requested your permission to go and attend that meeting. And it was painful. I could not sit back and say, because I am now acting at the CC, my colleagues down there, they can do as they please. And I went to that meeting with your permission. It was a worthwhile meeting. Gloves were off. We told the top six, to excuse the word or the pun, where to get off. Justice Pete was also there. And some, there is this thing called unconscious bias. Some had it, some were just deliberate. And we talk about a variety of things. And the reason being, we could not afford to have this court all the time going the wrong way when all other courts are on the right trajectory. I am made to believe that subsequent to that meeting, attitudes change, but there is light at the end of the tunnel, I'm told. I keep in contact with that court all the time. One of the other things that I do, CJ, is I am in the induction committee at the SCA. The purpose being to anticipate judges who have been invited to come and act, to induct them, to prepare them as to what to expect at that court. I have done that, CJ, while still acting in your court, and I hope I did not breach any rule. And because it is important for me that my colleagues, black and white, understand the culture of the court and understand what is expected of them. And that has worked. And I've had good reviews, good feedbacks that at least things have changed for the better. So I'm not sure if I've answered your question, CJ.
No, you have. You have. The next question, please listen to it very carefully because it may be necessary that you decide to pass and not answer it. Please be alert to the next question. Some of us have things written about them as judges almost all the time, even lies. Why is it, if you know, that this shocking development around the top six does not seem to have received the public attention it deserves by the same structures that write a lot about us and interrogate and fabricate things about some of us, and that they were never, there was never a deliberate action to find them out, to name and shame them? Why does it look like there is some cover around this top six? Why does it look like there is no scrutiny over the top six? And the next question, and again, please, my brother, listen to it very carefully. Who is the top six? That everybody has been, that some judges have been complaining so much about. And if you are not comfortable to say who the top six is, please don't go there.
CJ, the issue about the top six is simple. I'll tell you. Let me first start to respond to your question about why they have not enjoyed the exposure that other colleagues have. CJ, it's a really
Enjoyed or endured?
okay. Thank you for the emphasis. CJ, the answer is simple. We do not own the media space. And if we have control of the media space, we would be able to write about everything that happens there. People would write, because the top six then would include people of particular color. The media and everybody else would shy away from exposing perhaps the darlings of those people of the particular color. So that's what happens. So the likes of you, unfortunately, CJ and some of us, if it's considered that we may have erred or misdirected ourselves one or the other, the media would have a frenzy over us. And it's a fact, it's a reality that has to be accepted. So that is why, CJ, you have not seen any reporting about it. And it also surprised me because the proceedings of the JSC are open to the public, but you will not see or hear anything written extensively and expansively about what is happening or the toxicity of the top six then.
Yeah.
Okay.
Yeah.
Now you wanted to know about the top six.
If you are comfortable. If you are comfortable.
No, CJ, it's not a problem. The top six varies. It goes according to seniority. You would have your president, you get your deputy president, the next senior judge, and in their descending order. And it varies sometimes from one term to the other in the sense that one or two senior judges may have gone away on long leave or acting in another.
Can I be more pointed? Can I be more pointed? And please, again, don't answer if you are not comfortable. Who are the personalities who fall within the parameters of the top six that have been complained about? Because I don't want it to look like the judiciary is covering up anything. To the extent possible, if there are people known who are making lives of fellow judges uncomfortable, and it is possible to say, these are the people that have been complained about, it must be said. But please don't put yourself into unnecessary trouble if you have to avoid answering the question directly.
CJ, if I had been a victim of a backlash from the top six, I would say Justice Spets, who's now in the top six, has treated me badly. The problem with naming and shaming the top six is the complainants have not taken up the courage to say, this judge is the one who has violated me one or two things. So what I would be saying would be purely what I heard.
Okay.
Yeah.
Okay. No, I understand. Now, which judgments that you wrote as an SCA judge or even a high court judge would you say it's so outstanding with all sense of humility, that it commends you for appointment to the Constitutional Court, and take it further to the judgment that you have written as an acting judge of the Constitutional Court.
CJ.
In other words,
Yeah,
this is not time to try and be humble. You've got to brag. Leave it up to us to say, hey, but you blew your trumpet too loud. But it's the only opportunity you have to brag here.
Okay, CJ, thank you for the opportunity. Please indulge me.
I will.
CJ and the commission, many, many years ago, as an attorney, I will start by bragging from my position as an attorney and go back and later at the High Court, SCA, and the Constitutional Court. And in that way, you'll see my trajectory. And I think I would do justice by proceeding along that premise. In the early days as an attorney, like I said, CJ, my practice was about 2 blocks away from the High Court. There is a judgment that I was the instructing attorney in it. It's a seminal judgment in the law of defamation. It's a judgment by Cameron J., as he then was. It's Holomisa versus the Argus newspaper. It's on the law of defamation. That judgment is quoted extensively everywhere, and you cannot do any case of defamation without any reference to that judgment. It's a 1996 judgment, and I was still then young, CJ, and I am proud to say that is one of the most contributions that I made as an attorney. Again, CJ, I may emphasize that my counsel of choice, to respond to your question, whether my briefing patterns were skewed or not, Advocate Dalim Pofu was my counsel of choice then. And then our association as far as goes a long way. So I had confidence in him against a big newspaper with all the funds and everything else, that he would do justice to my brief. And indeed...
Should we ask him to recuse himself?
No, CJ.
Okay.
Yeah. Then, CJ, I was appointed as a judge in the High Court. Very early in my judicial career, I was allocated, before that. It was unheard of when I started at the High Court that an attorney could be allocated agent court duties. I became a guinea pig. I was put in that court. And I'm proud to say that I acquitted myself very well. And with the result that, unbeknown to me, the powers that be decided that I should take up residence in that court. I was more in that court every second or every third or fourth week. That helped me a lot because it capacitated me. It made me a judge that I am today. And the sky did not fall. And as a result of that, other acting judges were assigned those duties in the agent court. And because I've succeeded, a mere mortal like me, why couldn't others succeed? Then I was allocated a matter of print media versus the Films and Publication Board. dealing with censorship, and also dealing with some constitutional issues of Section 16(2) of the Constitution of the Films Publication Board, which I declared that section to be inconsistent with the Constitution. That judgment was taken up on appeal to the CC, and the Constitutional Court confirmed my judgment. So in other words, CJ, I had knocked at the Constitutional Court very early in my judicial career. I then had occasion in the Urgent Court to write a judgment on arrest suspectus Dei fuga. Those are civil debtors and civil imprisonment. The matter had come before a senior judge in the Urgent Court, and the senior judge had ordered that the debtor be arrested, and the debtor was arrested at the Morningside prison cells. When my turn came for the Urgent Court on reconsideration, once after the senior judge had finished his stint or his term, it filled me with a sense of uneasiness. And I said, this cannot happen. I ordered the immediate release of that person and wrote a judgment. And because the issue of the constitutionality of the section was not squarely raised, I touched on it and left it open. And CJ, you had occasion later to deal with the same principle in Malachi. And then you quoted my judgment authoritatively, and that gave me peace and happiness.
I must confess at that stage that I don't remember having met you before. I don't remember whether I even knew your face, but anyway.
Our judgments met. So CJ, then whilst at the Joburg High Court, I was exposed or put mostly in motion courts, opposed, unopposed, and everything else. There is one aspect that I need to bring to the attention of the commission is, a year after my appointment, that was when there was a course on fast tracking of women judges, and by Minister Mabandla and Chief Justice Langa, may his soul rest in peace. The women were then asked to come to the High Court in Joburg to be mentored. As you'd understand, some would be there and their judges would not be having work. I looked out for the women, aspirant women. I remember I had one interesting insurance matter. I had the 4 women sitting just below aspirant judges. And then we went through the hearing and everything else. And then thereafter we would have discussions. And in that way, I empowered them. Remember, I was a year old on the bench. I was able to identify and understand that they are not there through any accident. They deserve to be there. And some of them are, or most of them are judges now. And some have followed me to the SCA, and some have acted in your court. So it was a pleasurable experience for me. CJ and the commission, the Joburg High Court prepared me for the SCA. Like I said, my judgments preceded me. I was exposed to a variety of cases. I was in the tax court. I did IP work. Then I had no experience at all with tax matters. I was thrown into the deep end, and I'm responding, CJ, when I raise the tax issues to the lack of experience or thereof. So I was put in that court with an experience, with a tax experience, one may recall it, limited to a postage stamp or to that return form. Then I was able to sit in that court, wrote judgments, went to the SCA, some of my judgments, some were confirmed, one was not confirmed, painfully so. And whilst at that court, then I was allocated one heavy tax matter. I think I need to say this because it gave me a sense of satisfaction that this is a tax matter which had been going on for more than 12 to 13 years. And it traverses a lot of countries overseas and everything else. And when the council approached me, they said they would take about 3 weeks to lead the taxpayer only. And I realized then that if one were to go on in this way, I'm going to be here for the next coming 12 years with this tax matter. So what I did, quite unconventionally, obviously with the concurrence of the council, then I said, would it be possible if I can give you a week to go back and reduce the evidence of the taxpayer into an affidavit? And they did exactly that. They reduced that evidence into an affidavit, and then it gave me an opportunity to read the affidavit, and I read the affidavit. It was in a more 2 ArcLiver files. And then we would start with cross-examination. So that's when cross-examination started. After 3-4 days into cross-examination, the matter got settled. And it saves the fiscus a lot of money in terms of personnel and in terms of the refund to the fiscus. So this is the exposure that the Johannesburg High Court provided me with. I do a lot of training for the Joburg High Court. I still do. Now I am moving on to the SCA now. CJ, when I got to the SCA in 2014, I had missed the SCA bars in 2011 for reasons not relevant for the purpose of this commission, and which was painful to me, but I knew that my time will come, and it came in 2014. I was allocated 3 judgments in my first term. I wrote them all. 1 judgment went to the CC, and we were found to have been wrong. I was the scribe. I was set aside. It's Arun versus the City of Cape Town. And on the panel, I had Justice Nafsa, Justice Ponan, Justice Theron, who's now with the SCA, and retired Judge Willis. The judgment of the Concord was written by DCJ Museneke. And in the second term of the SCA acting, I had occasion to write a judgment, Pfeiffer versus Van Wyk, a judgment dealing with enrichment lien. Then The second senior judge suggested that we should give an extempore judgment. And the term there is to imp it. I refused. Remember, I was number 5, I was junior. I refused and I said, the reason why I'm in this court is for me to write. And I wrote the judgment, and the judgment was marked not reportable, even though I thought it should have been reportable, but the panel said, it's not reportable. I accepted. And lo and behold, the judgment found its way in the hands of the academics. I think Professor Slema, in the last interviews, asked me why I did not make it reportable, and I told her that it was not my choice. And she said she liked the judgment and she was going to prescribe it to her law students. So that is another contribution that I made to the law students, arising from my insistence to write the judgment. And I want to say again to Professor Slema, thank you for that. CJ, I wrote many judgments at the SCA. I also wrote on tax. I wrote on IP. I sat in panels. I sat in panels where we did customary law, I think about 4 or 5 cases. Ludidi, Mpepu, and the late Mama Winnie Mandela's matter, and the criminal matter of Inkosi Abatembu Dalinyebo. So my experience is diverse. My experience, I would regard myself as a versatile lawyer. I wrote another judgment at the SCA with insolvency practitioners, and it went to the Concord. The judgment was confirmed. The majority judgment written by Brother Jafta and Justice Madlanga writing the minority judgment. And CJ, there's a judgment that I wrote again at the SCA dealing with the K word, and which I found it offensive and not having a place in our modern society. Again, CJ, I don't think you knew me then. You had occasion to write a judgment, and then on a particular topic, similar topic rather, and you then quoted me authoritatively, and I must thank you for that. A reference to one's judgment by a higher court strengthens one's ability and one's relevance in the legal fraternity. CJ,
I take it you are done now, or you are rounding up.
I'm not done, CJ.
Okay, just try and round up.
I'm coming to the Concord. CJ, at the Constitutional Court, it is different from the SCA. We don't have seniorities and everybody is more equal. Your top 6 doesn't exist. There is nothing like that. It's a comfortable space to stretch one's leg and write. And if you've read the book of Steve Bantu Biko, you write what you like. And I was able to write and freely, not to say I could not write freely at the SCA. I wrote the seminal judgment that I wrote, CJ State versus Chavalala, I had to do a lot of research, check so many case laws or case authorities, and to come to the conclusion that common law or common purpose does apply to the common law crime of rape. That judgment really affirmed our society, CJ. And if you'd remember, CJ, we almost missed that opportunity. And in my post-hearing note, I said we have jurisdiction. We should deal with this case head on. And I'm glad the majority or all the justices agreed with me and gave me the opportunity to write that judgment. And it's a good judgment, I must say, if I were to praise myself. Yeah, and I wrote also on other aspects of the law, on labor law, on admin law, everything. CJ, you gave me that opportunity to write, and I thank you. Over and above that, CJ, my other extra judicial duties. I am passionately a trainer in the School of Excellence at Sajay. I train, mentor aspirant judges, permanent judges. One would ask, where do you get the time? I have all the time to do it. And I've, in one of the sittings, just not to be long, I put up a team of the trainers who were women only. The reason being simply that I sit with women colleagues on the bench, and I don't see any reason why they could not or they cannot be the one imparting the knowledge and the experience on other aspirant judges. And now recently, CJ, as in 2 weeks ago, I also coordinated a course through the request by JP Mlambo for exclusively or only women lawyers. We had about 35 of them, and then we ran that course, and I think the majority of those women would be acting in various courts in the country. And we took them through on judgment writing, motion court, criminal, civil, and everything. We also gave them assignments. And once you give them assignments to write judgments, you also, as the facilitator or the presenter, you learn the trades from other people. And the reason why I did that, CJ, is the realization that our women are marginalized, our women are left behind. So it is important that we should emphasize and help them. When I look back, I can simply say, CJ, in conclusion, that in all the courts, I have candidates who have come through Sajay and their judges. I take comfort in the fact that I can say my seats are growing on other people's trees. Thank you, CJ.
Thank you, Justice Matopo. Colleagues, may I have a list of those who would like to put questions to Justice Matopo, please?
Makwanisha,
Muimang,
Lamola, Lucas,
Nyambi, Ofu,
Please, sorry. Yes, after Honorable Nyambi, who's next?
just me, CJ.
Okay.
And
Thank
Judge President.
After Honorable Singh, who is it?
Deputy.
Oh, okay. And after Prof, who is it?
Did you hear Dodovu?
And
Tepe.
okay. Any other colleague?
Chief Justice, do you have Petse after Tsepe?
Okay, DP. You know, I sometimes make a mistake instead of saying DP, but I say DP Tsepe. Maybe I'm prophesying. After Deputy President Petse, who is next?
Did you hear Lamula CJ?
Yes, Minister, I've got you right here.
Thank you.
CJ Jenny Kane, please. If you could
Thank
please
you.
add me at some point. Thank you.
Is that Advocate Kane? Is there anybody after you?
Yes.
Who comes after Advocate Kane?
No.
No.
Did you get my name? Chief Justice Breitenbach?
I've got you, Honorable Breitenbach. You're right here. You are number 4.
JP
Just put me right after Bredenbach.
When I always want to be right after Breitenbach.
Wait a minute. Oh, Honorable Malema. Okay, you're
No, I'm
coming
joking,
after JP
CJ,
Lam.
I'm fine.
Or you don't want to be included?
Chief Justice, can I just, Matonsela here, can you just record that I don't have any question for this witness?
What about Honorable Malema? Should I include you?
No, I'm
Honorable
fine, I'm
Malema?
fine, CJ. I'm fine.
Okay. All right. Okay.
Do you have my name,
All right.
CJ?
Sorry.
JP Mlambo.
I've got you, JP.
Thank you.
Okay. Honorable Maganishe.
Thank you very much, CJ. Good morning, Judge Mutapo.
Good morning, Commissioner.
Thank you very much. Now, I have 3 quick questions, but I will start by 2, 3, yeah. But I will start by making an observation. I thought you were making a farewell speech as I was listening to you. It was more like a farewell speech, and this is what I've done, so I'm leaving you now. And I hope that is not the case. Let's start with the young Stephen Matapo then.
Ramaka.
Ramaka. Let's start with the young Ramaka Matapo. Very bright student from the University of the North. 4 distinctions in BPROC. I know that you said that you had to take care of the family, but with those good marks, after you were in practice, why didn't you proceed to LLB and postgraduate studies? First one.
Commissioner, I indicated that I come from a large family, and to be specific, I'm one of the 11. And everything that the family put together, they put together for my education. And you would know if you were exposed to the same hardship that I had, that there is nothing like black tax. It's your responsibility to ensure or make sure that your siblings attain more or less the same level of education that you have. Everything that I had, I plow it back to them. And I'm proud to say to you that I was able to put through to university almost half of my siblings. And then with the meager amount that I had in practice, I did not want to be that selfish brother who was more interested in his personal advancement. And remember, you are an attorney, people assume that you have the money, and you don't. And you have extended families, your nieces and nephews. They also look up to you to put them through to university or schooling. I had to take some of them, right, the nieces. And I can proudly say to the commission now that I have 2 nieces that have just recently completed their LLBs, and I'm helping them to look for articles. And I had a brother who became a lawyer, sons and stuff like that. So yes, I could have, but circumstances were such that I could not. But what I did was, I am not going to be a mediocre lawyer because I did not have an LLB. I capacitated myself and I know more law than most. And I know more cases than most.
Thank you very much, Judge Matapo. There is this colonial language that is being used, and I think sometimes it is part of the problems. You see, in Parliament, whether you have 20 years or you have just 2 months, you are just a member of Parliament. But in the profession, there is this strong emphasis on juniors, junior judges, junior counsels. What is your view on that? Tying it up with your experiences in the Supreme Court of Appeal.
I agree with you. It's an antiquated system of hierarchy that we found in the legal profession. Mr. Madonzela is silk, and Bofu is silk, and because they're silk, they've earned their stripes to be called silk. So that is where this hierarchy comes from. And when you get to the bench, because of your many years of experience at the bench, and then we loosely refer you as our senior, and it's a leadership recognition in one way or the other. And in actual fact, there is nothing wrong with it. The only thing that is wrong is when the leaders or your seniors abuse their position.
CJ, through you, just the last one. A lot of reference has been made yesterday and today to the top 6 in the SCA. Quite clearly, you would say some of the things that are attributed to those judges, it shows that they have not imbibed the spirit of the constitutional dispensation in them. Why should ordinary people expect that they will get justice from such people? Especially from judgments coming from, I would not say only the SCA. I think there are some courts that they might have such tendencies. As a layman, why should I expect that I would be given justice by people who display such tendencies?
I think I need to put one aspect to rest. Yes, we had the top 6 at the SCA. Things have changed drastically or dramatically in such a way that the top 6, or those who used to be part of the top 6, through natural attrition, are leaving the court. We are no longer going to have that top 6. And where I am sitting, I would also be part of the new top 6. And I have learned from the old top 6 not to do what they did to the others. So I need to put your mind at ease that animal called top 6, we have exorcised that spirit. We will no longer have. DP Petsa is number 2 now. President Maya is number 1. So in the top 6 that we have now, I think 2 members of the top 6 come the end of the year or early next year would be gone. And the court would now be in our hands. If we fail it, we would have dropped the ball in our hands. So we can't afford to do that.
Thank you, Chief Justice. I think when we deliberate, we might want to take the matter further, because I do believe that they are representing a world outlook. Those might be gone, but I don't think the tendency will just disappear like that. But I think when we deliberate, we might want to revisit that.
Thank you, Honorable Magwanesha. Honorable Moiman.
Ke a leboga, CJ. Good morning, Justice Matapo.
Good morning. Good morning.
If I may have Matopo.
Matopo. No,
Matopo.
Ke a leboga, CJ.
Thank you.
In your profile, I see one of your judgment is the Democratic Alliance against the acting National Director of Public Prosecution, where you found that it was desirable that the transcript be produced to test and properly contextualize whether the decision of the ANDPP was based on rational ground or not. Surely from where we come from, the ruling party, definitely this decision put us in it placed us in a conundrum. And I think you'll appreciate that following that decision, the Supreme Court of Appeal found ultimately that there was no connection between the recording of McCarthy and the decision of the ANDPP. Was that decision to test the rationality, to put the rationality to test, was it informed by what the CJ in one of his judgments said? He said that it is important that public office bearers must ensure that they act within the confines of the Constitution, and that this is so because constitutionalism, accountability, and the rule of law form a sharp and mighty sword that stands ready to chop the ugly head of impunity of its stiffened neck. And Justice Madlala also in 2008 said, there are certain foundational values, transparency, accountability, and rationality that must always inform the decision that we take. So, given the need to educate not only ourselves but also the public, do you think that there is a room to improve the role that the courts can play in terms of promoting good governance, particularly the rule of law, without necessarily blurring the line between the three arms of state? Thank you, Chief Justice. Thank you, Justice Matopo.
Thank you, Honorable Moeman. Justice, over to you.
I am not sure if you want me to traverse the judgment itself.
Yes.
And if so, just a bit of background on the judgment, which I want to believe you're au fait with it. When the matter came before me, it came against the backdrop of what had happened before the SCA. And there was a dispute about what that order provided. And it's a judgment of the SCA by Justice Nafsa. And when it came before me, the office of the NDPP or ANDPP elected not to file an affidavit, nor anything, right? Then before the proceedings started, I called the counsel to my chambers and asked whether there was anything that I may have missed in terms of the papers in the court file. Counsel for the NDPP and former President Jacob Zuma said they have elected to take a low point, which they were fully entitled to. And my question in court was, if the low point is not good, are you prepared to lie on that bed or fall on your sword? And they agreed. And it was just whether the tapes should be released to see what was happening between McCarthy and his Bulelani Nguka and his officials at the Scorpions, as it then was. And remember, it was then against the backdrop that there had been some illicit interceptions of conversations, and that those conversations would assist in the prosecution or dropping of the prosecution of the former president, and like your abuse of power and everything. The DPP, Mokotedi Mshe, had withdrawn the charges, and the DA took the matter up. So when it came before me, I had to assess whether that decision was rational or not. And I wrote a judgment. And that judgment was a culmination of other judgments that led to where we are now in South Africa. And you would ask me whether it was right or whether there was an encroachment on other arms of government, I would regrettably say no. And to answer your question, it is important that a proper and clear distinction must be drawn between through arms of government because of separation of powers. One arm of government should not be seen to be encroaching on the other arm of government, because then courts cannot be allowed to start legislating. That's what we always are reminding ourselves each time you are encountering problems of a similar nature, to say, is this judicial overreach or not? So it's a very, very thin line. And sometimes in other judgments, you would see that the lines have been blurred, the lines have been crossed. And then fortunately, we have, and law is self-correcting. We have an appellate structure where I may have erred by crossing the line. An appellate structure would say, no. I wonder if I've answered your question.
Thank you, Justice Matopa. Thank you, CJ.
Thank you, Honorable Moeman. Honorable Minister.
Thank you very much, CJ, and good morning, Judge Matopo.
Good morning, Minister.
I was touched by your story of paying for your siblings, because I'm also a product of the same arrangement. My fees were paid at the university by my sister. So it leads to one Shangani idiom that says that vana va munhu va tsemelana nhloko ya njiya. I'm not sure in Sepedi it's also there. I've heard it's
Bana
also
ba
there.
motho ba ngwathelana tlhogo ya jiya.
Yeah. So I was touched by that, Judge.
Thank you.
My question firstly is on the on the judgment that you made on the Minister of Justice and Constitutional Development and other versus the South African Restructuring and Insolvency Practitioners Association. For the benefit of the commissioners, this case dealt with the challenge to the constitutionality of a policy to regulate the appointment of insolvency practitioners, which had the objective of promoting fairness, transparency, and the achievement of equality for persons previously disadvantaged by unfair discrimination. And you found that this was unconstitutional because of it was not in line with the court judgment on the court system. And I want to believe that because from your background, I can see that you are a practicing attorney. So you are at pains for sure to pen this judgment, because of your history as an attorney, you understood that the fact that there must be some kind of transformation amongst the insolvency practitioners. So my question is that at the time when you made the judgment, didn't you deem it fit maybe to put some kind of measures or remedy or some kind of creative remedy so that the department is left with something that it could implement in the meantime while it is developing policy? I'm asking this because to date we are still struggling to come up with the policy since the judgment was made, because the court system, as you have pronounced correctly, there are difficulties. The other difficulty that we are trying to revert back to is the issue of the rotational system. It also presents its own challenges. So my question is that at the time when you made this ruling, didn't you think that it might be in the interest of promoting black practitioners in the insolvency space to put some kind of a remedy while the department is given an opportunity to find a suitable solution to this quagmire.
Thank you, Mr. Minister. One has to be mindful of the fact that, as Commissioner Muimang has alluded to, not to legislate. Number one. Two, at the background of that judgment, you had that quota system. Three, you talk about the lived realities of the practitioners, especially the insolvency practitioners. When you read that judgment, you would notice that the policy that was in place sought to advantage your previously advantaged practitioners and sought also to have a condescending measure, in the sense that they would say, insolvency practitioner Lamola would twin with Mrs. van der Merwe. And one may say that is empowerment. It is not, because you become that junior perpetually and there is no room and for you to grow. I think when I wrote that judgment, the realization was the time has now come for our people to be accorded equal status in the country of their own. The fact that you find yourself unable at this stage to put measures in place to deal with it, I would strongly urge you, Mr. Minister, to make sure that those practitioners that I know very well, they should be accorded their space. I could not do anything because of being shackled by the principle of stare decisis in terms of the quota system as in the Van Heerden case. And the CC, alive to the problems that I had dealt with and faced in the judgment, also could not, in its wisdom, put measures that you are bemoaning the fact that should have been put in place. And I think the reason is simple. Both myself and the judgment in the CC by JAFTA took the point that this policy is rational. Does it serve any legitimate purpose? And when we found that it does not serve any legitimate purpose, you don't fix it, the problem, one by one. I would urge you, and I would also urge the insolvency practitioners to take up the cudgels and reform and reformulate this industry.
Yeah, no, thank you, Judge. You may not be aware, but we have recently appointed the first black chief master in the history of this country since democracy. What could you advise him on the basis of you having dealt with this matter to resolve this issue of transforming the insolvency space for the benefit of black practitioners in a manner that will be rational, will not be condensing, but will be to the benefit of the country as a whole? Because if black practitioners are given space to come into this industry, they will also be able to understand the operations of the economy, the insolvency world, and all that is. So with the benefit of you having sat on this matter, what could you want to advise the Chief Master?
Minister, the advice is simple. We should not be apologetic about what is rightfully ours. We should not be apologetic about the fact that we have been marginalized for far too long. What the Chief Master must do, have a meeting of all the practitioners across the broad spectrum. Sit down with them, have a policy in line with the two judgments, and critically look at the judgment and say, in what way can we make it possible that all the practitioners can operate in a space that is less objectionable nor discriminatory? We should take up the fight. I would say to the Chief Master, you can have your boss barat, your road shows and everything else. You hear, you'll give the Chief Master that necessary support.
Thank you, Judge, and thank you, CJ.
Thank you, Minister. Honorable Breitenbach.
Thank you very much, Chief Justice. Good morning, Judge Matopo.
Hey, good morning. Good morning. How are you?
Very well, thank you, sir. How are you? You'll understand that Democratic Alliance was particularly delighted with your judgment.
I know.
In that matter, yes, and as an ex-prosecutor, I was particularly delighted with your judgment in the Shabalala matter.
Oh, thanks.
There can be no logical reason why, with respect, that the doctrine of common purpose shouldn't extend to the Commonwealth crime of rape. So I think that's a wonderful development. I've listened carefully to how you have set out your support for previously disadvantaged practitioners with some admiration, but with more admiration for your trouble that you've taken with women, which is particularly admirable. I would like to ask you, seeing that you have a lot of experience in many courts, whether it's your view that women practitioners, but more importantly, women judges, are held to a different standard than their male counterparts. I would be interested to hear your views on that. Thank you, sir.
Thank you, Ms. Breitenbach. It's good to see you. You and I had many battles down there in the prosecution. And,
indeed.
And you would remember our skirmishes and the battles that we had. And at no stage did I ever think that you are less competent than most of the women. And you were a fierce and a formidable opponent then. And I think you still are in your own little space and wherever you are. I believe quite strongly, and this is a belief that I shared in all the walks of my life, that women have a right to be in the space in the same way as men. It would be a travesty of justice if we were to relegate women, as I said in Shabalala, to second-class citizens. On the bench, I have mentored a lot of women. I have interacted with a lot of women. There is something different that women bring to the bench. Men may have that rush of adrenaline. Women are able to sit back, listen, and afford litigants a hearing quite properly. If I were to fly back to the SCA, if you have Justice Maya presiding, and you know that the hearings would be filled with some warmth and would be filled with some deference to counsel and respect. So women indeed do play a major role in the transformation of our judiciary. I hope I have answered your question, and if you need clarification, I'm ready to do that.
I'm fine. Thank you very much, sir. Thank you.
Honorable Nyambi.
Thanks, CJ. Morning, Judge Matop.
Morning, Commissioner.
In the case of the Congress of the People and another COPE versus Shiloah and others 2012, the diligence and the promptitude that you display hearing an urgent matter late afternoon on Friday delivered a well-reasoned judgment on Sunday afternoon. This judgment was confirmed by the SCA on appeal. How important it is for judgment to be delivered promptly and timeously?
Thank you, Commissioner. The background to that judgment is I took over the urgent court on a Friday after 4. And that weekend, one of my sister was getting married. And as the eldest brother, and you know, in terms of the African tradition, I had to go around looking for the goat or the sheep to slaughter and make sure that everybody is there. And when I think at that time, that was when the urgent court in Johannesburg was allocated to one judge. So I could not pass the buck or ask anybody to do it. Those duties fell on me. And COPE then, as you would recall, it was more of a breakaway from the ANC. And before hearing that matter, just to give that background, I spoke to the council on either side to see whether they can find a way with each other, the two warring factions. And it's a missed opportunity, I must tell you. They could have taken my counsel. They did not. I had that application on Friday afternoon. And as you would appreciate, while doing those negotiations and preparations, the judgment was always at the back of my mind. And it was so urgent, it came in the urgent court. So I had to work at night and make sure that Sunday I deliver a well-reasoned judgment. And it is important that judgments, to the extent possible, be delivered promptly. You do that because you want people to be able to regularize their affairs. A long, outstanding, and delayed judgment suspend the people or their affairs. So that's why I had to deliver it as quickly as possible. It is important. Let's not delay. One you would say justice delayed is justice denied. You can well imagine if I had reserved judgment, what would have happened? You have two bulls in one kraal fighting for the soul of the leadership of COPE. So I had to resolve it, and I tried them. I implored or nudged them to resolve it, and they could not, and the judgment came. And COPE lost its hope to live.
Is what it is. Thank you. My last question. My colleague, Commissioner Malema, would always remind me that in our respective villages, it's always a nice feeling when we see a person that has been appointed by us doing extremely well. So at all times, we must go for merit. And I look at the appointment, or the letter that is coming from BLA talking about you, Judge Matop, talking about your attributes, that you have got the respect by the legal fraternity. We are highly motivated, we are dedicated, hardworking, well organized, well spoken, and meticulously prepared for court appearance, independent, reliable, and mentors acting and junior judges. Maybe if you can tell us what is the secret behind these attributes?
Commissioner Nyambi, I schooled in a village called Butokwa in the Mukomeni area.
That's why I married.
I grew up there in my high school life, and I've seen when there how painful it was for all of us to pull ourselves through our bootstraps. I realized it then that when I have the opportunity, I must make sure that the road that I have traveled, it must be a road less traveled. I don't want people to travel the road that I've traveled. I may have survived through the grace of God, and I don't know whether other people will. So I took it upon myself to make sure that I train, I mentor from law students through the auspices of the BLA, Law Society, everything. When I started, I didn't have that opportunity, and most people did not have that opportunity. But because I'm in a privileged position, I should not kick the ladder. What other people do once they climb the ladder, they don't kick it because you'll pick it up and go up. They lift the ladder up and go up the roof with the ladder, and then you will never know how they got up there. So I realized I should not be that person. Be there, be involved. One other thing that I would tell you, or tell the commission is, even when I'm acting at the Concord, right, I still induct judges at the SCA. I still induct judges at the High Court. I still prepare judges for these interviews. And while preparing for my interview, many judges approach me to prepare them for the interviews that we'll be having in subsequent days. I did not say, wait, I've got my interview to prepare. I put that aside and prepare. And to prepare somebody for an interview takes 2 hours max. To induct somebody takes 2 hours max. So this is the time that I've been given. And this is the time that I think I should share with everybody.
Thank you. Continue doing good for the country and the judiciary. Thank you, CJ. Thank you, Judge Matop.
Thank you.
Thank you, Honorable Nyambi. Commissioner Mpofu?
Thank you, Chief Justice. Good morning, Justice Matopa.
Morning.
Well, I couldn't resist this opportunity because you always ask me difficult questions in the Concord. So it's my turn now. I'm in charge. So, CJ, always asks us not to do preambles, but I thought, CJ, with your permission, I just wanted to put some perspective. I'm always talking here, these commissioners know one of my passions is this issue of briefing patterns. and when it's not happening. So I think also when it has happened, I need to talk. I just wanted to take you back, 25 years ago, when you and I did the matter of Holomisa versus Argus newspapers. And Chief Justice, the point I really want to make is that, if you say you gave a brief to Advocate Mpofu, people might be thinking about Advocate Mpofu of 25 years later. But then we were talking about someone who was 3 years at the bar. First time my name ever appeared in the law reports was in that case. It was, as you say, a very significant case. And what most people don't know is that my opponent was Gilbert Marcus, who had been my mentor. When you go to do pupillage, you get a mentor, someone, those days, actually it was called a master. So you can imagine how terrified I was getting into that courtroom. And that's what I want you to explain, the value of empowering a person at that level and creating that opportunity. You've made many examples of what you've done in the context of training judges, training aspirant women judges, and so on. But that it's not about money. In fact, I don't think our client, General Olomisa, even paid us. So wherever he is, I think he still owes us. But we must go and collect our money from him. So it's not about money. It's about trusting somebody with that breakthrough, and then obviously after that they have to fly on their own. How would you say we should entrench that so that it's not a matopo who takes a leap of faith on a particular person, but that there is a system, and we've been talking to the minister about that, a system whereby those breakthroughs are actually regularized and normalized, particularly at the behest of the state.
Thank you, Commissioner Mpofu. I think it takes self-belief. If you're lacking self-belief, it will be difficult to believe that Minister Lamula would competently do the work. I mean, there were doomsayers when minister was appointed to the portfolio that he's in, that he won't make it. Look at him now. So whoever has that self-belief, and then you inculcate that self-belief and transform it into the realities, you would be able to say, yes, I have belief and faith that this person will make it. Now, when you look at the briefing patterns, it's a sore point that despite the noble efforts that the minister has put in place, remember, government is the largest consumer or the biggest consumer of legal services. We should not be having this debate. We've had this debate 25 years ago, and it is wrong and remiss of us to be still having this debate. While I was at the Joburg High Court, I sat mostly in motion court. And I would see junior counsel moving applications and like substituted service. And you can see there is nothing to it. And their white counterparts would be having a whole stack of files. And then what I would do, I would then call the state attorney down the road to say, My observation in court left a sour taste in my mouth. What are you doing to ensure that work is transferred to everybody? And you see, women counsel. There is this stereotype that white women counsel must do matrimonial work. And I mean, to say the least, this is nothing else but nonsensical. They are more equally competent to do the work that their male counterparts are doing. I mean, to castigate you a bit, this is even at the bar, there is that pigeonholing of women. Now, coming back to the briefing patterns, Minister, I'm happy that you have appointed a Solicitor General, but let's not have a figurehead. Let's have somebody that would ensure that the work gets translated. And the translation must not be, you just give me work and go and do applications to compare. There should be value in the work. And sometimes the state attorney would say, I've briefed so many, but there is no value in the work. Let's have value. And there should be a rule, if it was possible, to say, for every senior brief, it must be compulsory that we must have a women or a previously disadvantaged counsel. It hits across the board, black, white, female, Indians, and everything. They're all suffering, and we can't allow it. I think the time has come.
Thank you. Just to say a matter of clarity, when you are talking about the top 6, because both you and the Deputy President Pets are judges, so you are not able to speak in public, so we have to speak for you. I think there's a potential misunderstanding when you mention the name of Deputy President Pets. As an example, someone sent me a message saying, is he saying Deputy President Pets is the king of the top 6? But I think you clarified that what you meant by the top 6 in terms of seniority and what you call the new top 6, the good top 6, so to speak, and the one that is fading away by natural attrition. So I thought maybe you might want to clarify that example.
No, but the reality is part of the top 6, the new top 6.
Yeah, the good top 6. Okay.
Yeah.
Thank you. Yeah, I didn't want to be sitting here next to the other top 6. All right. Then in terms of just going back to the case that you and I did, but now more on the technical side, some of the principles that we established in that case, which were now these days are taken as common cause, such as the horizontal application of the Bill of Rights, and the fact that at least for our media colleagues who are here, it established the principle that the media in the space of political activity could publish false information about the person, as long as that was reasonably done. As I say, those are principles that have now become almost trite, but there's still a debate which you and I started in that case, which has not been resolved, around the paramountcy of freedom of expression, which is clearly an important constitutional value, on the one hand, weighed against the value of human dignity of the person who's being defamed, which must also be protected. As you know, human dignity was proclaimed in the case of Makwanyane, the death penalty case, as one of the most paramount rights, second only to the right to life in the context of apartheid, because apartheid by definition was the denial of human dignity of people. And we argued this forcefully in that matter. Where are you on that debate? Because then I know where you were, then you were with me. But as far as the current dynamics in South Africa, as between weighing those two very important rights, do you think that contestation has been resolved, will be resolved? Looks like it's better resolved than it was 25 years ago.
Thank you, Commissioner Mpofu. Subsequent to that judgment, I had occasion to pen another judgment while I was acting, and where I partly dealt with that contestation. It's a judgment in SA taxi securitization versus Media 24. Just a bit of anecdote. When that matter was allocated to me, I'm told that the council bemoaned the fact that why this case was allocated to an attorney, Nohale Jr., and blah, 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 all sorts of epithets. And very soon when we started the hearing, they realized, much to their sorrow, that they were dealing with somebody who was au fait in that area of the law. The judgment was taken on appeal to the SCA. The court was split. I was partially upheld and partially set aside. That debate has not been fully resolved. As a lawyer, one would say you're waiting for a proper case that could be taken further up to the CC, where you could deal with that aspect of the law and try and do a collation of other cases, Ohoshi, Dlomo, and all other cases, and distill out of that cases the role of the media, the role of publication, the falsehoods and the truthhoods of that. So we still are there.
Thank you, Chief Justice. I just in parting want to say that your judgment on the K word, which the Chief Justice quoted, was a very good contribution to our jurisprudence, and it made us to win the Brackenfell case a few months ago. Thank you very much for that. There are very few people who are prepared to confront issues such as the K word frontally, as it was done in your judgment and that of the Chief Justice. Thank you, Chief Justice.
Thank you.
Thank you, Commissioner Mpofu. Honorable Singh.
Thank you very much, Chief Justice, and good morning, Judge Matapo, and
morning.
To all the commissioners that are there. The issue, Chief Justice, of the top 6 still haunts me and bothers me. And I've heard it many times before sitting on this commission. And I think Commissioner Magwanisha is right, that we need to have a very honest discussion about this top 6. Now, Judge Matopo, you did mention that the top 6 is changing its character. So it's going to be there for some time to come, although with different players. And you did also say that some of the players will be leaving at the end of this year or thereabouts. Now, what is your view on the idea that we should have a full investigation on the existence of the top 6, its influence, whether undue or not, on the judicial system, so that South Africans can have comfort that even at that level of the judiciary, there is some level of collegiality and that jurisprudence is the winner. You did also mention the influence of the media. Now, I would not think that all media houses will not want to take up the matter of digging deeper into the existence and the influence of the top 6. There certainly would be media houses that would want to give different views and report differently to the public. What would your view be on this issue? Thank you.
Commissioner Singh, if there is a person better suited to talk about the top 6, it's me. I would do that not purely to protect, nor to unduly expose it. Perhaps to put matters in their proper perspective. What would normally happen at the SCA, which would lead to this unnecessary and unpleasant incidences, is that one would refer it or label it as judicial intolerance. I have, together with some of the colleagues, confronted the issue, and then we have succeeded in exorcising that ghost. But I cannot say to you that entirely it's gone. People's personalities are there. It happens that some colleagues would take unnecessary liberties and overexert their authority, especially on junior colleagues. To the extent that I have been aware of that, I have taken it upon myself to speak to the victim and to speak also to the colleagues concerned, to raise it with them that this behavior, it's despicable, it must stop. Whether the full-blown inquiry would help or not, I would say no, it won't. For the simple reason that we had our sensitivity or diversity meeting where we laid it upon the possible top 6 and impressed and prevail upon them that this particular type of conduct should not be countenanced and should stop. And I've kept tabs at the SCA or with the SCA, and I've been reliably informed that this has not happened. The meeting that we have was in 2019, and I have been away because I've been at the Constitutional Court for almost 2 years acting. So, but Justice Pesa will confirm it that things have now taken shape for the better. And I don't think we still have those wounds, but that we must revisit and scratch the wounds. But there would be. I cannot say that the incidences are gone and there would not be any isolated incidents. There will be. It's natural. There will be, Commissioner Singh. And I would not, I don't want to sit here and vouch and say it will never happen. You may be told that when the SCA is interviewed that it has happened. And I don't want to be seen to be a person that lied to the commission. I make that disclaimer. Thank you.
No, thank you, Judge Matopa. I think it's helpful to know that you are willing to stick your neck out and cooperate in any kind of inquiry that may come about with regard to the top 6. My second question, Chief Justice, to you, Honorable Judge, is yesterday we spent a lot of time on dissenting judgments. And I think since you've been acting at the Constitutional Court, you are aware of dissenting judgments or minority judgments. What is your view on minority judgments right at the level of the Constitutional Court? And I'm saying this having due regard to your independence, to your thinking, to you not allowing anybody to trample on your toes, etc., which you said right at the beginning. Thank you.
I think it must be emphasized why and when do we have dissenting judgments. A colleague may not see the issues the same way as you see them. And at the Constitutional Court, what normally happens is, after the hearing, the scribe would send out what is called a post-hearing note. That is, in other words, how you see the case. And colleagues would comment on your post-hearing note. And some would agree or some would not agree. And when they don't agree, you can't be engaging them also on the post-hearing notes. Then that's where you have to sit back and write your judgment in such a way that you persuade them, or that is, you write forcefully to persuade those who did not see the issues the same as you see them. And if you are able to convince them, they will come over and concur in your judgment. But if colleagues still, and notwithstanding that, see and approach the issues differently, I think it is their right. We cannot muffle or muzzle the colleagues from expressing what they think the case should be decided, or how the case should be decided. Nothing wrong with dissenting judgments. It happens everywhere. Well, there is a famous saying that your dissent today may be law tomorrow. So, and you would want to know, why is it necessary that a colleague at the level of the Constitutional Court would write a dissenting? The answer is simply, why not? But what happens is, there is what we call the do-nathering. Try and come together and see how far are we far apart, and what can we do to come together, and if need be, speak with one voice. You would have those meetings, you would have those do-natherings. And if still colleagues see the issues differently, there is absolutely nothing you can do. But there is serious engagement preceding delivery of the judgment. So that is how and why you sometimes see what you'd call dissenting judgments.
Thank you, Judge. Thank you, Chief Justice.
Thank you, Honorable Singh. Professor Schlemmer.
Thank you, Chief Justice. Good morning, Justice.
Morning, Prof.
It's nice to see you again.
Thank you.
I wondered whether you would recall our interactions the previous time.
I do.
Quite a number of years ago. The case of Pfeiffer versus Van Wyk, I do indeed prescribe to my students, not only because it clarified a particular principle of law, but also because we don't really agree with some of the other things that you said in the judgment, but that is what academic discourse is all about. What I would like to hear from you is, you referred also to reasoned judgment and the importance of that. The scholarliness of judgments, what is your take on that? To what extent, especially in an uncodified system that we have, what role does scholarly judgments play?
I think all judgments are scholarly. Otherwise, if I were to give a judgment that is not scholarly, I would not deliver it. And when you write your judgment, the immediate audience is the litigants before you. But you don't have to write it thinking about the litigants only, because your judgment may have an influence on other sectors of society and community. So then it is important that your judgments, to use your words, be as scholarly. I would perhaps put it this way: be as best as possible, and then you have to make sure that all the issues are properly narrated, properly researched. Remember, like you have made reference in the judgment that I have delivered, it is probably prescribed, not for the reason that I thought it is, maybe for the reason that to say, look at the judgment, it is not as scholarly written as it should be. And then the do's and don'ts. So one has to be careful. And when you write the judgment, to say it can be used somewhere, it can be used at another instance. I wrote a judgment while I was at the High Court in Johannesburg. And my son was studying law at UJ. And then he came with an assignment, and the assignment was based on the judgment that I had written. So it is important that whatever you write, you must be mindful of the fact that it could land elsewhere where it could be used. So it is important. I agree with you that the judgment should be scholarly.
Thank you, sir. Thank you, CJ.
Thank you, Prof. Honorable Dodovu.
Thank you very much, CJ. Good morning, Justice.
Morning.
I want to forego my opportunity to ask you questions because of two reasons. One is that I'm largely covered by the colleagues, but secondly is because of the interest of time. It's because of that. But just my point, I fervently appreciate what I hear this morning, and I'm learning a lot. And just moving forward, I think that just listening to you and looking at you, I appreciate your demeanor and your voice. But that is just between the two of us. Thanks.
Thank you.
Commissioner Tsepe.
Good morning, CJ, and thank you. Good morning, Judge.
Morning, Commissioner.
Judge, first I would like to commend you for the work that you're doing in training young lawyers in judicial skills, especially women lawyers. It is an important task for the transformation of the judiciary. And I think we should commend you for that work. What I wanted to ask you, the first question is, in this task, are you roping in other judges so that they can take over from you later, and mainly women judges in this role? That's my first question.
Thank you, Commissioner Tsepe. I did mention that I had a whole team of women facilitators or trainers. And now recently, when I coordinated a course for women lawyers, women judges, we had about 6 to 7 women who were presenting, and the men were just 3 or 4. Yes, I am mindful of the fact that at some point or the other, I have to pass the baton. The baton that that was passed on to me, it was passed by Justice Majid, He said he has run his race and gave me the baton, and those were big shoes to fill, and I had to make sure that I don't fail him. Thank you.
Thank you. The second question I wanted to ask you relates to when the CJ gave you bragging rights. You spoke extensively about your exposure as a judge in a diverse area of law, including commercial law, tax law, customs and excise. I wanted to find out from you, do you think the Commission should view your expertise or exposure in this area as a distinct advantage in considering your application to the Constitutional Court?
I think it is, and I have to make that concession. I think it is, and I have been privileged in the sense that I have been given the opportunity. Remember, in life, there's one thing that we need. We just need an opportunity. I've been given the opportunity to write extensively about everything. And I've sought out work on the bench that I be allocated to write on virtually and almost everything. I've written on contracts, everything. My experience it's diverse. And if you were to ask me to describe myself, I would say I'm a versatile lawyer.
Thank you, CJ.
Thank you, Commissioner Tsepe. Deputy President Pitse.
Thank you very much, Chief Justice. Good morning to you, Justice Ramaka Stephen Matopo.
Morning, DP.
I've noticed that almost every commissioner who spoke before me prefaced their question with an observation. So I'm not going to step out of that tradition. I'll do likewise. And the observation that I want to make relates to, should I call it the much maligned top six? You know, I'm looking at the list of judges of the SCA for the third term, and I see that when you return to the SCA after your long leave, you'll be at the doorstep of the top six territory. Perhaps you might want to, to comment on that if you wish to, and whether you are looking forward to being admitted into that league. Then going into serious business, I'm not going to dwell on your virtues as a judge. I think your record speaks for itself. But I want to deal with you on an entirely different topic. In fact, I want to take you up on the theme alluded to in paragraph 18 it is of the questionnaire. You don't have need to go there. I'll read out for you. It reads, open quote, mindful of the need to create a judiciary that is more representative of the people of South Africa along both race and gender lines, close quote. And if I look at section 174(2) of the Constitution, it provides that the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. And I've made a note of the permanent justices of the Constitutional Court at this present time. And what is clear is that there's currently no white justice in that court, be it male or female. There is currently no black justice of Indian extraction, white, male or female. And my question to you, do you think that the JSC would be advancing the dictates of and or demonstrating its fidelity to the constitutional command in section 174(2) if it were to recommend you for appointment at the Constitutional Court, given the candidates that we have at our disposal, offering the JSC an ideal opportunity to give effect to section 174(2) that the commission is enjoined to do. Thank you.
Well, if I start with your top six, I think we have belabored that point. And yes, you are the DP, you would know whether I stand at the door of the top six. But I think one myth must be demystified. The issue about the top six, even the top six themselves, never referred or described themselves as top six. I think in all fairness to them, that point has to be made very clear. It is through no fault of their own that they happen to find themselves in the top six. And it would happen to me as well, that I would, through no fault of my own, find myself in the top six. I think the issue, whether there is top six or not, for it to be resolved, it requires the leadership of that court no longer to be categorizing judges in terms of their seniority to a point where you have number one, number six, number what. At the Constitutional Court, when I acted there for the better part of my almost 2 years, I never got a distinct feeling that there were some judges who were more senior than the others. That artificial distinction has long been buried or was never there. So, and I think the leadership at the court should take it upon themselves to ensure that we no longer have it. And once you can put that to rest, we will not have this. I would not even say I would be a top six candidate in a year or two. So I think we need to do that. Coming to matters of substance. When I read section 174(2), my understanding and the text of it does not make it obligatory that you should consider all other racial groups. The answer is simple. If you take the history of this court, the Constitutional Court, it took about 25 years, maybe 25 years, let me put it that way, before we could have, okay, let me put it this way, before I get there. I think it would be remiss of us to look at the appointments in terms of skin pigmentation. And when you look for a fit and proper person, you're not looking at the color of the skin. We say South Africa belongs to all who live in it, black and white. We should look at judges not in terms of color, but in terms of what they can bring to the court. Now, the reality is, I think for the last coming 25 or 20 to 25 years, we've never heard in that court, if we were to play color, judges of colored descent. And at no stage was it ever raised that because of that, Section 174(2) was violated, because this body was not looking at color. Thank you.
Thank you, Justice Matobo. But just a follow-up on your suggestion that it might be advisable to, to do away with this issue of seniority. I'm aware, as everyone knows, that the Constitutional Court sits and bank. So at any given moment, there's just one court running. But with the SCA, that is not so. When we are in Bloemfontein, there are 3 courts running at the same time. And when hearings were conducted virtually, sometimes there were 4 or 5 courts running at the same time. And the seniority in reality determines who take charge of which court. And how, in your view, if you were to do away with that, would we manage that type of situation at a practical level?
Thank you, DP. I think you would recall, and I would have to mention it for the purpose and for the benefit of the commissioners, that I lost the debate twice. In other words, if I didn't get the support of the other colleagues. And the reason, this is my view, and this was my view then. I advanced an argument that says the DP and the president must be the ones that allocate work, scribing duties. I raised that argument, I lost it. I raised it again, I lost it. And the reason why I was advancing that argument is, you saw the presiders, because there was a perception that the presiders would say, I've allocated a judgment to Matopo. And it seems as if it is his judgment. It's the court's judgment. It is our judgment. And the presider would want to have ownership of that judgment. It cannot be. That pains me up to this day. Because at the Constitutional Court and at the High Court, you don't have those ownership of judgments. Why do we have it? A senior colleague would say, are you writing for me this term? It cannot be. It's not right. So, but if all what the role of the presider should be, just to go into court, marshal the proceeding, and that's it. And ensure that the judgment is sent and collated and coordinated, that is delivered promptly. That's about it. I lost that debate, and I'm, as you can see, I'm passionate about it.
Thank you. Maybe finally, as a follow-up, I don't want to belabor the point at this forum, but I'm extending an invitation to you at our general meeting upon your return to raise this once more and possible give everyone an opportunity to explore how practicable would that be? Thank you.
Thank you, thank you. I've done it before, and it came at some point. It came very close to winning it, and something changed. I'll do it.
Was it not because I was against you on that aspect?
It's also a possibility.
Thank you, Judge Matopo. Thank you very much, Chief Justice.
Thank you, Deputy President. Commissioner Matolo Depu.
Thank you, CJ, and thank you. Good morning, Judge Matopo.
Morning, Commissioner.
I know that people, all my fellow commissioners have been speaking about the transformation of the judiciary. And one of whilst they're talking, I'm just thinking, as you know, that the Legal Practice Act, the original intention was to try and fuse the profession, the attorney's profession and the advocate's profession. Unfortunately, we couldn't. We had to settle for the middle ground. But I must say, I'm really proud of you as an attorney, having come this far. And I must actually assure you that you are a shining armor amongst the attorneys. But what I want to find out from you is that how do you see the performance of attorneys in court and the performance of advocates? Because there seems to be this fighting for turf and this seniority and the other one is better than the other, and the perception that goes out there, as if we didn't go to the same universities and the same courses. And secondly, for me, we seem to have a problem that our advocates don't want to embrace the transformation agenda of the LPC. They still want to hold. I'm not talking about the converted on my right, So they still don't want to embrace that transformation. So my fear is, the more you go up, some of you who are really committed to transformation, we may have the missing middle. And how do you fast track that? We do away with the differentiation between the attorneys and advocates.
Thank you, Commissioner Lebu. Yes. Just a bit of background. When the attorneys were granted the right of audience in the High Court, there was a lot of resistance. And this is the resistance that you are now facing or encountering with the advent of the Legal Practice Act. The other members of our profession do not really want to embrace us. And the irony is, they get briefed by attorneys, but they don't think the attorneys can be their equals. So that's where it escapes me. The attorneys grovels and go and get work and brief them. But when it comes to the right forum, they want to be slightly ahead or above the attorneys. That cannot be right. And you would see that in court. What I would do in court, as in the motion court or in the civil trial, there would be attorneys and as well as advocates. And I would say, before I call, there would be this thing that the matters would call pair seniority. And the advocates would want to precede or call their matters first. I would say, no. Sigogo has been an attorney for so many years. And then Sigogo, go in first. Because the same way that I accord Madonsela or Mpofu the respect, I must accord it to Mr. Sigogo for his long experience as an attorney. So that's what must happen. That is what I inculcated at the Johannesburg High Court, to say I'm not going to beat about the bush. They have their rightful place in the legal profession. whether advocates wants to embrace us or not, I know we lost the battle in the Legal Practice Act. That is why the idea or the purpose or the reasoning or the thinking behind the Legal Practice Act was to fuse the two professions. But they have dug their heels. They don't want. So this is the problem that we have. But us on the bench, we must make sure that those artificial distinctions are not allowed to perpetuate.
Just a follow-up, Judge Matopo, do you think we can still move for the fusion of the profession?
I see nothing wrong with it. I see nothing wrong.
Thank you, CJ.
Thank you, Commissioner Matolo. Advocate Kane.
CJ, if you can indulge me after Advocate K or the last, just I have a follow-up to the judge, but even after Advocate K.
Is that you, Commissioner Nogesi?
Yes, Chief Justice.
Thank you, sir. Thank you so much. You'll come after Judge President Lambo.
Thank you, Chief Justice.
Okay, sir. Over to you, Advocate Kane.
Thank you, Chief Justice. Good morning, Justice Matopo.
Morning.
Call. We met for the first time in 2010. At that stage, you were already an established soul on the Gauteng High Court bench, and we did an appeal together when I acted on that bench. What I remember so clearly, and what accords with so many of the answers you've given today, is how you did teach others. And what I learned from you was a very measured, considered, and systematic manner of approaching legal life. You really taught me to look at it as a marathon. In those days, I was a lot more frantic than I am now, so it was a lesson I needed to learn, and I thank you for that.
Thank you.
For the same reasons that have been given by Commissioner Dodovu, I'm happy to say that I am covered, and so in the interest of time, I'll pass over to Chief Justice. But thank you.
Thank you, Advocate Kane. Thank you. Judge President Lambo.
Thank you, Chief Justice. Judge Mpof, sorry. Justice Matopo.
Yes.
I would like you to deal with two issues. One is the appetite of the top six of old to stomaching a dissent from a junior judge, especially one who is acting. I don't want you to tell a story. You can just give an example of a case and leave it there. Because just in the interest of time, that's one. And maybe to help you, I have a number of cases in mind, but one of them is a baboon shooting case, right? But I don't want to tell a story. So that deals with the appetite of the top six then of stomaching a dissenting judgment by a junior member of that bench. That's one. But perhaps the other one, because I just wanted to deal with both. The other one is the elephant in the room about the language that's used by SCA justices when they criticize judgments of High Court judges. And that extends beyond the top six, by the way. So I just want to read for less than a minute. I'll read you a comment, which is before us here, against one candidate, where the SCA was reversing that judge's judgment on review. And this is what it says, what the comment of the scribe of that judgment is. It says, why she did so, or whether she merely overlooked these other grounds, is known only unto her. Further on down the line, the same judge says, her failure to deal with certain of these grounds of review remains a mystery. I'll leave it there. Thank you, Chief Justice.
Thank you, JP. Judge Matopo.
Thank you, Chief Justice. Can I just start with the language? Because no, let me start with the top six and the reluctance to deal with dissent judgments. Yes, JP Mlambo, it was quite evident in the Baboon case that what happened to the judge who saw issues differently was wrong. The conduct of the top members of the top six was wrong. What happened in that case, as you would recall, I'll reveal the identity of the scribe once I've made my point.
Please don't reveal the identities.
Okay. Well, they can always find it. State versus Crossley. So what happened in that case is, after the junior judge had written, there was a repost. And the purpose of the repost was to show up that the junior judge lacked a fundamental understanding of how to analyze a simple and tried principle of criminal law, how to evaluate the evidence. And when I read the judgment and I spoke to the judge concerned, and yeah, it was wrong, and that's what should not happen. And up to this day, and I think it's something that should just not be allowed to continue or to happen at all. And when you read that Baboon case, it has its own history and how the case got to be at the SCA at that time. And yeah, maybe I should not say more and stop there. The language, JP, one has to ask oneself the simple question: how would you feel if somebody were to say that your judgment lacks thinking or whatever? I know, to respond to that one, I know of a colleague whose reasoning, a senior colleague, was said to be bewildering. Kaspedia Magacha. And I know of a colleague in Joburg as well, who it was alleged that Justice or Judge X did not apply his mind. And that offended the colleague tremendously, to say, but if a judgment says I did not apply my mind, what does that mean? So it is important to know that when we write the judgments, they are not, as I indicated earlier, they are not for the judge concerned. Posterity will come and harshly deal with us for having written so freely and so wrongly about colleagues. Anything that you describe, like for example, the language that is used here to say it's a mystery. I mean, you could use better and different and more respectable language.
Follow-up question, the small one, CJ, if you permit me.
Yes, JP. Yes, JP.
In your own experience, Acting Justice Matopo, have you ever found such language in any of the judgments of the Constitutional Court?
Now what? No. I mean, no. No, I've acted for just about, CJ is about 18 months, close to 2 years there. No. And colleagues will tell you that's not the language that we use. Thank you.
Commissioner Nogesi.
Thank you, Chief Justice. Judge Matop, I'm just interested in two questions out of the debate with the deputy judge. Doesn't really matter if in the Constitutional Court all judges there were to be black judges. Would it really matter if in the proper interpretation of 174(2) is that first, I mean, before that, all the judges that come here or candidate were competent, good candidate, appropriately qualified, were black judges. Would it matter if we appoint all of them? Or the president, sorry, we recommend, sorry.
I would not think so.
Finally on this, your interpretation of 1742 doesn't compel this body to start to say, oh no, let's calculate. In the Concord today now, out of 11, we have 2, we have 3, we have 4. I mean, this composition doesn't really compel that, or it simply emphasizes the fact that when you are doing appointment, you must take into account those factors in the process. I just want to.
It is correct. You cannot be starting to playing the numbers game.
Lastly, then, I mean, this is unrelated to this one. It's a follow up on the language used in judgments broadly. Did you, in the matter of the public protector, the language used by the Constitutional Court there, egregiously acting outstandingly, I mean, language that was used, the words that are used by the judges in description of what they believe is the actions of the public protector and institution of government. Would you say the language, judges must be careful when they deal with other judges on their language, or it is a matter that when you write a judgment, you must be careful of the language when you describe other public officials, even if it's a minister or is a government, whatever. The question of language is what one should be careful about.
I think I agree with you. If I'll answer that by way of an example of a case. If you would remember, there was, I think I'll give you the judgment. It's NDPP versus Zuma. There's a judgment by Nicholson in Durban. The language that was used there to say he red-carded the players, the officials, and everything else, it was not a language befitting a description of a judge. So one has to guard against at all times the language that you use in reference to your fellow colleagues. They are your colleagues whether you like it or not, or other members of the departments or wherever.
Thank you, Chief Justice.
Thank you, Commissioner Nokesi. Judge Matopo, now to ask you questions, because I was really just leading you, beginning with the language. At the Judges National Conference of 2009, the judgment you've just referred to and the language generally employed by the SCA with reference to the judgments of the High Court judges and courts of equivalent status was debated. Do you remember?
Very well, CJ.
Judge Lohodi was quite vocal about it, and it resulted in a formulation of a provision in the Code of Judicial Conduct to the effect that appellate courts must be very careful about the language they use with reference to their colleagues in other courts. You remember that?
I do, CJ. I was there. I remember.
Okay, yes. Now, turning to something else, who distribute work to judges at the SCA?
CJ, this is the debate.
And what is the criteria?
CJ, let me explain this. This is the debate that I lost. And it's very passionate and close to my heart. What normally happens, as I understand it, the head of the court would prepare a roll and prepare various panels. And what would happen if matter number one, the senior judge is DP Petse and 4 others. Senior Judge Petse would have the discretion to decide who should scribe in that matter. And it cascades downwards. And after Petse, let me put it this way. The president would allocate work to herself and allocate scribing duties. And after the president, the DP, and it goes and it cascades downwards. So the presiders are the one who decides who should write what on what not to write.
Okay. Well, on a different matter altogether, and this will be my last question, or maybe the second last. You don't have to mention the name of the person, but you would recall an incident when the law researchers that I had interviewed, one after another became unavailable, and I approached you, asking you to identify one of the current law researchers whose family is struggling thoroughly financially, so that his or her contract of employment could be extended to enable him or her to support his family in view of the challenging economic circumstances. You helped me identify that law researcher, but in keeping with the commitment to help others, just explain to me how you had been interacting with that law researcher who turned out to have been one of your own law researchers.
Thank you, CJ. As soon as I arrived at the CC, and actually this is what I do in all the courts that I've been, I make it my business to inquire on the socio-economic status of the people that I work with and the people that I interact with. You may not know this, CJ. This is what I do as a way of satisfying myself that the clerks at the Constitutional Court are well looked after, well catered for. I would sit with them, not only my clerks, even clerks from other chambers, to understand where they come from, to understand the challenges that they have gone through. Because, CJ, if somebody like me, who is not able to assist them, they look up to me as a beacon of hope or that shining light that can help them navigate through. So it is through that process that comes obviously naturally that I was able, when I sat with the clerk and understood that clerk's plight. And it really pained me when I understood his condition. And CJ, I quickly identified that that particular clerk had not finished his attorney's examination, and then said, every afternoon when we don't have a matter, I will sit down with you, we will prepare, because he was going to write, we will prepare the examinations. So that's what I did. And that's how I knew that the clerk's condition was dire, And I'm happy to say that I was happy when you inquired, and it became a natural thing for me to say this clerk whose contract was going to expire would have been in deep trouble in terms of looking after himself and his family. So remember, umuntu umuntu ngabantu. I had to help.
And how had you been helping him? And how did you tell me you had intended to help him? Had he not, had his contract not been extended?
It worried me, CJ, because he didn't know where he was going, and I had to eavesdrop or whisper to you to say, CJ, there is this position. If you could find it in your heart, in your space, in chambers where you could accommodate this person, and for which you agreed because your two clerks have decided not to take up the appointments.
Yeah. And you indicated that you had been helping him financially and you are prepared to continue to do so. Am I mistaken?
Thank you, certainly, CJ.
Yes. Thank you, Judge Matopo. You are excused.
Thank you, CJ. Thank you, Commissioner.
CJ, I'm an octogenarian. Is it possible to get a 5-minute leg stretch?
Colleagues, is it 5 or 10 that you want?
10.
10. Oh, thank you. Let's break for 10 minutes.
Thank you, CJ.
Thank you, JP.
As young people, what must
Or
we
should it perhaps be a tea break, colleagues? Can we make it 15 so you can have a cup of tea? Or is 10 fine? All right, it will be 10. It's okay. you, colleagues. I apologize, and I apologize to you, Justice Mulemela, that you had to wait for me. Are you well, Justice Mulemela?
You just switched it off.
Press the mic, please, Justice.
Sorry about that.
No, but I'm unmuted.
You, Chief Justice.
Is there a problem that end?
Yes, I'm the one that pressed the mute button.
Oh, I see.
Yes.
Okay, all right. Are you well, Justice?
Yes, I'm well, Chief Justice, under the circumstances. And how are you?
I'm very well, thank you. I don't see your face. I want to tell whether you are still a bit nervous, I must help you along, or whether you are comfortable, you're ready for all questions. I don't know why they are hiding. Yes, there you are. Okay, now I know what to do. I know what to do. Now, you've traveled quite some journey as an attorney. Just give us a bit of details about that attorney's firm by women that you were running.
Thanks, Chief Justice. I think the firm was established in 1996, if I'm not mistaken. And it was your typical firm that handles everything. We used to call firms like that general dealers, because you had to handle all aspects of the law. And so we covered all areas of the law, including conveyancing. And maybe what I need to do now is just to pause and mention that before establishing that firm, I opened my own practice as a sole practitioner. And it was quite a bold step, because I intended doing conveyancing as well, even though I was not a conveyancer. At that stage, I had only started attending conveyancing courses. I wrote the conveyancing exam and passed it. And at that stage, I had already established that firm. So months later, in fact, our paths crossed, meaning the path of Justice Kubushi and my path crossed at the conveyancing course, and we immediately clicked, and soon thereafter we established a practice, and as they say, the rest is history. So it was a fairly successful practice. I know that we were featured in one of the magazines. That magazine is no longer in existence now, forgotten the name of it. And I think a year or two later, Justice Kubushi was appointed as a state attorney, so she left the practice, and I carried on my own. And the practice was a success. We were on several panels of several banks, ESCOM, SASOL, and so forth. So it was a fairly successful practice, but it became too successful and too difficult to manage for one person. And so at some point I decided, okay, I wanted to specialize in labor law, and I thought the quickest way of handling that would be to maybe focus on labor-related matters, and that's how I ended up at the CCMA. But the years spent at that firm were very, very special. People often said they did not know how to refer to the firm because it was a female firm. Because usually when you addressed a letter to a firm of attorneys, and invariably the partners would be male, it would be addressed as messieurs, so and so.
And so people were saying, but we don't know what to say in relation to you. Is it messieurs? What should we say? And they resorted to mesdames. Yeah, so that was the era. It came and it went. And I went on to do other things, Chief Justice.
Well, just to clear the coast, you made reference to getting some work from ESCOM. I take it that there is nothing to give us reason to believe that you might have to present yourself before the Zondo Commission.
Not at all, DCJ, not at all.
All right. The High Court. How did it prepare you for the SCA? How would you say your judge presidency also equipped you for the SCA? How would you say a combination of those two experiences and your experience at the SCA prepared you for the Constitutional Court? How would you say your act instinct at the Constitutional Court, together with all this, gave you confidence that you're ready for the position you're now applying for? Just as I've said to all other candidates, and we will be saying to others, it's time now to brag. Even if you are humble, you would be doing yourself a lot of harm if you were to try and play the humility card. Just brag.
Okay, thanks, Chief Justice. Maybe let me just reverse a little and return to the point where I said that at our firm we were a general dealer. Even the firm that I served at before, Pete Jake Moloi, was a general dealer. And that was very, very helpful because it exposed one to different aspects of the law. And so early in 2005, a position became vacant at the Free State High Court. And an organization approached me and asked me to make myself available. And at that stage, I declined. I said, I will not make myself available when I have not acted. I know that to act is actually you have to be invited. So there's no guarantee that I'll be invited, but I do not want to make myself available for that position when I have not been exposed to what it is like to actually be in that position. Because with acting, you find there are people that come and act, and after acting, they decide, no, thank you, this is not for me. There's too much pressure, or it's too isolating, or whatever the case may be. People advance different reasons for not accepting appointment. So at that point, I declined and said, I think I want to act first and make a decision at that point whether I'm going to be appointed or not. And later the same year, in September, so I did not make myself available for that vacancy, and it was filled. And later in the same year, the Judge President of that time, Justice Judge President Malherbe contacted me and informed me that somebody had recommended me and invited me to go and act. I went there and acted for a month. And on the last day of my acting stint, the Judge President and a senior judge from that court invited, there were two of us that were acting at that stage, so they invited us for lunch. And during that luncheon, the senior colleague asked me whether I was going to make myself available should a position become vacant. So I said to him, I don't think so. I think the workload is too much. I think I first need to adapt. And so he said, well, I don't think it's a bad thing because I too was invited to act here. I acted, and immediately after my acting stint, they actually wanted to appoint me, but that was before the JSC days. So they wanted to appoint me. That was him now saying this to me, but I declined because I too felt that I was not ready, despite the fact that I had been practicing as an advocate for quite some time. And so I left, and soon thereafter, the judge president invited me again to go and act. And I went there, I acted for a term, and at the end of the acting stint, the same colleague asked me, well, I'm asking the same question again. Are you going to make yourself available if a position becomes available? I said, I'm not sure. I still think that there's a lot of work here at the High Court. I still think that I need to adjust and things like that. And he said to me, look, I can tell you now that I think you are ready. It gets better with time. I've been a judge now. He had been, at that stage, he had been a judge for more than 15 years or 20 years thereabout. And he said, I've been a judge for this long, and I can assure you that it gets better with time. So I am encouraging you to make yourself available should a position arise, because I think that you are now ready. And a position became available. I again did not apply, but in the meantime, I was working hard. Now working at the pace of a judge, trying to work at the pace of a judge to equip myself just in case I became interested in the position. I've always been a hard worker, Chief Justice. And having been a female in practice in a very male-dominated environment, there were a lot of doubts. Sometimes clients would come at my erstwhile firm, they would come, and in the main, the firm handled criminal matters, and I would overhear some of the clients saying, I don't want to be represented by a female. So that actually encouraged me to work harder. So the more I felt that people doubted me, the harder I worked, and I think it paid off. So in 2007, there was an advertisement that I saw where they were inviting ladies to go and participate in a course. I think it was pioneered by the former Minister of Justice, Bridget Mabandla, where they were trying to empower women with the necessary skills to make them judges. Just before I applied for the position, I was again invited to the Free State High Court to go and act there, and I accepted the invitation. But I felt that I would gain a lot from attending that course, because it was a course that was dedicated to equipping females with the recognition that most females had not been exposed to certain aspects of the law, like, commercial law and so forth, primarily because of the stereotypes that people had about women. And so I attended that course, and it helped me immensely. I could not attend the last part of the course. I think it was the last 2 weeks of the course, if I'm not mistaken, because then I went and I accepted an acting appointment in the High Court. And when I was there now on the third acting stint, I actually realized that it was much, much easier. And I thought to myself, the 2 previous acting stints have assisted me, and now this course also has prepared me for the bench. And I think I am now at a stage where I can say, if approached, I will make myself available. So I attended the course, acted in the Free State, and was invited to act in Gauteng. And thereafter, there was a position that was advertised in the Free State, and I decided to apply, and I was appointed. I'm just trying to say, Chief Justice, I was biding my time, and in the meantime, I was preparing. I was equipping myself. I was reading. I was studying, spending long hours reading and preparing myself. And studying and reading has become second nature to me, which is why I have never really struggled at any of the courts, be it the High Court, be it the Labor Court, Labor Appeal Court, Competition Appeal Court, and so forth. I have a high work ethic, which I developed over the years, and I find that it helps a great deal. Nothing beats preparation. And so I have spoken and mentioned how attending that course immensely helped me in shaping me to what I am today. I'd like to point out that I have attended several other courses under the auspices of SAJE, the Judicial Education Institute. And I found that these courses too were they were very, very helpful. They are courses that are intended to equip judges who have not been yet exposed to certain areas of the law, for example, maritime law, intellectual property rights and so forth, intellectual property law and so on. But they are also refresher courses to those judges that are already experienced, but who need to refresh. And somebody might ask, why would an experienced judge need to refresh? I will make an example, and this is the example that I'm making, that there was an era in this country when we were under the apartheid rule, when none of us knew anything. We knew that there was a concept or notion of a Bill of Rights, but it was non-existent in this country. Fundamental rights were being trampled left, right, and center with the blessing of the law and also with the blessing of the courts, unfortunately. I know there's a judgment. It's a 1934 judgment of the court at which I'm serving. At that time, it was referred to as the Appellate Division. I think it's Sachs versus the state, if I'm not mistaken, where the judge actually in his judgment openly stated that if the legislature has laid down a statute that encroaches on the liberties and freedoms, then that law had to be respected. It's quite shocking, but we do understand that that was in 1934. And so it went, and we know the history of the country. And we know that the same court in the 80s made a pronouncement in terms of which the former justice of the Constitutional Court, Justice Albie Sachs, and other political prisoners were denied the right to have access to newspapers and so forth, purely on the basis that they were regarded as political prisoners. And the judge had the audacity to actually say that, but the whole purpose of detention, that kind of detention, is to extract information. So indeed, inmates of that nature should not have access to information in the form of newspapers, magazines, pens and paper to write and things like that. That too is a shocking judgment if you consider where we are now in terms of our human rights. I mean, an outright violation of human rights, receiving a blessing in the form of a judgment of the appellate division. So, where I'm going with this is that it is quite clear then that there was no culture of human rights at that stage. And then we had the Constitution, so which is something new. Clearly, there had to be a huge paradigm shift or a change in mindset in terms of the thinking, moving from an era where there was parliamentary sovereignty to an era of constitutional supremacy, and we are now in a constitutional democracy. So courses were offered on constitutional litigation to legal practitioners, and I know I'm one of those that attended those courses back then. I think that was in 1995 or 1996. But obviously, the existing judges or judges that were, were already serving as judges, they also had to, let me refer to it as decolonizing the mind. They also had to decolonize their mind to have that paradigm shift to now start thinking along the lines of the values of the Constitution, the fundamental human rights that are entrenched in the Constitution. And so they too had to attend courses. So that was something new to them as well. They were already experienced. They had been on the bench for a long time, but they too had to attend courses. And I speak with, with no fear of contradiction when I say that I know that we have all embraced, the judges have embraced the values that are enshrined in the Constitution. And so all the courses that have been offered by Sajay, intellectual property, maritime, tax law, and so forth, have been very, very helpful, not only to me, but to other judges as well. And how do I know this? I know this because I've been serving as a judge of appeal since 2012, meaning I could sit and review the judgments of my colleagues. And I have seen that more and more and more colleagues, let me just say there's a huge improvement in the quality of the judgments. And it has often pained me to hear people talking about someone not having been exposed to commercial law just because at the time when you were an attorney, maybe your area was or focus was criminal law or something else. The courses have been very, very helpful to all the colleagues, including myself. And so I'm at a stage where I consider myself well-versed with all areas of the law that I can comfortably say to you here today that I know that I will be equal to the task at the Constitutional Court. I am lucky enough to also have acted at that court. And so I know what is waiting for me there. I have demonstrated, after acting in that court, I acted there in 2015 and went back to my division. And maybe here I will interrupt myself, Chief Justice, just to say, you will recall that during my interview for the position of President, I mentioned the advantages that can be derived from acting. And I said that an acting appointment is not beneficial only to the candidate who's acting, in the sense that it empowers that particular candidate, it gives that particular candidate personal growth. But it is also beneficial for the entire legal profession in the following sense, that if you are acting as a judge in the High Court and you are a magistrate, when you go back to the magistrate's court after your acting stint, I can guarantee you will not be the same person. There's a famous quote by Justice, I think it was Justice Wendell Holmes, who said that a mind, once it has been stretched to a new idea, it will never go back to its original dimension. And I can attest to that. I've seen it. And, you know, even in respect of people that are coming from the bar, they come there, they act, they go back, and they come and give feedback and say, this has been an enriching experience. And it's not only enriching to the individual, but to the entire bar, because then members, say in the magistracy, all the magistrates feel confident to go to this colleague who has acted in the High Court to say, I have this problem, legal problem, how can I deal with it? At the bar, the colleagues go and consult that colleague who has acted to say, how can I deal with this? And then I mentioned as well that acting in another court is also beneficial to the court, to the particular court. And I think having acted at the Constitutional Court benefited my court, because I went back, I imparted the knowledge that I had acquired from the Constitutional Court, and you know, continued to operate as if I was still at the Constitutional Court. That is why, Chief Justice, when you peruse the judgment of Tswaedi versus S, you will see that it is quite a detailed judgment. You said I can brag. I think I can mention that when I read that judgment, it gives me great pride. And I think I have demonstrated in that judgment that even though I was at the High Court, I was still operating at the level of the Constitutional Court. I have comfort in saying this because a number of passages from my judgment have been cited with approval in the Constitutional Court judgment of S versus Mlungwana. So not only is it a confirmation that I came to the right conclusion, but it also says that the reasoning was also solid. And in the judgment, you would have noted that I referred to various authorities, including foreign judgments. So, Chief Justice, my whole history, the journey that I have traveled even before becoming a judge, just from that day when I was nominated, then somebody approached me in 2005, before I even acted, to say, we think you should make yourself available. There was a huge paradigm shift, and I started operating at a high level. And I read a lot. I'm talking now about just literature that has nothing to do with the law. At the beginning of every year, I read 1 or 2 books just to sharpen the saw or to make my skills even better. And there's a book that I read, The 4 Agreements by Miguel Reitz. And Miguel Reitz in that book says, if you want to have a happy life, there are 4 things that you need to do. And he says, the first agreement is to be impeccable with your word. And the second agreement is not to take things personally. The third agreement is not to make assumptions. And the 4th agreement is always do your best. I think those 4 agreements have helped me a great deal in becoming what I am today. And I have applied it, you know, it has become my Bible. And it gave me great pleasure when I read the comments from different professional bodies where they described me as someone with integrity, somebody who works hard. And I said, okay, there you have it. I already tick 2 boxes in that book. I think, CJ, this is where I would like to leave it.
All right. Now, just apart from Swahili, can you just share with us a case or a few cases, either from the High Court, the SCA, or Constitutional Court, that demonstrate your ability to contribute meaningfully in the development of the jurisprudence at the highest court in the land? Just some examples, if they come to mind. I know an interview is a very strange thing. You get interviewed, something doesn't happen. As soon as you walk out of the door, you remember something quite potent that you should have shared. Just in case there are additional cases that you would want to hold out as demonstrative of your capability to function and function effectively in the apex court and help shape our jurisprudence in the right direction.
Yes, I'll mention the case of Murudi versus Northern Cape Housing. It's a case where I wrote a dissenting judgment. It was a panel of 5, and I was flying solo. So I wrote a dissenting judgment, and okay, let me just step back a little bit and say, when it comes to rescission of judgment, a judgment can be rescinded on various grounds. And one of the grounds is that if it can be rescinded if it is a judgment that was erroneously granted. And the whole debate was whether that particular judgment had been erroneously granted. And I found in my judgment that to the extent that the litigant in that matter, the litigants in that matter were present in court, but were not given a hearing, the judgment was erroneously granted because they were present, but they were denied a hearing. Audio alteram partem was not observed. That judgment was overturned by the majority judgment was overturned by the Constitutional Court, and the Constitutional Court in its judgment stated that I was correct in my interpretation. And so that judgment has made a contribution in relation to that particular aspect relating to rescission of judgment. It has just clarified that a judgment is erroneously granted even if a party is present in court. So I would say that's the development of jurisprudence that has happened. I would also mention the judgment that I wrote. I think it's provincial government versus Oudtshoorn municipality. Chief Justice, at first blush, when you read it, you might think this is just an ordinary run-of-the-mill, straightforward judgment confirming an order of constitutional invalidity. But when you read the judgment, you will then see that I deal with the aspect of separation of powers. I refer in that judgment to cool ideas and to, I think it's the National Coalition judgment. And even where both parties, and both parties were organs of state, even where both parties were agreed that the particular provision was unconstitutional, and were agreed that there should be reading in other words, that we found that the particular section of that legislation, the Municipal Structures Act, was deficient. And there was a suggestion that, okay, to make it comply with the Constitution, you could add this part. And both parties were agreed that we should do reading in and add the particular part that says to the extent that it is not inconsistent with the Constitution. The court still went to town dealing with the aspect of separation of powers. We did not just rubber stamp the decision to say both parties are agreed that we can do reading in And so we are going to do that. There were a number of considerations, and in the end, we agreed, we declared that particular provision unconstitutional, and we also made an order stating that there should be reading in to make it compliant with the Constitution. There are a number of judgments. I can't, recall them from the top of my head, Chief Justice. There's also the judgment of Harvey, which concerned the rights of the adopted children. It related to a will, a testament will that was drawn in 1953, in which the testator had said that he was leaving his property to all his children in equal shares. And the debate was whether his children also included the adopted children. And I took the view that it included the adopted children, even though the adopted children were not in existence at that time. And there was a similar matter from our court, but now relating to whether a will can survive constitutional scrutiny if it has a clause that says that the beneficiaries shall only be females. So my judgment was quoted in the appellant's heads of argument in that particular hearing. And I noted that in the judgment itself, there's a part that refers to what I stated in Harvey. So although it was not, Harvey, the judgment of the Constitutional Court in De Jager was not in relation to my judgment, but it was on a similar matter. And in the De Jager judgment, the Constitutional Court held that my reasoning was correct. Not in so many words, but there was a reference to a particular passage in my judgment which was quoted with approval. So I think that's the contribution that I have made. As I said, Chief Justice, there are a number of them, but those that are the ones that I can immediately recall. I have said in...
Thank you very much.
Okay.
Yes, carry on.
All right.
Please continue.
I have participated in a number of appeals. I mentioned that from 2012, I became a judge of the Labour Appeal Court and the Competition Appeal Court. I was on the panel of several judgments, and there are several judgments that ended up at the Constitutional Court, confirming the judgments, even though it was not my own personal judgment, but confirming the judgments in which I was a panelist. So now being a panelist, it means that you are part of the decision, you were part of the debate, you made a contribution in relation to the conclusion. And so at the Supreme Court of Appeal, I've participated in many appeals, more than 100 already. I have written a few dissenting judgments that received approval from the Constitutional Court. I have managed to, both at the Labour Appeal Court and at the Supreme Court of Appeal, sway a decision where the prima facie view was to find in favor of a particular party, but because of my contribution, we ended up, coming to a different conclusion. So that's the contribution that I have made. My contribution, in other words, is not confined to only to the judgments that I have penned, but to the judgments where I was a panel member. I made a contribution to the final product that came out.
Yes. Thank you, Justice. Colleagues, would you please indicate if you want to put questions to Justice Mulemela?
Nyambi.
Lucas.
Sigogo.
Matonsela.
Lamola.
Schlemer.
Not yes.
Tepe.
Singh.
Deputy President Petse.
JP Mlambo.
Honorable Nyambi.
Thank you. Morning, Judge Mulemela.
Good afternoon, Commissioner.
As somebody that was leading a division in the Free State, and you happen to get the opportunity and be appointed to the SCA, we have learned for a number of years about the issue of the top 6. You left Free State as a leader. Then you went to the SCA, and you are a woman judge, and you have been leading in the Free State division. Will you share with us some of the stereotypes we have had to deal with as a woman judge, and how we have managed to remain focused and still be competent, given the challenge of being a woman judge and getting to an environment where you have the top 6?
Thanks, Commissioner. Chief Justice, I think in my previous interview, this very aspect was alluded to, and I mentioned the problems that we had encountered. I think I did mention in that interview, if I didn't mention it, I am mentioning it now, that for me, the atmosphere in that court was a culture shock, because I came from a very, what you can describe as a very collegial court, where the colleagues made a genuine effort to foster collegiality. And I'll make an example. When I started acting at the Free State Division of the High Court, when the Judge President was orientating me, he said to me, look, try by all means to make attendance at the tea room as much as possible. We do understand that you will not always manage to do this, because sometimes you are in a hearing and you are of the view that it would be a disruption to adjourn the proceedings just to make an attendance in the tea room. However, on the first day of the term and on the last day of the term, tea room is compulsory. And so that has always been the practice in that division. First day and last day of the term, we gather in the tea room. We literally shake hands with one another, make small talk, regarding how the recess was, what were you doing in the recess and things like that. And if it's the last day of the term, just a chit chat, where are you going, when are you leaving, and things like that. And I think things like those, Chief Justice, are very, very important in fostering collegiality. And we also, had this practice of having at least once a term, we have lunch with all the colleagues. You bring your own lunch box and we all sit together and, around the table, and we chit chat. And I remember at one stage I was at the Competition Appeal Court, and our cases are normally heard at the seat of the Western Cape Division of the High Court. And it was the last day of the term. And so I was telling a colleague that I was happy to be going back to Bloemfontein because I had some traveling to do. because we have an outing as judges for the weekend. And this colleague was actually shocked to say, "You have an outing as judges?" And I said, "Yes." And we actually went away for a weekend. All the judges of most of the judges of that division. We went to a small town, some maybe 100 kilometers from Bloemfontein, and we all had fun there. And it's nice, you know, to interact and to talk about other things other than our work. And I would say collegiality is very, very important. And I think I did mention at the last interview that, you know, when you are being collegial to your colleague, it's not as if you are doing this colleague a favor. It's actually set out in so many words in our code of conduct that we must avoid personality issues and foster collegiality. And so I came from a court where I will not take the credit for myself and say I'm the one that introduced it. When I got there was collegiality already. You know, one of the unwritten rules in the tea room was that we all chat together as a group. So we would sit like in the form of a circle, and the conversation would be for everybody. So you'd have to speak loudly so that everybody can hear you and we all participate in the same conversation. So you'd not just be talking to the person right next to you. And I think it went a long way to fostering collegiality. That was the environment that I came from and went to that judge, and things were not the same. I think in the past interviews, it has already been mentioned what the problems were in that court. But we had a diversity training subsequent to that interview. And I think that diversity training helped a great deal. We had a frank talk, all of us had a discussion with a facilitator present. And I remember, and everybody was brutally frank. And I remember at some stage, the facilitator said she was giving us an hour or so to have a one-on-one with any colleague that you seemed not to be getting along with. And I used that opportunity to go to the other colleague that I had, you know, referred to in my previous interview. I went to him and said to him, "Listen, I think there's a problem. Let's get to the bottom of it." And we had a nice chat. And thereafter, you know, he just looked at me and he didn't say anything. And I was about to leave and saying to myself, well, this is not even working. And as I was about to leave, he actually reached out to me and hugged me, and we hugged. And ever since then, you know, the relationship has been very, very cordial. He refers to me as my hoops, you know, from that tension to where we are now. Strides have been made. So even though we had problems in the past, Chief Justice, we had the diversity training. We had a meeting pursuant to that diversity training where we discussed things, and we actually agreed amongst ourselves as judges that everybody has permission. If a colleague has offended you, then you have all the right to privately go and confront that colleague. So I think that has worked. You know, there's an understanding that we have to get along because we work together as a team. And speaking for myself, since then, I have not had any difficulty with any other colleague. And in my nature of, you know, trying to be welcoming to colleagues that are acting, I have reached out to the colleagues. I know that there's a committee that specifically interacts with people that are acting there for the first time to orientate them. But I reached out especially to my sisters, the female acting colleagues, and said to them, know that when you are on the panel, your view is as good as the view of any other panelist. There's no more seniority now. You are entitled to ask a question anytime you want to ask a question. You are entitled to be treated with respect. And if for whatever reason you are of the view that a colleague has not treated you with respect, you have all the right to discuss it with that particular colleague. So I think the diversity training has been successful, Chief Justice, and the frank discussions that we have had in our meetings. So I'm not complaining about lack of collegiality at the SCA. I think we have gone. I think we have gone past that now. And you know, after that diversity training, the lady was very, very helpful because, you know, she was talking about many aspects, and including unconscious bias. And in that very venue, one of the colleagues actually mentioned openly to say, yes, I think I acknowledge I have been privileged because of my race. So people were just open with one another. And it gave me an opportunity to reflect. And I remember we once had a difficult moment and we had a meeting. And on my way to court on that particular day, a song was playing on the radio, and it happened to be a song by Coldplay. And in the lyrics, something just stood out to me. And this is something that I mentioned at our meeting, to say, as colleagues, we must introspect. You know, we must have a serious conversation with ourselves and introspect and ask yourself this question. And those are the lyrics from that song. Am I part of the cure or am I part of the disease? And, you know, if you apply that, there's bound to be improvement. And I think the measures that have been taken up until now have assisted a great deal. I must also give credit to my sister, the leader of that court, Justice President Maya, because she created the space, safe space within which to exhale and to acknowledge that there are problems and for us to resolve those problems.
Thank you. My last question, I see that you are pursuing an LLD despite your busy schedule. How important is it for you to further your studies, and how do you see this impacting on your work, especially the office of which you aspire, the CC?
Yes, thanks, Commissioner. I had to put that on hold because I was due to take the remaining part of my special leave, which we normally refer to as long leave. And I had planned to do all the preparation for the thesis and everything during long leave. However, I was requested not to take long leave at that particular time due to some operational reasons at the court. And so I had to postpone it. And it's only now that I've taken leave. And so that is something that I'll be focusing on during my private time. It's very, very hectic. The workload it's hectic at that court. You really don't find a lot of time to do other things than work. As it is, I work 7 days a week to cope with the workload and so forth. So I have to actually find extra time to devote to studies and things like that. But I find that most of my life, in fact, most of the qualifications that I have are qualifications that I got while studying part-time. So I think I have found a way of multitasking, and to ensure that it does not interfere with my responsibilities at the court. So one day I will do it, but at the moment I had to put it. I actually had to put it on hold, and will only be focusing on it now. I'll see how far I go.
Thank you, Judge Molemela. Thank you, CJ.
Thank you, Honorable Nyambi. Honorable Lucas.
Thank you very much, CJ. Good afternoon, Justice.
Good afternoon.
Molemela.
Good afternoon, Commissioner.
Part of my question have been covered by the question that was asked by Honorable Nyambi. But there is just two issues that I want to raise with you, and possibly you can respond to it. I see that at a very early stage already, you started to act as a judge, and you were one of the privileged few that got that kind of exposure. And I also noticed that you spoke of an absence of a culture of human rights that was non-existing, according to what you exactly said. So one of the issues that I would want to know is what have changed exactly. Is there any positive aspects that you want to highlight? And secondly, as someone that has had that privilege that I've just mentioned, what have you done constructively and in a very structured fashion to make sure that you develop other women that find themselves in the same position that you found yourselves a few years ago? I think that is the remainder of the question that I wanted to ask to you. Thank you very much.
Yes, thank you, Commissioner. What has changed is we now have a constitution. We have a constitution that is the supreme law of the country, and it permeates through all the branches of the law. So the judgments that I referred to of the Supreme Court of Appeal are old judgments. The one is 1934, the other is, I think it was in the 80s, the one in relation to Justice Sachs. So that was before the advent of the Constitution. And all organs, all branches of the state are obliged to promote and uphold the Constitution. So it's not a question of whether one wants to recognize the Constitution or the fundamental rights that are entrenched in the Constitution or not. Nobody can wish it away. It's there, and everybody has to comply with it. And that is what has changed the jurisprudence in this country. And in relation to a structured approach of helping other women, this is something that I have been doing for quite some time, even before I became a judge president. But when I was a judge president then, what I decided to do was to allocate every acting judge, not only females, every acting judge, I would call them to my chambers and have a discussion with them, orientate them, and tell them that they should choose one colleague amongst the colleagues at that court, whom they can trust, for purposes of mentoring. They should approach that colleague, because mentoring is a two-way street. You have to trust the person who's mentoring you, to know that there's confidentiality, to know that when you open up to this person that I think in this particular area of the law, I'm not well versed. This person will not go around talking about you and will instead try and help you. So there has to be trust, mutual trust. Hence, I said, choose anybody that you trust. And if that person has not accepted to be your mentor, come and tell me so that we can make a plan and find you somebody else. Invariably, it has worked. And at the end of the term, I then interact with both parties to ask how it went. And it has worked very, very well. When acting for the very first time as a judge is a daunting task. And so you need somebody to hold your hand. You need somebody who will be sympathetic. In fact, not only when you are acting as a judge for the very first time, when you are acting in a new environment. So that would also include the Supreme Court of Appeal and the Constitutional Court. When you are acting for the first time, I mean, it's a completely new environment. It's a higher court. It's got its own ways of doing things that you are not familiar with, and so on and so on. So those are all the considerations. And mentoring and coaching goes a long way in empowering this particular person to be able to perform their tasks. Because if you are not happy at work, if you don't have inner peace at work, it actually affects your performance. So sometimes people are described as being not up to the task or not up to scratch, only to find that people are just overwhelmed by the new environment. And And if you don't have a mentor, you'll be lost at sea. Everyone needs a mentor. So I do that. And I encourage mentoring, other colleagues to actually volunteer. So you don't just wait until somebody comes to you and says, can you help me? So in the High Court, actually, on that first day, when you are introduced, you are actually also informed that the other colleagues give you the assurance that if you need any kind of help, you can go to any one of them. It will be up to you really as to whether you are going to go and seek help, because you can't impose yourself on someone. Someone must come to you and seek help. I have sought help from colleagues at the High Court. I sought help from colleagues at the Supreme Court of Appeal and at the Constitutional Court, and I received help. And the colleagues that I approached were very open with me and told me that, what I'm doing now, helping you, I'm more than willing to do it because I also received help from other colleagues. And one colleague, but maybe I shouldn't mention names, because once you mention somebody, it may offend the other to say, well, I also helped her, but she did not acknowledge me. Let me just leave it there to say, I have received help and I have reciprocated.
Just in following up, CJ. So I think the candidate that was here before you and even yourself, you are confirming that they definitely, in fact, that was the words of the former candidate to say that women generally need to get more attention in being developed within the judiciary. So I'm sure in terms of what you are saying, you agree that there is definitely that need. So you agree with me that you will have to sit down possibly and develop in a structured fashion an introduction or a program that will assist you to make sure that there is a development of particularly female and black female for that matter, in the general sense, to be mentored and to be guided and to be developed. I think we agree on that one.
Absolutely.
How would you want your colleagues to remember you, particularly in the light of your seniority, for your contribution to their own development? How would you want them to remember you?
As somebody who had empathy, who was always willing to assist despite the hectic schedule of our court, not only in relation to matters of work, in other words, our workload, but also in relation to personal matters as well. Just creating a platform where people feel being approachable, basically.
Thank you, CJ. Thank you, Justice.
Thank you, Honorable Lucas. Commissioner Sigogo.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
I had two questions for you, but you dealt with the first one in respect of your judgment, the Marudi judgment. I wanted to talk to you about that judgment, particularly as to the courage that we had to be alone when four other people were not seeing the same way you did, and you were then ultimately confirmed by the Constitutional Court, but you have dealt with that part. And when I read your judgments, I see consistency in terms of reasoning. Then I would like you to share with the Commission as well as the public at large your judicial philosophy. What is it?
Judicial philosophy has to do with how you interpret the law, your approach in how you interpret the law. And historically, people would say, I'm liberal, and then somebody would be described as conservative and so forth. But we are now in a constitutional democracy. and the constitution is the supreme law of the country. And I don't think it's up to individual judges to decide, this is my philosophy. You just have to comply with the provisions of the Constitution, section 39 in particular, in relation to the promotion of the values that underpin the values, the dignity, all the values, human dignity, freedom, and so forth, to respect all those values and to recognize that the Constitution is binding, it's imperative, and so there has to be, let me call it, for lack of a better word that I can think of now, predictability. We should know that when the circumstances are like this, the outcome will probably be like this. So we use the Constitution as our guiding principle. Judges and courts are the guardians of the Constitution. So I would not stand here and say I'm liberal, my philosophy is that I should be liberal or like this. What I must do is I must just go according to what the Constitution instructs me to do. And you will note that in the preamble, it sets it out very clearly what everybody wanted in the first place. And what everybody wanted was, to heal in the main, to heal the divisions of the past and to establish a society that respects fundamental rights, that is based on social justice and the values that are in the Constitution. And that's basically what I do. I think in most of the judgments, you will see that there's always a reference to the Constitution, simply because it permeates all areas of the law. It does not matter that it's a matter that relates to contract, that relates to personal injury or whatever. The Constitution is the overriding principle.
Thank you, Judge. Thank you, CJ.
Thank you, sir. Commissioner Madonsela.
Thank you, Chief Justice. Good afternoon, Justice Molamela.
Good afternoon, Commissioner.
When I survey the path that you have taken in your judicial career, seems to me, and please correct me if I'm wrong, seems to me that you have been a judge in the Free State Division, you headed that court, and that was not long period of time to head that court. You moved to the SCA, and you have been at the SCA now for 3 years. Now you want to move to, you're applying to go to the Constitutional Court. It worries me that as I look at the work of the Judicial Service Commission over the years, there's been a struggle to get women as strong as you to assist the JSC in its task to turn around the judiciary as a whole in the country, in various parts. And you took your part in Free State. And I would imagine that in the SCA president would have relied on people like you to make a change in the demographics and even the strength of that court. We're coming with people like you. Now we are 3 years there, now you want to move. And are you not going to move to The Hague when we take you to the Constitutional Court? Soon after we appoint you, I'm worried about your quick movements without allowing us to work around you and rely on you to shape up the judiciary the way that we want. We seem to be having you moving along too quickly. What do you say about that? What's the point of this?
Thank you, Commissioner. I think I can call it a perception. It's a perception that you and maybe a few people have, but I think what people do not realize when they read my CV and and see the different positions that I have occupied and the courts I've worked at and so forth, people tend to think, oh, okay, she was appointed at the High Court in 2008. And then, then it means that in 2012, she left the High Court and went to the Labour Appeal Court. And then she left the Labour Appeal Court and went to the Competition Appeal Court and left that court to become Judge President. What people do not realize is that actually I spent 10 years in one court, and that can hardly be called a quick movement. I was I was appointed permanently in that court in 2008 and moved to the SCA in 2018, 10 years. And most people don't realize that because they think that I've been moving from this court to the other. What happens is that you hold that position while you are still based in your division. So if there's a competition appeal court matter that I have to participate in, I would go to Cape Town to go and deal with that matter and come back and participate in the role. And you are not even given time off, while you are reading those voluminous records of the Competition Appeal Court, you are not given time off at the High Court. You still
No, can I agree with you? 10 years at the Free State was good. Can you focus on the SCA?
All right.
3 years?
Yes. I would say 3 years is more than enough when you consider the following, that for me to be appointable to the Constitutional Court, I did not even have to go and serve at the SCA in the first place. Let me make this an example, and I'm going to mention a name, and I'm doing this with all respect and humility to say we had and it's a lady that I'm very proud of, Justice Kate O'Regan, who from being an academic went directly to the Constitutional Court. She did not become a judge at the High Court. She did not become a judge at the Supreme Court of Appeal. And that was perfectly acceptable. And she made a huge contribution. And then there was another female judge, and I know she won't have any objection to me mentioning her name, a lady that I respect, Justice Bessen Kabinde. Justice Bessen Kabinde was a judge at the Northwest Division, and then went and acted at the Supreme Court of Appeal, but never accepted appointment at the Supreme Court of Appeal, and instead accepted appointment at the Constitutional Court. And of course, we have one of our luminaries, Justice Krichler, who was at the SCA for only 2 years before he was elevated to the Constitutional Court. So
I won't say about Justice Krichler, say more about Justice Krichler at the moment. Can I just, maybe I should give a chance to the others. I had a question, but I think because of time, I'd like to give others.
Thank you, Commissioner.
Honorable Minister.
Yeah, thank you very much, CJ and Judge Mulumela. My question is in relation to the background that I see that you're an attorney in practice, and you have stated here that you have run a very successful practice as a female practitioner with other female practitioners. We are confronted with the challenge that I suspect you also were confronted with when you started practice. Across the country, in particular, female attorneys are crying about access to work. As you are aware, the state attorney hardly briefs attorneys. I'm particular now about female practicing attorneys, where they go to Polokwane, Mbombela, Umtata, KZN. It's a public outcry there. How did you succeed to be even in the panel of private firms, including that one of the state, and still run a successful practice? under the circumstances that I am describing.
Yes, thank you, Minister. I was a member of the Black Lawyers Association, and just after 94, we formed a committee that was called the Empowerment Committee. And I was part of that committee. I served in the Empowerment Committee, and the role of that committee was to go to different government departments, to all the parastatals, to all the banks, to remind them that there are Black practitioners and they are also capable of doing the work, and to ask them to consider including us as Black practitioners in our panels. And I do recall that when we did that, the issue that was always being raised was, but we want a company that has a track record. For example, to us, they said, we can't give you any conveyancing work because you don't have a track record. And that was around 94, 95. And I remember the answer that we gave them was, but there's just no way we could have a track record in conveyancing matters when we were not even allowed to own land. So whose property, whose land would we be transferring? That's why there's a paucity of members in as far as conveyancing is concerned. And so I think that helped a great deal. And there are a few practices, attorneys practices that were put on panels, but sometimes, of course, you would be put on a panel but not be given work. I can mention that there were 2 banks. We were on the panels of 2 banks, and we didn't get any work from them. And eventually we went to them and demanded that they should remove us from their panels because they were just window dressing, because they were able to say on our panels, we also have this particular firm. It's a Black firm, it's a firm where the directors are females and so forth, but then we were not getting any work. So my answer to you, Minister, would be that, you know, there has to be a conscious effort to try and get work for Black practitioners. Not only the attorneys, the advocates are also struggling. I know this for a fact, because I mean, I know that at the Supreme Court of Appeal, at the Constitutional Court, we hardly saw any ladies over there. Not to say that there are no women that are like me, that are sufficiently qualified to do those cases. There are, and they have received training and they have the necessary qualification. But I think what is lacking is the will, you know, to consciously empower these people. I mean, briefing patterns and the skewed briefing patterns has been a topic. It has been something that has been lamented upon ever since I started being a judge. I think in my very first interview, there was a lamentation about that, but we don't see any serious improvement about that. I know that there was a stage when we saw practitioners in the streets, Mr. Sigogo, and you know, protesting basically, and we know that it is an issue. Am I wrong?
No, you're not wrong.
You're correct.
Yeah, I'm correct. Yes, I know.
Yeah, no, you're not wrong, Judge. I'm being deliberately specific with the female practicing attorneys and not going to the advocates, because I think that one of advocates, it has been thoroughly exhausted, particularly in this platform, on the issues of skewed briefing patterns and the difficulties that the advocates at the bar have, including the female practicing advocates. But the issue of attorneys, females in particular, has not been as exhausted as I have heard in terms of the discussion. Hence, I'm asking you particularly about the female practicing attorneys, because as you are aware, across the country as you engage with them. It's an issue that they always raise, and I think it's also exacerbated by the fact that the state attorney does not really brief attorneys, whether a female or black. It's only on correspondence work. So I'm asking you on the basis that you have ran a firm of attorneys, females, and that seems like there was some kind of measure of success. So what will be your advice to us as the state, but also to the private sector out there with regards to this issue of the briefing pattern? I know that the Legal Practice Council is currently developing a legal sector code that will put some kind of a monitoring mechanism that will check in that regard, particularly issues addressed to female practicing attorneys. What should we really do? I know that it has been engaged over years and years, and I also had the same problems, you had the same problems. But do you think that the legal sector could be the best suitable mechanisms in that it will have a mechanism of monitoring and reporting that this is how the female attorneys are being briefed across the country?
Yes, it will definitely have a positive spin-off. I have no doubt about that. The question is whether it will be implemented, because in most instances, we have beautiful things on paper that are not implemented. I mean, the whole issue of briefing patterns, undertakings have been made many, many times that support is going to be given to the Black practitioners, both advocates and females, and attorneys, Black females included. But as to whether that is actually implemented, I don't know. I doubt it very much because I don't see it happening. So all I will suggest is that there has to be an interaction, serious interaction, maybe form a committee or something where there's interaction between government and the office of the state attorney, you know, to monitor them, to actually see that whether they are implementing this and by empowering women, and contacting different state law advisors, because state law advisors are there, they give advice, and then eventually when the brief is issued, it goes to a white firm, and you know, talk strongly to them to say, this is what we want and this is what we need to see happening. Because I think
yeah, maybe on that point, Judge, what then do we do with regards to the private sector? I get that the state attorney, which we have done, the Solicitor General is already having engagement with the Legal Practice Council. What then do we do with regards to the private sector? Because the private sector, as you are aware, operate in the many parts of the country, in some of the remote rural areas where government has no real control as to who ABSA, Standard Bank, SAPI, or any private sector company. What then do we do with that aspect? At least you succeeded, but in this instance, what then do we do so that they do the same thing that ourselves as the state attorney are required to do? And we commit that we will follow up on that and report again in this platform. But with the private sector, what then do we do? That legal sector code is aimed to do that, but how do we ensure that they also implement?
The private sector, there's something that is called BEE rating, and for them to get government work and so on. For example, we made an example with a bank. For a particular bank to hold the government account, for example, you could say to them, this is what we require, 1, 2, 3, 4, 5, and then thoroughly check whether there is indeed compliance. An issue that has worried me in as far as that is concerned is that you'll find that a company has a good empowerment rating in the sense that they tick all the boxes relating the presence of females and Black people, but what is not assessed is the duration of employment of those people. So you'll find that a company appoints somebody for a year, but this person is not treated well and soon leaves the firm, and this person is replaced by another black person. After 6 months, this person leaves immediately thereafter somebody. So I think that when it comes to the scoring, the duration should also be taken into account, and the conditions, the employment conditions of those particular employees should also be taken into account. So it's all about seriously monitoring.
Thank you, CJ, and thank you, Judge.
Thank you, Minister. Professor Schlemmer.
Thank you, Chief Justice. Good afternoon, ma'am.
Good afternoon,
I am very impressed to see that you say that you read a lot and that you study a lot and that you have qualified yourself so far. How important do you think is it that a judge writes scholarly judgments, especially in the face of the fact that our legal system is not codified?
It's very important. It's actually it's part of accountability, but maybe I will qualify and say not necessarily scholarly, but a well-reasoned judgment. A judgment must have all the reasons for the decisions that are made. That is part of accountability. Let me make this example that if you were to give the correct order, but it is not accompanied by the reasoning, and the reasoning is completely wrong, then even an appellate court is not in a position to correct that reasoning because that particular reasoning is missing from the judgment. So where I'm not sure of your definition of scholarly, but my definition of an adequate judgment is a judgment that gives cogent reasons for the decision that has been arrived at. And that is what is required not only, but that is what is required by our code of conduct as well, that we must give reasons for our judgments. As to whether you in particular will consider them scholarly or not, I don't know. But it suffices if the judgment gives reasons for the finding or for the decision.
Well, I suppose when you give cogent reasons, that is based on authority.
Of course.
And that is what is a scholarly judgment.
Thank you.
Thank you.
Then all of them are scholarly.
Commissioner Nokesi.
Thank you. Thank you, CJ. Firstly, Judge Mulimela, let me appreciate the fact that you have availed yourself for the Concord. And as I understand, in all the instances, even when you became the judge president at Free State, it was not your first choice. You were called upon because of other issues that have arisen there. So I appreciate the fact that you have availed yourself. Yeah. On the top 6, there is something that is related to it. The language that is used in the judgment of the appeal court when you address the judge in the court of call. I mean, you disagree with the findings. Things like she did not feel lack appreciation of facts, strong language such as had a total misunderstanding and misdirections on the facts of the case. I mean, the language, that's very important. But I don't want us to limit only when you direct to the judgment of the court. But in instances where there is a discretionary exercise which you disagree with, like, for instance, the public protector, the strong language used by the Concord itself, resulting in some cases where there were those personal court orders which were set aside because they could not be. How do we address the issue in the judgment of the language by the judges of appeal in relation to the judgment that they disagree with, or an exercise of discretion by other organ, by other arm of government?
Thank you, Commissioner. If you have a look at Article 11 of our Judicial Code of Conduct. It talks about restraint, judicial restraint. And amongst other things, it states that there should be restraint in how we deal with not only the judges or the public protector, but with the litigants. You know, how we express ourselves about parties and issues. We must be very, very careful. So I think we must use temperate language, and we must ensure that we comply with that. I know that I think in 2012 we had a judges conference. It might have been earlier. And no, not in 2012. I think
it was 2009.
2009. Thank you, Chief Justice. Yes, we had a conference, and that's one of the aspects that came out that was discussed, and we all agreed that we must treat one another with respect, even though we disagree. It's okay to disagree. However, we must always show respect to other people. We must always be mindful of, if I think one of the provisions in the Constitution actually states that everyone has inherent dignity. So you have to treat everybody with dignity.
The other question that I would like to debate, I mean, particularly black people, you refer to some cases. The black people have been oppressed for so many years, more than 365 ever since. Now, if, for instance, out of the judges, at one day, an occasion can arise where all the judges in the CC, for instance, are all black judges. Is there anything wrong? Would that be contrary to the provisions of Section 174 in the Constitution?
Well, thanks, Commissioner.
If yes, how? I mean, if you can school me there.
I think earlier on, in one of my responses, I emphasized that we have to comply with the Constitution because we are in a constitutional democracy. So if you consider the provisions of Section 174(2), it says when appointing judges, you must make sure that...
So you consider.
Yes.
It doesn't say you must. You are not obliged. Take into account. It means you must take into account.
That's right.
Yes.
You must take that into account. And so as long as that has been taken into account, that will suffice.
Lastly, Chief Justice, I'm sorry. The last point I would like to check on is we have traveled a long way since 94. If one interprets the provisions under Section 174, particular subsection 2 that you referred to, or that we refer to, is it not safe to interpret that as to say that was in response to the status quo in 1994, where blacks completely were not either judges, were not even qualified, were not even entitled to? That was in response to say, let us address this aspect. Is it not time has come that the Constitution itself in this regards have to be amended to reflect current realities in terms of the tenure of judges, in terms of composition and also further?
Yes, thank you, Commissioner. In my answer, I will refer you to the separation of powers to say it is the legislature that enacts laws. And my duty as a judge is only to interpret the laws and to apply them. So I have no comment as to whether the Constitution should be amended or not.
Thank you, Chief Justice. Otherwise, wish you all the best in these interviews.
Thank you, Commissioner Nogesi. Commissioner Tsepe.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Very happy to see you. Judge, I just wanted to talk to you briefly. You spoke about the obligations in Section 39(2). And you spoke about your appointment, particularly in the Labour Appeal Court and the Competition Appeal Court. I wanted to ask you, what has been your experience in those specialist courts when dealing with the subject matters in those courts, but also in commercial matters on the observance by judges to the obligations in Section 39(2) when interpreting legislation or developing the common law or the customary law, to take into account the object and spirit and purport of the Constitution? What has been your experience in those courts?
I think by and large, as I mentioned earlier on, the constitutional values have been embraced. We know as judges that they are binding on us, and by and large, there has been compliance. There have been a few judgments of the Constitutional Court where other courts, including our court, was criticized for not properly interpreting a particular constitutional provision. However, what must be borne in mind here is that, there is scope for error. There is no judge that is infallible. We are all fallible, but we try our best under the circumstances. And sometimes we do get the law wrong, or rarely the facts wrong, but that has, no bearing on the probity of a judge.
Thank you, Chief Justice.
Thank you very much, Commissioner Tsepe. Honorable Singh.
Thank you very much, Chief Justice, and it's good to see you again, Justice Molamela, even if it's on this virtual platform. I remember very fondly our interview in April of 2018, where I think Commissioner Malema expressed some dissatisfaction with the CJ when the CJ said you were making a sacrifice when you applied for the position to the SCA from being the judge president. And I think we dealt with that matter at that time. But what I'd like to ask you, Justice Molamela, is in hindsight, do you think that not being the JP at that time and moving to the SCA, where you've done excellent work, has been what you have always wanted? And do you think that your contribution as a Constitutional Court judge, if appointed, will be one that should be worthy of our consideration? Given that you've only acted for 5 months in the Constitutional Court, but one would think, and I would like you to say whether or not the experience you've had in the SCA will hold you in good stead if you are appointed as a Constitutional Court judge. Thank you.
Thank you. Maybe I should start right where you left off, right at the end, to say, yes, definitely my experience at the SCA will stand me in good stead. But not only the experience at the SCA, the experience acquired also from the Labour Appeal Court, the Competition Appeal Court. And yes, and I mentioned earlier, maybe I'll just mention it again, that I think I am ready. I have broad experience. I'm an all-rounder. And I think I will be equal to the task of being a justice of the Constitutional Court. In relation to your concern about having been at the SCA for only 3 years, let me just allay your fears or your concerns by reiterating what I mentioned earlier on, to say that I did not even have to go and accept appointment at the SCA first. I could have made myself available as a judge president, for example. I could have made myself available at the Constitutional Court, and there would have been nothing wrong with it. And maybe I'll just add that I was, just reading to see what's happening in other jurisdictions. And I noted that in the United Kingdom, for a judge to go and serve in the apex court in that country, you only need to have done 2 years at the former court, meaning that my move from the SCA to the Constitutional Court, I would have had to be at the Supreme Court of Appeal for only 2 years. So by all accounts, it seems that I can be considered to be ready to take that appointment.
No, thank you, Judge. No, certainly it's not a concern of mine that you hadn't served long enough in the Constitutional Court. In fact, I think you've had excellent grounding at the Supreme Court of Appeal, because the principles of law would somewhat apply similarly at both levels of the court. I'd just like to ask you a question. I don't know if it was humility or omission in your questionnaire where you did not put in the fact that you were Judge President in the Free State. I would take it as an omission. Because when I looked at that and I said, but I remember Justice Molamela, and certainly she was JP. It's on page, one of the pages. I'm looking at the page now of the questionnaire that you filled in. But let's take it as an omission. You spoke earlier about dissenting judgments, and you have written dissenting judgments. What I'd like to know is, at the level of the Constitutional Court, what is your view on writing dissenting judgments or minority judgments? And how would you apply yourself if you do not agree with the majority on a principle or a matter of law? Thank you.
Thank you. You know, before a judgment goes out, it's preceded by very robust discussions and debates amongst the panel members, both at the Supreme Court of Appeal and at the Constitutional Court. And so when a judge eventually writes a dissenting judgment, it's after careful consideration and, you know, being of the view that there is this particular view which needs to be aired, in the sense that be put out there in public. Dissenting judgments in most instances do not talk to the present, they talk to the future. Because if the legislature decides that there's a particular statute that needs to be amended, a statute that needs to be amended, it will take the judgments into consideration, both the majority judgment and the minority judgment. So there is a place, definitely, for a minority judgment, even at the level of the apex court. So, and, you know, I considered a number of judgments of the Supreme Court of Appeal, because I believe that, you know, you must always benchmark and consider what happens in other jurisdictions. And I've seen a number of their judgments where there are dissenting judgments, many of them. And so there's absolutely nothing wrong with that. It's just a view that is held by a particular judge, that the judge feels strongly about, that the judge feels that it should be aired. And as you could see, sometimes the minority view ends up carrying the day, as it has happened in the case of Murudi, although that had to happen after the intervention of the Constitutional Court. So there is definitely a place for dissension, and it is in fact encouraged, not only a dissension, but the writing of separate concurring judgments as well, because the next court, it is to the advantage of the next court to have as many views on the aspect as possible.
Thank you. I know you don't have the Constitution in front of you there, but 174.1 was referred to 174.2, Chief Justice, and it says this: the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. I just wanted to read that section of the Constitution to you and for Commissioner Nochesi. Thank you, Chief Justice.
Yes.
Thank you, Honorable King.
May I respond to that?
Deputy President Petzl. Oh, you need to respond? Okay.
Yes, I wanted to respond.
If you want to, Justice, please go ahead.
Yes, I want to respond by saying that unfortunately at the moment, that constitutional imperative of Section 174 has not yet been achieved. Even in my first interview, there was a lamentation about the fact that the judiciary there's no gender parity on the judiciary. And that was in 2008. It is now 2021, and that is still the case. There is not enough representation of females in the judiciary, meaning that that section that you have just alluded to, Commissioner, has not been complied with. It's a serious concern because we know the reason why things are as they are. Speaker after speaker after speaker on the lack of representativity will tell you that at the bottom of that is patriarchal practices. I mean, there was a stage when in 1912, a female judge, a female attorney, aspirant attorney by the name of Wookie was not allowed to practice as an attorney because apparently she did not fall within the definition of person as defined in the statute that regulated the admission of attorneys. So the reason is not hard to find why there are few women in the legal profession. And if we accept that patriarchy is at the bottom of that, then we need to deal with it. Patriarchy has been dealt with in a number of stages. For example, there was a stage when a woman had to get consent from her husband for everything that she needed to do because of marital power. It was abolished in 1984. In the case of Bay, the former DCJ, Moseneke DCJ, lamented patriarchy and its effects and mentioned that it is what lies at the bottom of the perception that women are subservient to men. And in that case, that custom was done away with of primogeniture. Now, my question really, and this is something that is troubling me, is why do we address it when it comes to certain things, but when it comes to others, we don't? Why don't we see an equal representation of women and men on the bench? For a number of years, it was stated that women were not sufficiently qualified. Women have been trained. There are now many women that are sufficiently qualified. And then it was stated that women are not making themselves available. But we have seen that even when competent women have made themselves available, sometimes they do not get the nod. So what are we doing? When we abolished marital power and when we criticized primogeniture, we inter alia stated that it creates a bad impression about women, that they are not equal to men, trampling on Section 9 of the Constitution, which deals with equality. Now, how can we allow it to be the order of the day when it comes to our courts, the very guardians of the Constitution? I looked at the statistics and I've seen that in the continent, not too far away from here, in Zambia, the representation of female judges there is 52%, which is in line with our demographics. And I've asked myself, why have we not achieved that? And I read a statement that was made by the Chief Justice in that country, who said they did this because, amongst other things, they were complying with the protocol on, I think it's called the Protocol on Gender and Development. And South Africa is a signatory to that protocol. It was signed in 2008, and it was amended in 2016 to bring it in line with the Sustainable Development Goal 5. So that's how they achieved that. Now, the same protocol is binding on us, on South Africa. How come we are not complying with that as well? should we keep comparing ourselves to the countries that are performing badly? And yes, I know that there are some first world countries where the representation is not what it should be. In fact, when I looked at the statistics of Canada, I saw that female representation on the bench is about 35% thereabout. And when I had a look at their family courts, the representation of women is about 65%. So in my view, that is just, perpetuating the stereotypes that we have about women. And it pains me to be part of an institution where you are sitting there and the court is not representative. We are in a country where several households are led by women and they are doing a wonderful job. What goes wrong now when it comes to putting those women in positions of authority, like being a judge? Especially when actually there's an obligation to comply. And in 1994, the former president of this country, our beloved Madiba, made a speech. And the speech that he made was at the opening of Parliament. And amongst the things that he mentioned there, 1994, 27 years ago, was that women must be empowered and they must be represented in all positions. I'm just paraphrasing what he said. So actually what we are now finding in the protocol is something that was articulated very well by Nelson Mandela in 1994. We are still not there yet. It's painful to sit there and envy other countries. I attended the International Association of Women Judges Conference in Argentina 2 years ago. And there were women from many countries all over the world. And we could just, envy a lot of them who were saying that we have achieved representation. I think France was one of those that said their representation is already at 70%. And perhaps one can say, no, but those countries are first world countries and so forth and so forth. But I want to go back to Zambia and say, here is Zambia, they have done it. Why can't we do it? Thank you, Chief Justice.
Thank you.
Chief Justice.
Thank you.
Chief Justice.
Deputy President Benson.
Chief Justice Julius.
Yes, sir. Yes, sir, Honorable Malema, is that follow-up?
No, I was just saying it's 2:10.
Yeah, no, I didn't know what to do, quite frankly. For the first time, I didn't know what to do. Can we just deal with the remaining ones, or are you proposing that we take a break and bring her back? I thought maybe we must dispose of Justice Molemela. We have 3 people, including me, put questions, and then I will implore her to be brief where she can, and then we go for lunch.
No, I agree with you, CJ. I was just saying if you can plead with her, just to take into consideration that it's 2:10.
Yes, Justice Molemela, in your responses, please just be as brief as possible.
Chief Justice, Schlemmer here, if I might may have a follow-up after everyone is finished, please. Or just before you
do
speak.
it now.
Thank you.
Do a follow-up now, Prof.
Thank you very much. I think I should just give a little bit more clarity. I was a little bit taken aback by the reaction of the commissioners when I said the scholarliness of a judgment include references to authority. When you say you do research and you write judgments with reference to authority, my question also pertained to the issue that the South African legal system is uncodified. Do you ever refer to discussions of case law? Do you ever refer to any other academic materials that were written on a particular subject matter? Because that adds to the authority and the well-reasonedness of a judgment. And we have seen over the years, last, I don't know how many years, we can see that there has been less depth in judgments and in the reasoning of judgments.
Well, there are many judgments that refer to published articles, and I too have referred to a number of articles in my judgments.
Thank
Thanks,
you. Thank you, Deputy President Benson.
Thank you, Chief Justice. Good afternoon, Judge Molimela.
Good afternoon, Deputy President.
By way of observation, I must place it on record that I am grateful to you for putting things in proper perspective in relation to the current working environment at the SCA, especially with reference to the remarks, if you will still recall them, that you made after the hearing I had together with you and other colleagues on the 11th of March 2020. I just thought that I should place that on record. Then my first question to you, and I would like you to comment on this. You know, when we speak of the independence of the judiciary, the focus is on institutional independence and not individual independence. And I must say that I admire your fearlessness to dissent when you're convinced that the majority is wrong and you are right. And would you care to comment, if you may, on the importance of individual independence?
Thank you, Deputy President. There are a number of elements to individual independence, and one of them is security of tenure. You know that as a judge, you should be able to be fearless in your judgments without worrying about the repercussions thereof, that you might lose your job and so forth. And there is security of tenure in as far as South Africa is concerned. So that is not my worry. And the second element of individual independence is that you must be free to make a decision without being influenced or attempts of being influenced by other people. It doesn't matter who it is, in relation to how you should find or what outcome you must give in a particular matter.
Thank you. Incidentally, I read a judgment of the AD, as it was then called, when 5 judges of that court said that their colleagues who had 10 years ago found that a judge in the KZN High Court was wrong, were in fact wrong, and the High Court judge was right.
It happens.
Then the second one, given that Commissioner Malema has impressed upon us that it is now 2:10, is more a lamentation than a question. I take it you will agree with me that the president of the SCA is doing her utmost best to reinforce the SCA. And no sooner has she done that than our colleagues are snatched by the Constitutional Court. Why do you want to leave us only after 2.5 years with the SCA?
I will skip the part where I have to repeat that I did not even have to go to the SCA in the first place, because I've mentioned that before. But I'm of the view that I've really done my part, contributed significantly, and I think it's time to move on. And in line with what I've always stated in all the interviews, you know, when a position opens up, if I am appointed to the Constitutional Court, a position is going to open up, and I can assure you that there are many, many women who will be able to fill those shoes.
So you reckon that you do well to enrich the jurisprudence of the Constitutional Court?
By enriching the jurisprudence of the Constitutional Court, I'll be enriching the jurisprudence of the whole country because of the doctrine of precedence, meaning that the judgments that I will be writing there will be binding on all the other courts. So that will still be a benefit for the other courts, including the Supreme Court of Appeal.
If you are recommended and ultimately appointed, would you be charitable to us and not come hard on us when you upset us on appeal? Thank you. Thank you, Chief Justice.
Thank you, Deputy President. Judge President Lambo.
Thank you very much, Chief Justice. Justice Mulemela, good afternoon.
Good afternoon, Judge President.
You dealt partly with the issue I want to raise is when you sit on appeal, you sit in a panel. And I would imagine you've been involved in more male-dominated panels than where females are in the majority. Am I correct?
Yes, because of the demographics, yes.
Yes, I think I'm coming to that point. But have you been able to sway the thinking of the panel in terms of the direction of the judgment in when you deliberate after hearing matters? What has been your experience? I mean, has there been condescending to you? Have you been treated equally? Have you been able to sway the thinking of the panels?
I have been treated with respect. My views have been entertained. I did mention that we have very, very robust discussions. I've never felt that I'm being undermined. Even when other people had a different view, I respected the fact that we are not a homogeneous group and we will not always agree on everything. And there's space for dissension. But yes, I have been able to sway. And I think I did that in a matter where you were the presider while I was at the Labour Appeal Court. Yes, Judge President Mlambo. You might not remember this, but that was a matter where we had a discussion and I swayed the court and we came to the outcome that I had suggested and given reasons for, and eventually it carried the day. And the panel was of the view that it was so good that it could actually be handed down, and I handed the judgment the very next day.
Thank you very much for that assurance, because I was just responding to what you were saying about the demographics and not being given opportunities and not being recognized as equal partners in this trade.
Yes.
Incidentally, that's a panel that involved 2 judge presidents and you were able to sway them.
Correct.
Well done. Thank you very much, Chief Justice.
Thank you, JP. Just 2 quick ones, Justice Mulemela. The question that Commissioner Madonsela put to you and Commissioner Singh and Commissioner Betze, I think you need to confront it so that it doesn't unduly prejudice you during the deliberations. 1, you were a judge president for 3 years, from 2015 to 2018.
Correct, CJ.
You get appointed, people get excited, There's been a paucity of women at the leadership level, and the expectation is to build around this woman leader. 3 years down the line, you leave for the Supreme Court of Appeal. Well, there's a celebration. At least the Supreme Court of Appeal is transforming. Number of women is increasing. 2 years, 11 months, and 13 days down the line, you are quitting. So confront it. We all know that you are not bound to first become judge president or to first become an SCA judge before you can go to the Constitutional Court. Why does it look like you can't stay in one place, influence that place significantly before you can move on? As Commissioner Madonsela said, why shouldn't we suspect that you'll soon be going to the Hague or whatever, either to the ICC or the ICJ? Why do you appear to be moving so soon after elevation to a particular position? Just explain it.
Well, CJ, if you recall, in relation to my appointment as the judge president, I mentioned the not only me, all the candidates mentioned the problems that we were encountering in our court. And you'll remember that there was just one problem and it related to the role. So it was not a big challenge that could not be attended to. And that's the first thing that I did when I was appointed in that court. And the division was running like a well-oiled machine. The reviews that we were getting, many times it was voted as either the top or maybe the second best performing division in terms of the statistics that were issued by the NPA. It was a well-run division. And I held the view that I had achieved my task. But consider what I did while I was there. I empowered other women. 3 women acted in the position of judge president. I gave them an opportunity to act in the position of judge president and deputy judge president. So my leaving that court did not leave a void, because immediately after my departure, 2 ladies continued acting as the deputy judge president in that division.
Yes.
And so,
if I may interrupt you, I'm sorry, if I may interrupt you.
Yes.
Now, here is the problem. You've been lamenting the underrepresentation of women at the leadership level. You left and you strongly recommended a man to replace you.
Yes.
Undoing the progress that was done there.
Yes,
That is the point.
Yes, there were many considerations, Chief Justice. There are a lot of considerations. You consider experience as well. And as I mentioned, there were 3 ladies that had acted as the deputy judge president, and 2 of those ladies have now made themselves available for appointment in the vacant post. And hence I say there was no void. But let's look at the bigger picture as well. I left and I went to the Supreme Court of Appeal, where at the Supreme Court of Appeal, there was also a problem regarding representation. Many positions have now been advertised and they will be filled next week, or in the course of this week, sorry. And I'm quite sure that the provisions of Section 174 will be taken into account in filling those positions. And now look where I'm going, and let's look at the representation in that court. So in the same way that you mentioned that there was an applause when I joined the Supreme Court of Appeal, I'm quite sure that there will be an applause if I join the Constitutional Court, because it will be a woman adding to the existing complement in that court. Yes. And as I stated, Chief Justice, this whole thing is like a chain with many links. If you pull just one link of the whole chain moves. So my leaving the High Court created a vacancy. In that vacancy of a judge, a female judge was appointed. That in itself has improved the statistics. I went to this Supreme Court of Appeal. It improved the statistics in that court. I leave that court. Women are going to be appointed to that position. In the end, when we sit down and look at all the statistics, we might find that actually the gender representation has improved a great deal if we are going to move along those lines. Replace the ones that are leaving with female candidates, because there are many female candidates out there.
Yes. All right. One last question. There is what I think is a malicious attempt to soil your name and the name of other judges. And it moves in circles. You know, it's been recycled. That's what I wanted to say.
Yeah.
After a few months, the thing is on social media, and people, the person, the people, or the thing, because we don't know whether it's a juristic person or what, running by the name of something where after a few months, the thing is cycled again, and everybody now is shouting, oh, there is corruption in the judiciary, and nothing has been done about it. What have you uncovered about the so-called Mape who keeps on making these malicious allegations of involvement in corruption against you and other judges, or bribery against you and other judges? I think it's important that you confront it on this platform.
Yes. GCJ, you know, there's a book on this. I think the title is The Smear. And yes, and we must accept. It's a reality of life that from time to time attempts will be there to have a smear campaign and to try and soil your brand. It has happened in this country. I'm not the first judge. I read the former DCJ's book, and he mentions in that book, and in actual fact, he even he has incorporated a letter that he received from the president. Let me step back a little bit to say, he states in the book that he and another judge, Judge Froneman, were accused of having been spies. And there was
yes, and Westhuizen as well.
Yes, and there were in Westhuizen, yes, and there was an investigation, and they were cleared. So quite clearly, those allegations were baseless. And then there were allegations about myself and other judges on the Free State bench. And I remember I had a discussion with Justice Musi, and Justice Musi said, you know what? Let me tell you, you'll see that if nothing is done about this, next week other names will be mentioned, and the week thereafter other names will be mentioned, and so it will go. And that's exactly what happened. If it's not a week later, 2 weeks later, there was another list that went out, included a number of colleagues, including some who have made themselves for appointment to positions at the Supreme Court of Appeal. And recently there was another list that was circulating, and it mentions more names. So what happens? If I have to give you an explanation, I don't know why people do such malicious things. In as far as this tweet is concerned, I and the other judges laid charge, and we discovered that this person is using a fake name. So the account is a fake account. And the case was reported to the Hawks. It was being investigated by the Hawks, and they were part of their mandate was to get in touch with Twitter to try and identify this person. So more than what we have done, CJ, we cannot do. There are allegations from time to time about many judges, and I hope, I mean no disrespect, to mention that you too, and you have been upfront about it, to say that you too, false allegations were made against you too. And as a matter of fact, in that very tweet that you are referring to, a false allegation is made about you too, because it is stated there that you were told about that and you did nothing. And it's
a lie.
It's a lie. It's a lie.
Thank you, Justice. Sorry we kept you very long. You are excused.
Thank you, Chief Justice and Commissioners.
Colleagues, we come back at 3:15.
Thank you, Chief Justice.
Thank you. Thank you.
Thank you.
Good afternoon, Judge Pillay.
Good afternoon, Chief Justice. I was looking for you
How
all
are you?
around.
How are you?
Sorry?
How are you?
I am fine, thank you.
All right, okay. I'll first travel slowly so that you can settle in the environment, and then we can take it from there. I noticed that you have not been indifferent to what is happening in the nation. You got interested in the efforts to help rid our country of apartheid. Tell us a bit about that.
Well, my practice started in that area of our law. In fact, in that time of our country, I started practice as an article clerk in 1979. And when I qualified, I had to help out at the firm of Paul David, who was at the time held up in the British consulate in protest against the apartheid legislation that was being mooted at the time. And then when he came out and went into trial, my partner was in hiding, Yunus Mohammed, and I joined that firm to manage the human rights and political cases that were heading to his court. Practice in that firm of Yunus Mohammed was a privilege and a great groundbreaking time for me and for the law. One of the judgments that we were co-responsible for, Curtis and Kondo, I noticed was quoted in the Barnard judgment, solidarity on behalf of Barnard, and the principle there was a right to a hearing before a person is detained. There are many other judgments that our firm generated at the time, including in the labor field, Sabia, the right to a hearing, and Lachisa Tsinoli, where we challenged the emergency regulations. Those are some of the highlights of that experience. Then President Mandela was released, and we were lucky to be in Cape Town at the time, visiting prisoners on Robben Island. Then came the drafting process, the second constitutional drafting process, where I was drawn into drafting clauses of the Constitution, particularly the election provisions. Then Minister Tito Mboweni appointed me to the Labour Relations Drafting Task Team that produced our current Labour Relations Act. And he appointed me also to the Essential Services Committee, the first that we've set up in the country. I had to set it up, establish the jurisprudence, and 5 years later, I was called to the Labour Court. And before that, I had a rich arbitration practice, private arbitration. And the thing about private arbitration is that you are called to help parties to resolve their disputes. So unlike us as judges, we're imposing people. Arbitrators are invited to help out in disputes. That's not the case in the CCMA, but private arbitration works that way. And for me, that gave me a huge amount of confidence. As a practicing attorney, I had advocates appearing before me, including senior counsel. I learned from the best in the industry at the time.
But it also helped me with drafting. The strength or the reason why I had a thriving arbitration practice and dispute resolution practice was because I delivered my arbitration awards pretty much on the turn. And the same culture continued with me in the labor court. Well, as you know, labor arbitrations have to be delivered within 14 days, but in the labor court, we were moved around a week at a time. So 1 week it's Johannesburg, the next it's Cape Town, East London, Port Elizabeth and Durban. So if you didn't want to lug your records around, then you got rid of your judgments by the end of the week. So that also helped me inculcate a practice of getting my judgments out very quickly. It's also, the good part of it is, well, my family doesn't think it's a good part, but I'm quite cranky until I get my first draft out. So after hearing every matter, the first thing I would reach out for is a dictaphone or a drafting paper and put down my formative thoughts and the direction in which I'm taking. This practice has served me well in the Constitutional Court, which I'll tell you about and how it's been modified. But then I migrated to the High Court. A very different experience, a very exciting experience also. And I looked at the DGRU's list of fields of law, and they've listed about 13. I think I've covered at least 12. Customary law passed my desk on one occasion. But what's not mentioned there is mercantile law, which I've also been exposed to. One of those judgments was quite a sizable amount involved, which I refused leave to appeal and went to the Supreme Court of Appeal, and the petition was refused. It was a case of a ship being damaged in Richards Bay. Then I come to the Supreme Court of Appeal. I was fortunate to have 2 terms there, and thanks to President Meyer for affording me that opportunity. It was another great experience, sharpened my skills in drafting, for which I am grateful to Mohammed Nafsa's metaphorical red pen. And that was, I'm also grateful that that experience preceded the one I am now seeking appointment for. Then I'm currently acting in the Constitutional Court, and I must thank the Chief Justice for this opportunity. What really excites me about the Constitutional Court is the processes there. And I think my experience is different from others because it's been entirely under lockdown. So I haven't had to waste time at airports and lugging bags and records around. So it's been very focused on the work, reading, and tending to the inbox in our emails and writing. So what excites me about the Constitutional Court is the processes. There's a particular dynamic that comes from the processes we use at the Constitutional Court. Let me give you a brief description of this. So when a matter is set down, the clerks distribute amongst themselves. So there's 8 chambers distribute 8 questions and prepare on those questions that may arise in the case. Then the scribing judge prepares a case note for a pre-hearing case note, which is circulated the day before the court hears the matter. And in that case note will be identified the issues that will or may arise in the matter itself. Then we have the hearing, and then within 7 days usually, the first post-hearing note must be produced. And that when that post-hearing note is produced by the scribing judge, it gets emailed to all the judges, and then each judge has an opportunity to comment on it. And that's the first level of the excitement, because you're looking to see how far away you are from the thinking of other judges. And to the extent that you're not on par on one or the other issue, you're thinking about how to bring about consensus around areas that you are not in agreement with, or how to avoid disagreement. And the second excitement arises when you put out your first draft. That would be after you've taken into account all the feedback you've got from the 10 other judges or whoever else is presiding, and to pull together a judgment that is persuasive, that wins everybody's vote, is another excitement. I'm still going through all these exciting phases. I can't tell you that I've put out anything yet, but it will happen soon. So this was my first term at the Constitutional Court. I am also extremely privileged, singularly privileged, to be able to serve on the Independent Electoral Commission. I am the judge commissioner there. The work has been extraordinarily rewarding. I get to see democracy from another end. I get to meet the most amazing administrators of our democracy. And one of this year has been particularly trying, testing. Well, as you know, last year was COVID, and so we had a mass phase of by-elections. But this year we are earnestly in preparation for the local government elections. We started the year with having to meet tight legislative deadlines, which we did. As you know, the Political Party Funding Act has come into operation on the 1st of April, and there are amendments to the Electoral Act, which we managed to get through. There's also the pressure on the IEC from the Constitutional Court's judgment on reforming or amending the legislation to enable individuals to participate in elections. So those timelines are pretty tight. And I'm happy to announce also that we are ready for the local government elections. That's what our CEO has been informing the public, and I'm happy to repeat that here. There are, as a result of the Constitutional Court judgment, which put the IEC on terms to attach addresses to voters. I'm also happy to say we are 94% up to date with addresses. One of the amendments that we effected to the legislation was to ensure that anyone who qualified as a voter would be allowed to vote if they were able to produce an address. We are still finalizing one or two things as far as the addresses are concerned, but the basics for the local government elections are in place. And yes, that takes me to Summarizing that I have over 40 years of experience in wide areas of law. I should just mention also that the 10 years in the labor court brought me to the coalface of socioeconomic rights. More so than the High Court did. In the High Court, it's very hard to get practitioners to practice constitutionally. Very often, judges have to point out there's a constitutional point. The judgment you have before you that the DGRU produced in the report on me, the case of Mr. Dlamini, the practitioner there is ever grateful that I raised with him the constitutional angle to what would otherwise have been a pure common law case where the person who signed the contract, Mr. Dlamini, would have been bound on the basis of the pacta sunt principle. And you simply need to flip through the Constitutional Court judgments to see that the constitutional point is raised for the first time very often at the Constitutional Court. And that's not how we want our practitioners to practice constitutionally. Academically, my highest qualification is a doctorate, which I got from the University of Pretoria last year. The topic is moving litigation from dispute resolution to problem solving and building organization. I was an extraordinary professor for about 9 years at the University of Pretoria. I'm currently such a professor at the University of Free State. I had visiting fellowships abroad at the university. In fact, I taught at the university, law school, Seattle Law School, the Open University, Oxford. I was a visiting professor there with several of their units. And at Harvard was my last sabbatical. So I've spent every sabbatical in pursuing some form of academic interest. And I owe this to my family. My parents were deprived of education. They didn't have the opportunities. And so it has been a mantra in our family that the best investment you can make is one that no one can take from you, the one that keeps on giving, and that's in education. So I continue with my public interest work as well. I gave the Victoria and Griffiths Mthenge lecture in 2013. And as we were waiting in the wings to go in to make the presentation, a friend of mine said, "Why don't you give an award like some of the other people are doing?" And there and then I decided to give an award in the name of my late partner. So this is called the Yunus Muhammad Public Interest Law Writing Award. I work with, initially I worked with the University of KwaZulu-Natal. It expanded to the University of Pretoria, and now the University of Free State and Cape Town participate in the project. After 3 years, I mentioned it to Kagiso Capital, which is the investment arm of Kagiso Trust, at a function where they were honoring my late partner in the building that they were opening off the M1 in Johannesburg. And the CEO there, Gatso Skuman, said, "We would like to partner with us." In fact, what had happened when he passed away in 2008, a number of the trust, the investment companies, and some of the other corporates, FNB, I think, or First Rand, announced that they wanted to commemorate my partner along with other trustees, Beyers Nadir and Archbishop Tutu and so on, Max Coleman, in different ways. And but it never got off the ground because we had the 2008 economic crash. And so this was the opportunity that Kagiso Capitals sees. They handled the funding, they put up the checks. I handled the academic side of things. I collaborate with the 4 universities. What is the competition about? It's about each university putting up published articles from that university. They make a selection of the best article and suggest to a panel. The panel consists of me as coordinator and the other one representative from each of the universities, and we choose the best article from that university, for which a prize of 5,000 rands is awarded, and there's different categories of publications. And then there's a national award, which we sometimes have had to get deal breakers. Malcolm Wallace helped us on one occasion. Frank Mickelman from Harvard helped us on another occasion. And so there's a national award. We have had, because of COVID, the first launch of the project was physical and in Johannesburg, and we had a number of speakers present and so on. But since COVID happened, we've had the winner of the national award presenting online to whoever tuned into the program. That's the Public Interest Law Publication Award. I have been invited and I've joined the board of Cancer, another very rewarding public service, very much under threat in terms of its financial ability to meet its demand through COVID, the inability to raise funds as it used to through the malls and so on. But we're getting there. Then, of course, Dr. G from SAJE draws me into different types of activities for SAJE and training and so on. Deputy President Petzer, one of the things that President Meyer mentioned at a previous session of the JSC was that a weak judge who takes time or has difficulty grasping the issues and therefore has difficulty articulating them in the form of a judgment, has a consequence that that panel is delayed, and the burden on the other members of the panel is increased. Now we're talking about a panel in the Supreme Court of Appeal, but in the Constitutional Court, the panel is the court. And I am very mindful that I have to meet those standards of not drawing down or delaying the other members of the court, and to make sure that my feedback and responses are prompt. In terms of the challenges facing the court and whether I'm up to it, I think there are at least 3 challenges facing courts internationally. The first, I think, comes by way of the 4th Industrial Revolution. This is the most unregulated area of our life. We have fake news pervading our environment. We have misinformation. Elections have been won and lost on the basis that reputations have been destroyed as a result of that. So the pressure on the common law to develop where legislation is lacking is huge. At the IEC, during elections, what we have is a special unit to deal with fake news, to have a system where complaints are dealt with expeditiously because you can't wait for court hearings and so on those matters. But this is a very serious threat also to democracy, particularly where there's an interference with election results. But also the fourth industrial revolution has changed the nature of our economy. We need to recognize that we're no longer a commodities-based economy, whereas our labor force, unfortunately, has been predominantly trained to work on the mines and in the fields. That kind of, the current economy is going to entrench those inequalities, those pressures on socio-economic rights and for distribution. And so the pressure is going to be on the court again on how we exercise constitutional rights in favor of the population, those parts of the population for whom the Constitution is meant to exist. The pressure on the common law will test areas of law relating to privacy, to intellectual property, to dignity, and security, and a host of other untested areas of law. We are legislatively unprepared for it, I think. Australia recently tried to legislate against Google and Facebook to cause them to pay for advertisements that run on their platforms. And as a show of power, those two corporates shut down systems. But I suppose the happy end, or it's not necessarily the end, but the result of that is that they're in dialogue and in some process trying to figure out how best to regulate the internet. So the fourth industrial revolution is a big part of, I think, the challenge for all judiciaries. The second is the pandemic. We found ourselves having to make rules in a constitutional democracy on the back foot of the pandemic. And what rules we've made have yet to work their way through the courts to see how the courts are going to respond to that. The environment is another threat. And as more people become unemployed, the pressure on the environment, which is already strained, is going to increase. So again, the pressure on the courts, how do we deal with that? So the next, the last global challenge, I think, is that of constitutional crisis and backsliding. Now, post the Cold War, the Cold War brought the romantic era of constitutionalism. Constitutions became the flavor of the times. Everybody wanted a constitution. I think there's over 65, probably more, constitutions that came to be in the last 20, 30 years. Even England got a Bill of Rights. But what we're noticing now that constitutions are under threat. And I say this not as something that I imagined, but there's a book in which some 20, 30 countries have been surveyed, including our own. And they define what a constitutional crisis is and what constitutional rot is. Constitutional crisis, they say, is a situation where keeping disagreement within ordinary bounds of political discourse becomes impossible. Political crisis, a symptom would be where public office bearers announce publicly that they are not going to be bound by the Constitution, where public office bearers and people, I suppose, in general, refuse to obey court orders even when court orders, even when one disagrees with court orders, we know that under Section 163, 5, that we have to, 163.4, we have to obey court orders, whether we like them or not. Thankfully, our judiciary and our Independent Electoral Commission is a bulwark against constitutional crisis. We're nowhere near constitutional rot, which is a state where institutions are completely dysfunctional, where public trust in our institutions is non-existent. So we're nowhere near there. But it just shows, Chief Justice and Commissioners, how important this institution is that we serve. I'd like to pause here. Perhaps I should just say that the work that judges do is sometimes publicized on television, and it looks entertaining and so on. But the hard work, where we really grapple with stuff, is beyond the view of most people. And in reflecting on what is it that compels us to stay the course, I'm reminded of in fact, the health workers who, during the pandemic, came to work and worked to save our communities. Chief Justice, there were two things that came up in the reports. If you'd like me to deal with that now, I would deal with it. Otherwise, I'll wait for questions around those. Thank you.
I think wait for the questions. Thank you very much. Colleagues, may I have the names of those who desire to put questions to Justice Pillay, please?
Makwanisha.
Matonsela.
Muimang.
Shlima.
Nyambi.
Dodovu. Nakiesen.
Malema.
Tete.
Lamola.
Mlambo.
Thank you. Honorable Magwanisha.
Thank you very much, Chief Justice. Good afternoon, Judge Pillay.
Good afternoon.
Thank you. I only have one question for you. Is it true that you remain a director of two investment vehicles? And then if appointed, do you have any intention to remain a director of those two vehicles?
Thank you for that question. That's one of the questions I wanted to clarify. The one corporation, Beyond 1719, has been on my application from the year 2000. I explained then that it is a convenient vehicle in which my partner and I set up for my family in their retirement, not me, my parents, in their retirement. The assets in there is now 2 properties which pay rent and sustain my family. The second close corporation I inherited from my partner, who, when he passed away 13 years ago, it houses equities listed on the Johannesburg Stock Exchange. That too I disclosed on the two previous applications for appointment to the Constitutional Court, which, by the way, I was recommended for appointment on that occasion. And when I applied for the Supreme Court of Appeal, in fact, on one occasion, Justice Minister Radebe had a joke about my close corporations. But Minister Lamola is here, and he can tell me whether he wants me to do anything with those. I could very well hold those properties in my own name, the shares in my own name, but it's a nuisance, and it seems to run itself, but hasn't interfered with my work. My judgments still go out. The companies I have in my portfolio have also been, the shares have been reported in the judge's registration every year. It's been there for everyone to see, and no one has applied for my recusal on the basis that I've got net bank shares or this or other shares. It's never interfered with my work. In fact, it's better out there, locked away in a close corporation, than my having to deal with it in my personal capacity. So I'm open to suggestions, and if elevation to after 20 years, holding these instruments, if that is a barrier to elevation to the Constitutional Court, it's not a problem, it can be dispensed with.
Thank you very much, Chief Justice.
Thank you, Honorable Mogwaniche. Commissioner Madonsela.
Thank you, Chief Justice. Judge Pillay.
Hello, Commissioner Madonsela.
At page 15 of your application, you refer to the Devon Constitutional Law Discussion Group, which you're a member of. And
I'm going to listen to you. I'm not going to find it.
Yes, Anna, please. You don't have to look at it because I think you know what I'm talking about.
Yes, it's where we met first.
I wanted to explain to the commissioners what is that all about.
It was a group of practitioners and academics who came together and identified interesting topics, and one or other practitioner or academic would present on the topic and we would have a discussion around it. And that's years ago. And Commissioner Madonsela, you were responsible for keeping it alive, and I must remind you, you have not done that.
It's still alive.
Okay.
Yes. How is that enhanced? Just a follow up on that. How has that enhanced your knowledge of constitutional laws?
I've always been interested in constitutionalism, and that was a wonderful opportunity to articulate all sorts of aspects of the Constitution. And often it would be a case that came out of the constitutional law around which we would have a discussion. There was no other platform. And as a judge on the Labour Court at the time, it was pretty lonely, and even lonelier in Durban, where you sat by yourself. So the opportunity to engage academically was quite a privilege.
The second question is relates to judgments, the delivery of judgments. I have the privilege of practicing in the courts where you are the judge. And I must state this upfront that of all the judges in our division, you are particularly known for giving your judgment very quickly. And when you go to your court, you get an answer very quickly. You know where you stand with the judge, which we appreciate. Now, the question is, we, as a Judicial Service Commission, we encounter a situation where there are complaints about judges delivering judgment timely. And I'm saying this with all due respect. There has been I've noticed in recent times, because of my involvement in the constitutional law reading group, which I'm keeping going on in Devon.
You just haven't invited me.
Yes. I've noticed that some of the judgments in the Constitutional Court, where you are now sitting, and most recently one involving the Competition Commission versus Standard Bank, was delivered almost a year after it was argued. What do you think should be, or what do you think you could bring by way of, is there a process in which judgments can be delivered earlier in the Constitutional Court? Or why do the court judgments delay? Do you know?
You know, the process, as I said, there is a process and there are timelines. And if it is delayed, it is because there are some difficulties that are encountered in terms of arriving at a consensus or exploring different ways of doing things. My experience is 1.5 months. So from February to now, I've been in the court and we sat until the middle of March. So my experience is very limited to say, well, this is what needs to be fixed. But clearly, if we can get, the basic principle is that if we can get to to grasp the issues quickly and write clearly and coherently, and in fact, if we write, I suppose, shorter judgments, that might help. I know that the complaints have been coming about long judgments from the Constitutional Court. That's before my time. It takes long to read through, correct, and give feedback. But that might be one of the reasons. But there is definitely a process. I know that we all commit to the process, and it is only when there's some difficulties that arise that one has to trade off time for the best outcome.
Chief Justice, just as a follow-up on that question, with the permission,
Yes,
Chief
sir.
Justice, my suspicion is that judges don't agree when they deliberate on matters before them, and that might contribute to the delay. And to what extent do you firmly believe in the writing of your dissenting judgment, even if it may cause delay? Delay versus delivery of the judgments quickly and conceding a point that is not of substance in your own dissenting judgment?
And there's a struggle, a really solid struggle to get consensus. And but we're independent adjudicators, and we have that tension to respect. And if it is an immaterial point of departure, you might concede it. But if it is material, you have to, after trying to get consensus, dissent. And that's honest to your conscience, because that's what we're there for, to be honest to our conscience.
Their licensing very general so I wasn't actually.
Well, Mr. Chilwani, there's interference there. Please take care of it. Please proceed, Judge.
So dissent is not a bad thing. And I don't think one should look at dissent or being overturned on appeal necessarily as negative. I see judgments, dissenting judgments, and being overturned as opportunities, well, both for learning, but also opportunities for looking at things differently, opportunities for taking the best from both judgments, or for both sides, or as many sides of the debate that there might be. It's not necessary that every dissent is wrong or that the majority is wrong. And I think to say that a judgment is right or wrong is the wrong approach, because that's a binary. And in binaries, you miss out everything in between, and there might be a lot good going on in between.
Thank you, Chief Justice.
Thank you, sir. Honorable Mwema.
Thank you, Chief Justice. Good afternoon, Justice Pillay.
Good afternoon, Commissioner.
Just one question from my side, which is linked to the point that you raised around the readiness of the Commission to successfully deliver the next local government election. Indeed, the Constitution says the electoral process must, in general, result in PR. But of lately, given the directive by the Concord to Parliament to amend the electoral laws with a view to do away with our practice of saying that the only route to the provincial legislature and the national legislature is through political party vehicle, thereby ruling that independent candidates must also be allowed to represent themselves both in the legislature and national parliament. From your experience, do you think the timing is right for us to embark on such a drastic electoral reform? Thank you, Chief Justice. Thank you, Justice Pillay.
Well, it's not what I think. It's what is. The Constitutional Court has said that it's time to make this drastic change, and the IEC is really doing everything it can to accomplish that in the time frames, which are pretty tight. You would have heard that a task team has been set up by the Minister of Home Affairs, Aran Matsaledi, and the Commission is not a member of that team, but one of our colleagues is helping out with that commission. And we have to wait. There was a launch in Parliament of that task team and its work. And I think we must wait with some excitement, perhaps some trepidation. Certainly from the IEC, it's both, because as the administrative body, we've got to make sure that we deliver a draft. We're instructed to order to deliver the legislation. And I'm not exactly sure how we're going to navigate that. Because once we have a draft, it has to go through parliamentary processes of which you are better informed than I am. Then there may be challenges to the draft constitutionally and so forth. So the timelines are quite tight. And to answer your question, it is upon us. And the debate is over. We've got to get on with doing it.
CJ, just a follow-up. Look what the local government system, which is mixed, both ward and PR, where a ward candidate or a ward councillor passes on, by-election is possible. At a practical level, with provincial and national general election, when an independent candidate passes on, how from your conceptualization will we be able to deal with that difficulty?
It is one of many, many difficulties. To begin with, what thresholds do you set for entry to participate in the elections? Thresholds have to be one that you don't, it's not exclusionary. Setting a registration fee or the number of supporters, all of them have pros and cons. And those are the issues that we're working with. The question of when an independent demises, what happens? It's the jacket, as my colleague says. My jacket was there, and the jacket is no longer there. So what happens to that post? We've got to figure it out. And actually, when I say we, I mean we as a society. The burden of drafting falls very much on the legislature. And our input as the IEC is from a technical perspective on as to what would work, what won't work, what could be done better. But very much we're not sitting back, but we're helping wherever we're invited to help.
Thank you, Justice Pile. Thank you, Chief Justice.
Thank you, Honorable Moiman. Honorable Singh.
Thank you very much, Chief Justice, and good afternoon, Judge Pillay.
Good afternoon, Commissioner.
Just on your comments on the new legislation, well, it's indeed going to be a daunting task, given the timeframes that we have, but it's one that we have to deal with. And you have mentioned some of the things that we'll have to really deal with and try and convince the courts that maybe, well, we can't question the decision of the apex court, but perhaps the reality of implementing what they have said is going to be something quite difficult. But having said that, Judge Pillay, I think you are aware of bodies, legal bodies and other bodies that provide comments on each of the candidates that apply for various posts in the judiciary. And I think you were about to start commenting in your introduction to some of them. And Commissioner Magwanisha dealt with one of the issues that was raised by the Law Society of South Africa. Now, in addition to that, I see the Law Society raises the issue of your participation in NADEL, and I think you should be given an opportunity to respond to that. But in addition to that, they also say that you've had experience in the labor court and not much elsewhere. But I note you've had 10 years in KZN. But you can respond to that criticism as well. But also there are letters of objections that have been sent to us by 3 individuals. And the objections relate to judgments you've given in particular cases. I think you would have read that. And one also refers to a possible conflict of interest in 1 or 2 of the matters that you presided over. Now, I wonder whether you would respond to those comments, adverse comments that have been given, but also to say that there have been positive comments from advocates for transformation supporting your candidacy, from the GCB to say that you are suitable. So I think it's an opportunity for you to respond to those objections that have been sent through to us. Thank you.
Thank you, Commissioner Singh. Yes, the one, the first concern raised was my membership of NADEL. Now, that information you would find in my very first application for appointment in the year 2000, when my partner was alive. And I'm going to blame him for this because we tried to figure out when NADEL was formed. And I'm just trying to think back how it came to be that I put in 1984. What I do know is that the year I started articles was the year in which the DLA was being mooted, 1979. The Democratic Lawyers Association was spawned as a result of the Magistrates Court being launched in Durban late 70s. It had segregated entrances and so on. And so the practitioners protested, and DLA was being mooted at the time. Pretty soon, the other centers, Cape Town, Dalla Oma, Johannesburg, Ismail Ayub, Kachalia, and in the Eastern Cape, in Sabeza, Dumisa and Sabeza, all started thinking about having branches or organizations for lawyers. And it was edging close also to the formation of the United Democratic Front in 1983, and which was followed by the emergency regulations, states of emergency. And the lawyers' body gained traction then. So at some point, these individual bodies morphed into NADEL. And I might have the 1984 date wrong. I know that when I Googled, I see that NADEL was formed in 1987. But I was an active member, practitioner in amongst lawyers. I served with Pius Langa and Linda Zama on a subcommittee of NADEL after it was formed. And I don't think the questionnaire is challenging my integrity about whether I was involved or not. It's just that I assumed that NADEL had been formed as branches beforehand, than before it was launched in Riverside Hotel in 1987. So that's the explanation for NADEL, and that mention of an incorrect date. Then there's one person who, Ramkissoon, I think his name is, who wrote to the JSC saying that I shouldn't be appointed and all sorts of things. But that person actually applied to the Constitutional Court during my term there to have his case, the decision I made, overturned. And of course, I recused myself. And the unanimous view of the court was to refuse leave to appeal, jurisdiction not engaged, etc., but didn't grant award costs against him, and that was it. There are other people who liberally comment about judges' decisions in the media, and everybody knows that judges don't respond to media statements. People who have a gripe with judges, there are platforms to raise them. The JSC is a platform. It's getting pretty active at doing, at supervising the judiciary. So anyone who has a complaint, put it before the JSC. We'll deal with it. That's what it means to abide by the Constitution, abide by the rule of law. We can't respond to noise out there because that's just what it is. But it is damaging. It is damaging, particularly to women, when misogynistic messages hit the media. And if those women are judges, are mothers who have to put up with that, then Chief Justice, you asked me on a previous occasion, why is it that women don't make themselves available? If they have to put up with the risk of being abused of things that don't matter, that are aimed purely at interfering with our work, why should mothers put their families at risk? Because the judge can take care of herself, but her children are out there in school, perhaps teased, but worse still, threatened. So this is a very dangerous practice that our society should not allow to burgeon. We need to put a stopper. This is a sort of digital information disaster or side effects that's not helpful to our society. Conflict of interest, if ever there's a conflict of interest in which I am in a matter in which I'm presiding, then it is up to the person who perceives that there is a conflict of interest to apply for my recusal. That too is a process recognized by the Constitution, recognized under the rule of law in every judiciary. I've hardly had any applications for my recusal. So unless an application is made, unless I feel conflicted, then there's no application for recusal. The other thing to remember is the Safu judgment. When Louis Late brought an application to have late President Mandela testify, that application, well, to testify, but I think more to embarrass the president, because his evidence in chief was half a page, and his cross-examinations extended over 150 pages, but that's by the by. But the application was prefaced by an application for recusal of 5 judges of the Constitutional Court. And it was left to the conscience, apparently, of the remaining judges whether they should continue to sit. Now, there are troublemakers, detractors from our democracy, and we should stand firm if the judiciary is going to remain the bulwark against a constitutional crisis, constitutional right. Thank you.
Thank you. Judge Pillay, Chief Justice, through you. You've referred to the Ramkissoon matter. But in the book that's given to us, Feedback from Law Bodies, book 2 of 2, I don't know if you managed to read the letter from Mr. Malusi Mokhale, which is labeled as Objection 1.
GCB. Commissioner Singh, it might just be easier for you to tell me what it is.
Okay, through you, Chief Justice. Malusi Mokhale, I'll just give you the opening sentence and what he says in the end. He wrote to the JSC, I think it would be wrong to appoint Judge Daya Pillay to the apex court in the land. I was not convinced by her legal reasoning in the latest court judgment involving President Jacob Zuma. And then in the end, he says, lastly, putting her on the apex court where you need a rational, unbiased judge, where decisions of such court have fundamental impact on the lives and the lives of our nation, will be a grave mistake. Now that's Malusi. Then Mondi Duba writes on February 14, I want to raise my worry and concern about Judge Daya Pillay being shortlisted and likely to get the job to be in the Concord panel of justices. And then he ends up by saying that I hope and trust that my genuine concern will meet your attention. And then we have a third objection here from a student who calls himself a student, Mr. Simpiwe Mlotshwa. And Mr. Mlochwa here also appreciates the opportunity. He's watched the interview of Judge Pillay before the JSC on YouTube, and he asked whether the Honorable Judge Pillay still holds the view that politics is an important cases before her ladyship, like she alluded when she was a candidate for judgeship in the SCA. And then the last three lines, is the Honorable Judge a friend or a close acquaintance of Mr. Hanekom? Is the judge a friend with Mr. Godan, Minister of Public Enterprises, or a close acquaintance? Does she feel that she needs to recuse herself on matters where litigants may perceive conflicts of interest or some bias on her part? I thought it's important for you, Judge, to respond to those objections and comments. Thank you.
Okay. Well, there's two matters in which Mr. Zuma was a litigant before me. I'll deal with both. The first was the civil matter, which Mr. Hanekom brought in the Durban High Court. That case was assigned to me. I was told that I was a senior judge, and I had to, a senior available judge, and I had to deal with it. If I had a choice, my preference was not to deal with, to have one of my other colleagues deal with the matter. But I was told that there's no conflict of interest, and there was no conflict of interest, and I dealt with it. The reason I hesitated to take on the matter is, besides having allocated that Friday to do other work, I had recently been hosted by by the former president at his Nkandla home for lunch, and it seemed a little bit discourteous to be presiding in a matter. But that's, anyway, I got to deal with the matter. It was a common law dispute, defamation. And that's the law I had to apply. But knowing the parties, and I didn't have to read anything outside the pleadings, it was all there, founding affidavit, answering affidavit. It was all there. The politics was there. They were both members of the governing party. They were at war with each other. And what I recognized in that process was that I could resolve this dispute as a defamation claim and say, yes or no, Mr. Zuma defamed Mr. Hanekom. What I saw beneath that was a problem that I was never going to be able to reach. The source of the conflict was way beyond my competence, knowledge, and it was not a matter before me. And that diagnosis I was able to make because of my years of experience before I came to the bench as a resolver of disputes, mediator, facilitator, and so forth. And so that was the first judgment I made, and that's why I prefaced, because there were questions about why did I quote Oliver Tambo in the opening lines. And I thought that if these protagonists won't appreciate my judgment, then at least they must appreciate the utterances of their own leader. And it happened also that I was reading Luli Kalinikos's book, biography of Tambo, towards my doctorate at the time. And so it was fresh in my mind, and I put it there. And it's something I do in cases where I sense that the parties could benefit from some other insights about effective conflict management, not just dispute resolution, but conflict management. And I included it in a dispute. I've listed the case on where servitude, two parties were fighting about a servitude. The second judgment in which I had Mr. Zuma as a litigant, again, was thrust upon me unexpectedly when I happened to be the senior judge in the crime court in Pietermaritzburg, I was told, like I was told with the Hanekom matter, that it's probably that the matter will be adjourned. And in the Hanekom matter, when the parties pitched up in the morning, we're ready to roll, and so the matter proceeded. Similarly, in the criminal prosecution of Mr. Zuma, I was told this is just for an adjournment to arrange a date or something like that. And so I turned up in court and found that Mr. Zuma wasn't in attendance. The normal thing a judge does when a litigant fails to appear in court is to issue a warrant, and the judge has a discretion to stay the warrant. And that's exactly what I did. I stayed the warrant. There's no conflict of interest in those matters and the current matter serving before the Constitutional Court. And I'm very mindful of what I say here so that I do not disqualify myself from hearing matters in which litigants have already passed through the courts before me, as they might continue to do going forward. Because then we might be facing a Louis Late situation, and anyone who loses in litigation has simply to make a noise in the media, and judges can't be disqualified on that basis. That would be setting the absolute wrong precedent, and that would put our judiciary, this august body, in jeopardy. So that's the second thing. Am I friends with Mr. Hanekom? No, I'm not friends with Mr. Hanekom. I saw him in my courtroom on that day, and I know that it was him only because I've seen him in the media. Mr. Gordon, I've known Mr. Gordon for a very long time. We're both from Durban. We're both activists from Durban, and it's hard not to know Mr. Gordon. I think that's about it, Commissioner Singh. Have I answered all of your questions?
Yes, thank you. So in conclusion, you say in your view, these allegations of conflict, etc., are unfounded as far as you are concerned.
Completely, Commissioner Singh. The thing is that the calling of a judge is a very intense calling, like it is, as I said, for health workers. And it's very difficult to be true to the profession, to be true to the law, to be true to the Constitution. Deviation is hugely disturbing. And really, I'm completely, I was, as I said, I was party to drafting the Constitution. It is the baby that we produced. And long before that, when we, as activists, stomped the streets of the townships, mobilizing people to organize themselves and to fight for democracy, well, this is a democracy we got. This is the Constitution we got. And we've taken an oath to defend and protect it to the best of our ability. And that's what I am committed to doing. Nothing that I have done, nothing you will see in my judgments will suggest otherwise.
Thank you, Chief Justice.
Thank you, Honorable Singh. Professor Schlemmer.
We didn't hear that, Chief Justice.
Oh, I called on Prof. It's a turn.
Oh, okay.
Thank you, Chief Justice. Good afternoon, Judge. I would like to ask you a couple of questions on your link between academic life, your research, and being a judge. And specifically, I'm fascinated by your PhD or your doctorate that you did. I think the work that you've done in there is quite fascinating and can lead to quite a number of interesting follow-ups by hopefully others that will read it again. I see that you wrote there, and that is something that I also find when one reads a judgment and that you critique it, that you say here, critique of judgments tends to leave one with the overwhelming impression that fault lies with judges or that litigation has to be rejigged as a process. But then you link it also to the participation of the litigants and their representatives. Would you like to elaborate a little bit on that so that we can have an understanding as to the impact that the litigants and their representatives have on the outcome of a judgment?
Yeah, well, you've heard time and again that the process of adjudication is a presentation of the evidence and argument and arriving before an independent, impartial judge, adjudicator, who will render a reasoned decision. So that's the format, that's a formula for adjudication. But what goes into the evidence is a choice that the litigants make. How to formulate the claim, whether it's an application, whether it's a review, whether it's an action, is a choice of the litigants. And their lawyers. The litigants choose the lawyers also. So there's huge space for choice. And judges are bound by that, what comes before us, what we call as the legal materials. But when I started the doctorate, I thought, as I said, that maybe litigation needed to be rejigged so that maybe you add on another process, tag on like mediation before litigation, like we have med-ob and so on. But when I got into the process of reading, I realized that if you're going to rejig litigation, then you're going to have to call it something else, because there's something very dynamic, and I wouldn't say pure, but something very dynamic about the process of adjudication that we must not lose. And that is that argument for and against a position is a wonderful thing to be part of, to hear and to analyze and to make a finding as to which is a better way of thinking about the issue. But regrettably, we live in an unequal society, and we don't have parity of participation. And so very often the court has to come to uplift that side that is flagging, and it's usually the side that is underrepresented, has very little resources, and so forth. I've been criticized in at least 2 judgments, one by the Supreme Court of Appeal, for sticking my nose beyond where I should have, and by my colleagues in the High Court. And my answer I gave in a previous judgment exactly about this, parity of participation. How do we get the best jurisprudence when we don't have the best representation for one or other side? But so coming back to this question of choice, judges also exercise choice. And what is this extraneous thing that influences choice? Because we're bound by the legal materials. But in every case where there is, say, 5 facts, 2 principles of law, and 3 judges or 5, 7, or 11 judges, you could have as many permutations of fact to law resulting in judgments as there are judges. But you can't say that those are wrong or right judgments, because they are judgments as defined, meaning the application of law to facts to result in a reasoned decision. So what is it then that informs how judges choose facts to law? And I think this is where our worldview comes into play. How we think about gender rights, racism, how we think about the economy, how we think about everything that's important in life. So that's our worldview, and it's crafted by our life experiences, the choices we've made in our lives, a host of other things. I hope I've answered you.
Yes, you have. And I just want to follow up. I've asked the other candidates as well, the role that scholarly judgments play. When I read excerpts from your thesis, it seems to me that the scholarliness of the judgment may sometimes also depend on the argument that came before you. To what extent do you think you as a judge have an obligation to do additional research to ensure that your judgment is scholarly so that you do provide the necessary answer to the litigants if they do not, for instance, have the best legal representation?
Scholarship, I think, has been just part of my life. Once I've known a little bit, I needed to know a little bit more. And also there was a bias against attorneys coming to the bench. And so it was always a challenge to overcome that. And being an arbitrator helped a bit. But scholarship is partly about explaining things to oneself in the first instance, knowing that you've got it right. And you've got it, you've looked at the arguments for and against, you've looked at articles for and against, you've looked at cases going this way and that what you finally settle for is what you're comfortable with. And then the next challenge is to present that in a way that the readers, particularly the litigants, are able to access it easily. So legal writing and not legalese, it means writing clearly, concisely, and precisely, and communicating complex ideas as simply and effectively so that the litigants can develop from there, the practitioners can develop from there.
Thank you very much. Thanks, CJ.
Thank you, Prof. Honorable Nyambi.
Thank you, CJ. Afternoon, Judge.
Afternoon, Commissioner.
My question is linked to the one that has been asked by Commissioner Singh. The issue of the support from Advocates for Transformation. They raise that sometimes you appear temperamental, but they are supporting you. But when you're responding to the first objection about the issue of the former president, the one that was read by Honorable Singh, he touched the introduction and the conclusion. Once you read the letter, it's explaining that part of what was raised by the legal team representing former president, there was an issue of a medical certificate coming from a government institution in the form of a military hospital. And you were in a rush. So they talk of lack of empathy and humanity in how you handle that issue. So I thought when you have the opportunity, you were going to touch that issue of the letter because that's where this issue of lack of empathy and humanity, and those are attributes of a good judge. Your comment on that?
Well, I think you would have heard the hearing was televised. And the reason why I questioned the medical certificate was because of the alterations in them. So it had nothing to do, it's what I would do with any litigant. If, you know, the court sees medical certificates of all kinds. And it's and sometimes the medical certificate will read, the patient says he's unwell. Now, it's for the doctor to say whether the patient is unwell and what is wrong. But this had alterations. Now, that's my concern. And I did exercise my discretion in favor of Mr. Zuma in the sense that I did not authorize the issuing of the warrant immediately. I stayed it because that's what we do. And Mr. Zuma was not a flight risk. So I did exercise my discretion judiciously. I trust I've answered you.
What is it that you might regard as your own weakness?
I'm sure I have many, and the DGRU has identified one for sure. They called me a sledgehammer at my previous interview. I don't cut through butter like a hot knife, meaning as a metaphor that I suppose that I could develop my diplomatic skills a little bit more. And yes, that's true. That's one of the criticisms that came up, and yeah, I'm sure I have others.
Through you, CJ, I was expecting something that is coming from you, not the one of DGRU.
Oh,
your own weakness that you regard as your own weakness.
I know I mentioned it because I identify with that criticism. And, it's not just the DGRU who's raised it. It's also my friends who tell me that, I could rush into things and express my views rather robustly on occasion instead of soft pedaling and being a bit more gentle.
Thank you, Judge. Thank you, CJ.
Thank you, Honorable Nyambi. Honorable Dodovu.
Thank you, CJ. Good afternoon, Justice.
Good afternoon, Commissioner.
Good. In the public discourse today in our country, there is a talk of judicial dictatorship. And as I observe it, it is coming up very, very strong. Now, this afternoon, I just checked what is dictatorship in a dictionary. It says it's absolute authority in any sphere, intolerance, and imposition of power and authority. Do you, as a person, believe that there is an emergence of judicial dictatorship in our country? And what does it mean in the context of our constitutional democracy?
Thank you, Commissioner. There's a book called Towards Juristocracy that I found useful. And basically, what juristocracy is a condition in which the judiciary wields more power than the other arms of government. Now, the judiciary doesn't decide cases unless they're brought to it by the other arms of government, by the people. And the difficulty for the judiciary is, accelerates when there is a lack of common purpose and reciprocity in society. When people find it very hard to arrive at consensus about things and constantly run to the courts, to ask the courts to make decisions that they should really make themselves, then the litigants are giving the courts more power than the courts even want. The courts, Justice Froneman made this remark, I think it was in the Sausage judgment. It is the crisis in government and in institutions that burdens the courts. It's not the courts that chase judgments and seek power for themselves. So the one way that happens that juristocracies are created is when society is unable to resolve its conflict amongst themselves without judicial intervention. The other is when the court is packed by the appointing authority, by persons who would espouse the values of the appointing authority. But there's a danger in that, because today person X appoints a judge. There's no guarantee that that judge is going to make decisions favorable to that person or that interest, and vice versa. There's no guarantee that that person who made the appointment is going to remain in power as the cycle of democracy changes. But there's a third element, and that is that judges have a class interest. All of us are educated, we have to be. And many of us have better education than others, have come from better economic circumstances than others. And when we choose judges, yes, we must, the Constitution says, have regard to race and gender. But elitism is a phenomenon that we need to watch in the judiciary. So it is protecting constitutional rights that is foremost. And that must be the agenda. Elitist interests should not be encouraged. And that's when you get juristocracies.
Okay. Linked to what I'm asking you about, there is a talk of other tendencies that are beginning to manifest. For example, people are saying that judges in South Africa today think that they are above the law, they are above reproach. There is a modicum of encroachment into other spheres of government. And where I see it, should I be worried? Just today and yesterday, we heard of something that is worrisome. A top 6 within an institution like the SCA. Where I see it, should I be worried that when such things are emerging, because top 6 to me is a cartel. It is an infection. It is toxic. Should I be worried where I see it that things are okay and the judiciary is on top of the world, is okay, there is nothing wrong, and they will preserve our constitution. And as you say, it is a bedrock of our constitutional democracy.
Commissioner, I think all of us have a lot to worry about. Well, I mentioned some of my concerns, and it is a deep concern that we don't dialogue as much today as we did when we drafted the Constitution. It's amazing that we've had this, what is regarded as a peaceful revolution, with the acceptance of our Constitution worldwide recognized and so on, that there's such a high level of disagreement amongst us. As for the top 6, I heard about it. So I went prepared when I went to the Constitutional Court. I said, I'm going to put my head down and draw the best I can out of this experience. And I did. There were minor skirmishes, and thanks to Rami Matopo, whom you've heard earlier today, he was a blanket of comfort. I called him my social worker, and he paved my way, and to the extent that the experience was overall positive.
Okay, thank you. Thank you. Lastly, Chief Justice, and I'm linking this with the questions that I posed to you earlier. You are part of the electoral court. You are a judge
Commission.
Electoral court.
No, I'm not.
Are you not part of the electoral court?
No.
Okay, if that is the case, I stand down my question. Thank you, Chief Justice.
Please add my name.
Thank you, Honorable Commissioner Nokesi.
Thank you, Chief Justice. Good afternoon.
Chief Justice, is my name there?
Oh, it's your name.
You are next, Honorable Malema.
All right.
You come after him. Yes.
Chief Justice, Chief Justice, is Cyril Taba. May I request that you add my name as well, just to follow up at some point? Thanks.
All right, I will include you, sir.
Justice, these questions have been dealt with extensively by Honorable Singh and Mr. Nyambi. But there's just one other objection that I'm not sure whether you have seen, this one of Avinash Ramkistan. Yeah. Well, I mean, it's the language he uses which concerns me. For instance, where he says, I mean, referring to you, I mean, in paragraph 2 and 1, so, one who we accuse is also in the business of being a prepaid judge, one whose name is also found on the CR document, CR17 document. My question is in relation to this. I know because we don't have evidence. How do we end this thing?
How do we end?
How do we end these, whether it's rumor or whatever, because here is every time this thing emerges, and it's now emerging that you are one of the prepaid judges, you're in a document. How best this can be dealt with in your own way?
Well, I think set up a forum, conduct an inquiry, put up the evidence, call us to account. That's when we will deal with it. I can't respond. No judge can respond to media statements. And as I mentioned earlier, Commissioner, litigants who lose are the ones who complain to the JSC, as you would know.
Yeah.
And for every losing litigant who makes a noise on the media, for the judiciary, for the leadership in the judiciary, for the JSC to react, it's not right. And to react means, and to act on it, means that we are confirming that those detractors are interfering in contravention with the Constitution, with the judiciary. Whereas everyone, organs of state, must help the judiciary, Section 165, and must obey the laws and court orders, even if you don't agree with it. That Mr. Ramkissoon appeared in my court unrepresented. And in motion court, and practitioners here would know, he was first on the roll, he came up as an urgent, and he started, and I said, Mr. Ramkissoon, I have this courtroom of people waiting to be heard. How long do you think you're going to need? Oh, I'm going to be here the whole day. I said, well, that won't happen. I have to, if you want a whole day, it has to be arranged elsewhere on another time. But how long do you think you'll take to get your point across? Half an hour. I sat quietly. I heard him out. I made a decision. His papers were horribly in a mess, which was confirmed by the Constitutional Court.
Yeah. No, okay, no, it's fine. The last question is, it's just kind of, I follow up from from your statement. You said you attended a function of President Zuma, I mean, former President Zuma. Was it at his, I mean, at Nkandla, I mean, that's how I understand. Was that at the, I mean, during the time when you were a judge, when there are these disputes? And what is your relationship with former President Zuma? What is your own relationship? I think that's my only question.
Okay, as the IEC, I get to meet the previous presidents as part of IEC work, and that is in the context in which he hosted me and another commissioner at his house. But my relationship with Mr. Zuma goes back into the days when he was in exile. He facilitated my visit in search of a friend of mine, the late Rajas Pillay. He was very gracious, and he ensured that I was met at the airport. He came to say goodbye. So my relationship with him has always been affable. He's an amiable person. And even after he became president, I met him at the budget speech. And so I have no personal truck with the president. I just do my job. And I am a disciplined member of the judiciary, and I have to be after 21 years.
But these allegations now of conflict, if you have such detailed relations in the eyes of a public man, somebody from the public, don't you think that they have some merit? But that's a question for another day. Thank you, Chief Justice.
Yes, Commissioner, it is a question for another day, but in court.
Honorable Malema.
Thank you, CJ. You'll have to indulge me. Afternoon, Judge.
Afternoon, Mr. Malema, Commissioner Malema.
Do you think that it is correct for a judge to look up to a politician for a decision whether to be in business or not? A judge that is applying for the highest court says to us here, a minister will tell me if I must leave business or not. Do you think it's correct to even say that?
Oh, I think the Act requires the Minister of Justice to approve the holding of any other office or source of remuneration. The Minister can confirm that.
But for you, morally and otherwise, we just heard here that you have listened to a case of that involves Standard Bank. And we hear in the same spirit that you've got shares in Nedbank. You might be biased in a sense that the decision you take on Standard Bank will have implications on Nedbank, and it can therefore influence or affect your shares. Looking from a distance as a layman, what must I make of you with such interest in business?
Well, I don't have an interest in business. I think if you go around and ask judges, many judges have investments in many institutions. And if you look at the registry of judges' assets, you'll find those disclosures there. I have shares in Standard Bank, I have shares in Nedbank. And so punishing the one or the other is not going to make any difference. In fact, they're furthest from my mind. And in fact, the judgment against Standard Bank, it never crossed my mind that my shares would be affected at all. You know, Mr. Malema, this issue of judges and their judgments affecting the share price was actually very much more topical when we were in the labor court, because a judgment saying that a strike was lawful or unlawful had a big impact on how the company operated. This is insignificant, and I think most of us have retirement annuities, and one way or the other, our pensions are invested in the PIC, which in turn holds shares. So the proximity of my decisions to these entities is just so far removed that it's not an issue.
You might understand that not to be an issue, The banks have become a big problem in this country. The banks have become too powerful in this country. And for a layman who litigate against banks, which in most cases win against us, and sitting from a distance and knowing judges have got shares, worse in all banks, because you even went beyond, now you've got 2, 3, Nedbank, Standard Bank, and all of that. Banks win cases against us and judges have got shares in the banks. It doesn't matter whether it affected your judgment or not. Justice must not only be done, it must be seen to be done. I'm sitting in a village in Mkomeni, in Butlokwa, in Limpopo, and I hear that that judge who presided over my matter against the bank actually has shares in the bank. What does it do to my brain? I've got no education, I've got nothing. I don't know how it works in terms of shareholding or being a business person in the banks, but we just know business to be shares. You've got shares in the banks, you preside over matters that involves banks, and you rule in favor of banks against ordinary individuals. Does that help to enhance the good image of the judiciary?
Mr. Malema, I think the practitioners in my division will tell you how I lambasted the banks. Standard Bank, for instance, comes to the High Court with a claim for 10,000 rands repeatedly. 10,000 rands is the cost of hiring an advocate. Why are they litigating in the High Court? The reason I get is, or the explanation that I get is that the banks are chasing returns. So they have a panel of attorneys, and you got to perform, you got to deliver. And so the more you litigate, the more revenue you bring for the banks, the more you are used. But it doesn't cut it in my court. They also litigate for amounts that should actually be in the courts below, magistrates court, district courts, and so on. And I have repeatedly transferred matters there, and I've invited them to take me on appeal. I've given them 6 reasons why they should not be in the High Court. Of course, that increases the cost of litigation. In the 2 matters where there was this 10,000 rand claims, the litigants were, in one instance, in Port Shepstone. The case is being heard for 10,000 rand in my court in Durban. And they were expected to make that decision. They can't pay their debt, let alone get to a court. So I can assure you, if assurance is needed, that the banks really don't think I'm their friend.
Judge, you see, that's the problem, because we are now being extremely subjective because of your involvement with the banks. I'm saying to you, and we have to get this point very clear, not you. Remove yourself and your shares and your interest from the bank. I'm saying to you, would it be in the best interest and in the good image of this judiciary to have judges having shares in the banks and ordinary people litigating with banks and losing? We're not saying you are judging in favor or not, but we know in most cases our people are losing against the banks because they don't have the muscle to fight the banks. And they later hear that actually the judge so-and-so, Judge Mpofu, is a shareholder in the banks where they were litigating against. Will that help to enhance the good image of the judiciary? That's what I'm talking about. We're removing you now.
Commissioner Malema, I think if you look at the JSC, where most of our investments are, all of the corporates are in one way or the other infringing on one or other rights of workers, of the people, because these entities are in the business of making profit, whether it's Vodacom or MTN, the complaints about, well, the Constitutional Court had a Vodacom decision to make, but data pilferage, abuse, all of that, big companies, they do it. So whether it's a bank or whether it's a utility, whether it's a mining company, all have skeletons of one sort or another. So if someone can find a safe place where our money can grow for our retirement, our RAs can be invested, I think we can all rest more comfortably. But we can't manage our money. We can't be in business and make our money grow. We have to put it into fixed deposits otherwise, and hope that inflation doesn't eat it up. But that's the state of play. And if there's a collective decision that we must not invest in particular entities or in particular forms, I'm happy to abide by the collective decision. But
Well,
there we are.
I take it to my, you're not going to answer my question. I heard someone of the lawyers saying there's something called evasive. So there's something that sounds like that. Let's leave it. Is there a picture of you and Hanegom and Godan circulating?
You mean together?
Yeah, together.
I've never taken a picture with Mr. Honecker.
Do you have a picture with Mr. Godan?
It's possible.
What's
but
your
I'm not
relationship with
circulating
Mr. Godan?
I've answered that I'm a friend of his. We've been friends.
Do you think it enhances the good image of the judiciary to have judges befriending politicians?
Unfortunately, it's not a relationship I can dissociate myself with, for the simple reason that he has been my friend from a long time, and I cannot deny that. It's never, the fact that he's been in government has never interfered with my adjudicative work. And he and I recognize boundaries. Politicians recognize boundaries with the judiciary. In the IAC, I interact with many politicians, and there are boundaries.
Judge, you know, when you interact with us in IEC, you're not our friends. We're not friends.
I know.
Yes, I'm talking about friendship, and you shouldn't deliberately distort what I'm asking about. You are a friend of a politician called Pravin Gordhan, who is alleged to have captured judiciary. And I'm asking you, does that help to enhance the image of the judiciary? And you never answered the question on your practices, if whether these practices are helping to boost the confidence of our people on the judiciary. That's what I'm asking about.
Okay, so if that's the part that I've evaded, I thought I had answered it. My answer is that I don't think, I don't know enough. But if somebody sitting in the rural area has the interest in my holding shares in Nedbank, I seriously doubt it, because I think my work as a judge should not be determined by what shares I hold. But if it is a problem, we can talk about that. As far as Gordon capturing the judiciary, as you say, it's allegations. If there's allegations, they must be tested, put up the evidence, bring it to a process, let's investigate it. I'll be happy to participate. Allegations out there is just allegations. Sorry.
No, I'm saying you being a friend of a politician, does that help to boost the good image of the judiciary? I'll tell you why. There are judges that I've known from when I was young. And when they got appointed, I disassociated with them for their own protection and for the protection of the judiciary, because there shouldn't be a story that they are friends with politicians and therefore they conduct themselves in this or in that way. And you are saying you will never terminate your relationship with Gordhan because it comes from a long way, even if it damages the good image of the judiciary, because from that friendship, an impression can be created that Gordhan is influencing you and you are influencing others to rule in the favor of his faction.
Commissioner Malema, you asked me what my relationship was. And in the broad nature of what of defining a relationship, I use the word friendship. Yes, we have been friends, but my association, and it's never impacted on my work as a judge for the past 21 years, and it will not impact on my work going forward. I've made judgments against the Treasury. I've made judgments against against SARS, and it's never been a problem. But friendship doesn't necessarily mean that I'm having breakfast, lunch, and supper with Mr. Gordon. Our association has drifted over the years, precisely because, well, COVID has also been part of it recently, but over time, the two of us, when I spoke of boundaries, this is what I mean. My association with people who have been my friends, who are now politicians, have distanced themselves from me precisely for this reason. They don't want to compromise me. They respect the judiciary. They respect my role in it. They want me to be in the judiciary. Many of them have supported me in this endeavor in this application. And so they know where my heart is, and they know that my heart is not with politicians, but my heart is with the people of South Africa for whom this constitution is meant to serve.
I didn't get the impression first time because I thought the constitution was coming after the relationship with Gordon. Thanks for the clarity. The other question, after the lunch with President Zuma and going to preside on his matter, did you declare to the parties involved that you had a lunch with President Zuma? And after declaring to the parties involved, did you declare in the public court for us, the public, to see if that will not be a problem for us? Because you cannot go and have a lunch with a person and before you know it, you are hearing a matter involving the same person and you don't tell us, because I want to tell you now, if I knew you had a lunch with Zuma and you declared it publicly, I would have made an agent application to join that court and ask for your recusal, just for that reason.
No, quite right. If I was in a social engagement with Mr. Zuma, I was having lunch with him as one friend to another, I would have disclosed it. I was in an official engagement, and as part of my official duties, I didn't think it was important to mention all my official engagements. It's a matter of public record. And I would have assumed that Mr. Zuma would have instructed his counsel to apply for my recusal, if that was a problem. I anticipated an application for a recusal for one or other reason, but both parties were very happy to have me. And in fact, there was a high level of collaboration by both counsel with each other in the proceedings. They made my work infinitely easier because there's no dispute of fact. There's no dispute of what law applied. The issue was for me to decide whether this appeared in the tweets, I think it was, and this having been said, does it amount to defamation? That's all I had to decide. And that's what I decided. Both parties knew my background, I assume. There's no secret about my associations. So there was no application for my recusal. I did not feel conflicted. And this is the thing about the law. You focus on the law, nothing else matters.
Ma'am, the public court doesn't only belong to the litigants and you, it belongs to us. And whether Zuma was happy with you, maybe he thought because you had lunch, you can deliver something. I don't know. That's why he didn't object you. I don't know why Hanagom didn't object you. But I'm saying, we, the public, coming to hear now that you had a lunch with Zuma and you didn't have the courtesy to tell the public that is also interested in the matter that please, if it comes across one day that I went to Nkandla to have lunch with Mr. Zuma. Please be aware I did. Don't you think in the judicial wisdom, it was necessary to take us, the public, into confidence?
Ms. Malema, if I did not mention here that I had lunch with Mr. Zuma, very few people would know about it. I don't mind the public knowing. And I'm happy to disclose everything about my relationship with Mr. Zuma or anyone else you want to ask me about. But so here I am disclosing, and if I had something to hide, you should be worried.
Again, you're not answering my question, because I'm talking about a case, and that case even involves monies that people are going to have to pay. I'm not talking about these proceedings. I'm saying in the judicial wisdom that you claim to possess and you want to go to the highest court. Don't you think on a higher side now, you should have made us aware, not because you want to go to the constitutional court, but in your execution of your duties honestly, that because this is a high profile case, it involves high profile people, please be aware that I had lunch with Mr. Zuma, or put differently, do you know what it was going to cost if someone had leaked your picture with Zuma during lunch after hearing that matter, even before you delivered judgment? That remember, this is the judge who just had lunch with Zuma before hearing the matter of President Zuma. Do you know what damage was that going to do to the judiciary? Worse if you didn't declare. Because if it comes through other sources, it's like a breaking story. But if it is declared by you, it's fine, it's well and good, it's clear, you have nothing to hide.
Well, that's what I thought I was doing. I mean, I didn't have to declare, but as I said, I was on official duty with Mr. Zuma. And if a picture appeared on social media, it wasn't a problem, because that's what social media does. And whoever wants to spin a story around it would. It's a question of to what extent we buckle under the pressure of social media, and to what extent decision makers are able to separate the noise from the reality. Which brings me to reminds me of another book, Mr. Malema. It's a book titled Tough Cases. And a group of judges in America got together and wrote about their tough cases. One of the tough cases, and if you Google now Elan, Cuba, you will see that that was one of the toughest cases of the judge presiding in that matter. It was a case of this youngster who escaped with his mother from Cuba, and the American court, that this particular judge sitting alone had to make a decision about that, where that child's custody lay. It became an international debacle, with the media camping on the child, where the child was living, and the judge had to cut out the noise of the public on the issue and focus on the law. It gets tougher and tougher to focus on what we are meant to when there is this noise in the media, these allegations. I hope I've answered you.
No, you didn't. Chief Justice, I'll move. What is Morogoro Consultative Conference? Whose consultative conference is this one?
I think there's an ANC Morogoro conference that Kalinicus refers to in her book.
So a judge quotes a political party's conference document in a judgment. What do you call that if it's not a judicial capture?
Are you referring to Tamba's?
Yes, Morogoro. We are quoting Tambo's closing address of a political party gathering in a judgment that belongs to me. It's not your judgment. Once you pass it, it is the judgment of our courts. And I must also quote it confidently and rely on it. But it's quoting a political speech given in a political party gathering, not Mandela's speech given at the Union Building, accepting to be a president of the Republic of South Africa. The two are different. This is a political party gathering. You confidently open a judgment with it. What do we call this?
Well, as I explained earlier, that I quoted that because that is the president of the litigants before me. And if I didn't make sense in my judgment, and I did say to them in the judgment that this is a conflict over which I have no reach. And so by quoting that, I was alerting them to their president, and hopefully they would listen to their president, look to themselves to see how they could overcome their conflicts. So that's, I quoted it from literature. It's a biography of the president of the ANC. So it wasn't meant for anybody else, it was meant for the parties.
Judge, you knew what you were doing is incorrect. That's why you didn't write. It is called, I asked you deliberately because I know it. It is called ANC Morogoro Consultative Conference. And you knew that it will be inappropriate for you to quote ANC documents in your judgment. You deliberately omit the ANC so that people will not even know that a judge of a neutral court quotes a political party gathering documents in her own judgment. Yet we must still perceive you to be a neutral and objective judge who's not biased. Judge, I'm going to argue in this in a closed session, that you are nothing but a political activist. You are no judge and you deserve no high office. If anything, you also factional and belong to Pravin's faction, and you are pursuing factional battles using the bench. Will I be fair in that criticism?
No, you won't. For your information, Mr. Malema, I refused leave to appeal in the Hanukkah matter. It went to the Supreme Court of Appeal, who refused the petition. It went to the Constitutional Court, and the Chief Justice also was party to the decision refusing leave to appeal. So if I misbehaved in any way, there was every opportunity for the court sitting over me to call me to order.
Thank you, Chief Justice, and thank you, Judge. Thank you, Chief Justice, for being
you, Mr.
patient.
Malema.
It was necessary.
Thank you, Honorable Malema. Commissioner Tsepe.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon.
Judge, I want to take you back to the time when you were talking about the work that you have done. And as you know, the Constitution requires courts, when interpreting any legislation and when developing the common law and the customary law, to promote the spirit, purport, and objects of the Bill of Rights. What has been your experience in specialist courts or when dealing with commercial matters? What has been your observance of how the judges are dealing with this constitutional obligation? And can you point to cases that you wrote that reflects your observances of this important constitutional obligation?
I try as much as I possibly can to find a constitutional angle to the cases I'm deciding. But for most practitioners, the Constitution, they practice law as if the Constitution doesn't exist, as I said earlier on. And the only time they start looking to the Constitution when they try to scrape the barrel for a ground to appear before the Constitutional Court. And as I said, you got to flip through the Constitutional Court judgments to see how often this happens. We don't have enough or strong constitutional consciousness or culture. And part of the writing project that I promote and support is aimed at encouraging that consciousness, because I think if people write, then the hope is that they would also act in the public interest. And so the topic is not just on any competition, not just on any constitutional issue. It's on public interest issues. So I don't know whether I've answered or whether you want me to go on.
It's fine, Judge. The one issue was to point out the cases that you wrote where you reflect your observance of this obligation. Chief Justice, if I may, just on the issue of the competition that you have encouraged, I wanted to find out, following your address, I think at one of the universities, to encourage law students to practice public interest law. Have you been following up to see if that challenge has been taken by law students? Because it is an issue that I'm particularly interested in, to see that young people actually do practice in public interest law.
Yes, in fact, many articles actually come from the women. And incidentally, the last winner of the UCT award had a publication in Muslim News, which was a circulation, a national circulation. And it was an article accessible to ordinary people. You know, Muslim News is a newspaper. And we awarded that. And she was the attorney. She was now an advocate. And she was the attorney who brought the Daniels case to the Constitutional Court. And she presented the article on Muslim women's rights on death of a spouse, and we had an American interlocutor to take her through her paper and make the presentation, which went very well. So most of the writers are in fact women. And we had a transgender who was a winner of the first award, and his topic was toilet space. So it's developmental.
Thank you, Judge. Thank you, CJ.
Thank you.
Thank you, Commissioner Tsepe. Honorable Minister.
Thank you very much, CJ and Judge Pillay.
Thank you, Minister.
My first question is it, to your understanding, the first time that an ANC policy document or speech is quoted by the courts in delivering its judgment by yourself? I remember reading a judgment. It's just that I can't remember whether it was at the Concord or it's at the Gauteng High Court, where the court quoted the ready to govern document of the ANC with regard to the intention of establishing a Chapter 9 institution, which is the Office of the Public Protector.
You're probably right. I know of no rule and no rule of law that says you can't quote from any particular document. And of course, Kalinikos is an authorized biography. It's a fairly reliable source from that point of view.
So it will not be inconceivable that in assisting the courts to sometimes understand the intentions of the legislature, you may go to the policy views of the governing party. In
fact, in the early judgments, if I recall, there would be extensive references to the Freedom Charter. And I suppose in the certification judgment, there would have been references from the charter there. Academics write about the Freedom Charter as being the source from which the rights emerge in the Constitution.
Oh, okay. No, that's fine. Does the perception of bias with regards to your shareholding in various investment and so forth worries you, particularly in the eyes of the public? Because I think what is important is what also the public think about this issue of bias, whether it's real or perceived.
Nobody's raised this issue with me for the past 10 years. And it's been there out in the public domain. And more recently, we've had to disclose all our interests and so on. And the media made a spectacle of my assets. And that's just par for the course. It's open for anyone to inspect, and anyone who feels uncomfortable, as I said, there's a process. Raise your concerns. Quite frankly, it's a nuisance to have to manage these assets, and to park it off in a place that I don't have to think about it is an easier option.
I can confirm that it's true that there is that register of interest for judges. Do you think it does, the fact that judges sometimes could have their interest housed somewhere in trust or in investment companies and so forth, affect the issue of bias, particularly in the public perception for the job that they do on a day-to-day?
Minister, I consciously avoid putting myself in positions that are likely to disqualify me from hearing cases. It means that you isolate yourself increasingly, and particularly now in the Constitutional Court, this is ever more so. Because so many of the issues are issues in which the public have an interest. And when I joined Cancer, I had to think carefully about joining this organization. And I decided to join them because of the public interest value that they serve. And to bring my skills and experience to that board. But Cancer is one of those organizations that's not litigious, as far as I can see. And if there's any litigation against it, I will not be able to participate. Similarly, I mean, some people think it's an anomaly that a judge serves on the IEC. And of course, I cannot preside in any matter in which the IEC is a party. But I don't have any interests otherwise where I can disqualify myself from presiding. Certainly, if someone who is a friend of mine who appears in person, but who that person also holds an official position, if that person appears in person about a divorce or something like that, I'd probably remove myself. But in an official position, then it's just that, an official position. We interact in different ways, and I don't see any reason for removing myself.
What is the impact of the allegations that are made against the judiciary to yourself as a judge in person? I mean, even your colleagues, including the institution of the court itself, if those allegations are not put to a process of investigation and of giving you as a judge or the institution of the court an opportunity to respond to these allegations. And these allegations are perpetually made in the public platforms, in social media, and all kind of platforms that are available.
Well, as I said, Minister, we as individual judges can't react. It's the institution, our leaders, those who value the judiciary as an institution, the protectors of the judiciary. It's up to the institutions to defend us for their own sakes and for the sake of our institution, the judiciary. As I said, this is one of two institutions holding up the democracy. And there's a risk if it's not defended effectively, then we are going to slide. There's and there's instances of when women become vocal, powerful, influential, not just here, but in my election work, there was a case of a woman who was a frontrunner in an election, and 2 weeks before the elections, they somebody put out a media statement saying that she was seen in a parked car late at night with a man, and that destroyed her election campaign, and she had to join forces with another incumbent. But these false statements are hugely damaging. And they damage also not the person targeted, but the institutions. And as I said, the failure of institutions is a symptom of constitutional rot.
Do you have maybe examples of countries where this like could have happened and led to this constitutional crisis or mayhem or whatever that could arise, as you started earlier on when you started with your presentation?
I don't have personal knowledge. Like everybody else, I read in the newspapers that that our neighbors have had issues of a constitutional nature of one sort or the other with the judiciary. There's the Judicial Institute for Africa, which publishes the travails of judges in Africa on a weekly basis, and that publication is housed at UCT, and I can't remember offhand of a more specific case, but I think, and I don't think it's right for me to mention the country, but there was a country where the Chief Justice was hounded. Delegation sent to her by politicians, sent to her doorstep, and she was on the run. And the chair of an election management body in Africa had a similar experience, had to pack up and scoot to another country under cover of darkness. So election management bodies and the judiciary are threatened species. So we really need to be careful.
On one of the tasks that you said you have done was this issue of arbitration on various matters by private parties. One of the criticism I read about and get from practicing attorneys and advocates they raise about the private arbitration is that sometimes it denies the courts an opportunity to develop jurisprudence, and as a result, in our country, there's paucity of commercial jurisprudence. And there could also be some kind of a designed, deliberate obfuscation of the role of the court in dealing with commercial disputes. That's why most of them, they end up with the arbitration, although sometimes they could go for review, but the courts are really, in most cases, denied an opportunity to develop this jurisprudence. What is your view to that criticism that comes out from time to time?
Oh, that observation, Minister, you're absolutely right. I mean, the observation is true. If you look at the court roll, trial court roll, JP Mlamba will bear me out here, certainly in Durban, bulk of the cases would be road accident fund cases or claims against the MEC or the Minister of Police for malpractices of one sort or another. The state is usually the other party. The commercial disputes have been disappearing from the roll. The motion court is full of claims by banks claiming against for unpaid debt. You hardly ever have a commercial dispute in which you can get your teeth in. The most likely commercial dispute you will get is probably where there's an imbalance and the weaker party can't afford the costs of the arbitration, and then you would get a commercial dispute in those circumstances. But absolutely right.
So what do you think should be done to help this kind of a situation?
I heard along the corridors that a certain JP has been recruiting judges to his division to bolster the commercial experience on the bench so that practitioners are attracted to bring their matters to that court. And that is one thing that can happen.
Thank you, CJ.
Thank you, Minister. JP Mlambo?
Thank you very much, Chief Justice. The first question I want to ask you, Judge Pillay, is the main litigants in our courts today. I think you dealt with them in the last question from the Minister. It's the government and state entities. It's the banks and it's the RAF. Those are the main litigants in our courts.
Yes.
Insofar as the banks are concerned, their main area, I think you alluded to it, is foreclosure. Who stood up and introduced directives to curb the trends that banks had developed when they embarked on foreclosure applications against financially depressed litigants?
Was it? Yes?
Who was it?
It's the judiciary. The judges actually set benchmarks on a number of fronts. That foreclosure, firstly, the Constitutional Court and the right to property to start with, that if there was, if the foreclosure was of a property in which there was children and it was a primary residence, then there had to be better arrangements made before there could be foreclosure.
Yeah, but it's the judiciary.
It's the judiciary
that stopped that racket.
Yes.
Thank you. You wrote a dissenting judgment. I'm just changing the subject a bit. A dissenting judgment in that matter penned by Judge Steyn, in which Judge Nkosi concurred regarding the role of Section 342A of the Criminal Procedure Act. I'm asking you this question simply for you to explain, and I don't want you to give a long explanation, why you dissented, which Judge Steyn criticized as a constitutional analysis rather than dealing with the facts. But am I correct that Section 342A is one of the most effective tools in the hands of judicial officers to prevent backlogs and delays in litigation?
Absolutely. It was a very difficult decision and probably took me the longest to write because the majority in my division was held the view that Steyn J was espousing. And the magistrate's court, in this case was in the magistrates' court for 8 years. There still hadn't been a plea. There was all kinds of delaying tactics. And finally, there was an application for a stay of prosecution in the magistrates' court brought by this litigant in that court. And then there's a challenge now. Why did that court assume jurisdiction? Well, the parties brought the case before that court, and it boiled down to an interpretation of Section 324A and a constitutional interpretation. And I think the trap that my colleague found herself in was the notion of subsidiarity. And she cited a professor who's, for that authority, Professor Statler, a very nice professor who participated with us in the Detainees Parents Committee, but that's an aside. His textbook was out of date.
Yeah, but I think the long and the short of it all is you buttressed the importance of the section.
Yep.
Especially regarding the history of that matter. Right. My last question, you can respond if you want to. And I'm sorry, CJ, it's the third one. How feasible is it for all judges in South Africa to close all their bank accounts, to receive their salaries in cash, and if they have anything left, to store that cash in their houses?
I think that's a rhetorical question.
Thank you, Chief Justice. No further questions.
Thank you, Honorable Kaba.
Thank you very much, CJ. Good afternoon, Justice.
Good afternoon, Commissioner Krola.
Thanks. I must say that I am impressed by your calmness and the clarity of answers. Now, coming to the question. In Westwood Insurance Brokers versus eThekwini Municipality, you handed down a judgment, I think it's your judgment, in which you held municipal officials personally liable for the cost of litigation.
I tried to.
And your ruling is a sequel to other rulings holding government officials personally liable for cost. That the courts are intervening in this way, does it not suggest that our laws are not tight enough, or the law enforcement agencies are not doing their work? What has been your experience?
Thank you for that question, Commissioner. I think I should explain what Westwood was all about. And it was in the context of procurement law. And procurement law is one of the tightest systems we have. There's like 4 tiers of checks. And if you don't meet the first baseline check, if you don't produce a tax certificate, or if you don't meet the requirements, if you don't fill the form properly, you're out. So Westwood is the most extraordinary procurement decision I have ever encountered. And we talk about changing the laws, but I think there's a human hand at work here that needs to be visited. So what was this case about? The case was that eThekwini had put out a tender for water insurance. The requirements were that the tenderers must produce a certificate of being registered on the Financial Services Board. And they must be South African companies. But most importantly, they must be capable of providing water insurance. So when the matter came to me as an urgent, they had more or less agreed, the parties, to a setting aside of the award. And they wanted me to make the decision. But council had failed to realize that, and the setting aside was on the basis that they were not members of the Financial Services Board or registered in South Africa. Two facts you just had to Google to establish. The third fact, when I scrutinized the papers, it wasn't provision of water insurance. It was provision of professional indemnity insurance, which means that when doctors and lawyers malpractice, that was the insurance for that purpose, not for the leaking pipes in the townships and so on. And so what would happen if I didn't step in? So this is a situation where judges are careful about stepping in and making a decision for the decision maker, which would have been at Tegweni. But I left the incumbent who had the business to continue providing that service, because what would happen is that the township houses where we paid 5 or 10 rands as part of our bills would then have to provide their own insurance, and they don't even know how to get private insurance. And if there's in a drought situation, the water is wasted. It's a calamity. So that ended the substantive dispute, but there's a question of costs. And I could not understand how in all this pleading, there was no explanation for how this error came about. There were legal advisors involved in the process. There was one youngster in the administration who put out a report to say this tender shouldn't go through. And they disregarded that voice. It went through 4 tiers. At the 4th tier, there's a legal advisor, there's engineers with tertiary degrees. How did they miss this? And so I thought I needed an explanation. I didn't think that eThekwini should use taxpayers' monies to settle the applicant's bill. And so I called on the city, please tell the court who are the people involved. And then I got a list of names. And then I wrote another judgment and said, a directive to say, will each of these persons give an explanation for how it came about? The legal advisor gave an explanation and pleaded to whoever was prepared to listen that she had very little time to prepare this. There was a little error, but she doesn't tell me what the error is. But if they simply said, we messed up, we made a mistake, we are sorry, that would have been the end of the matter. There was no explanation, which is what disturbed me so deeply. And that's why I said, well, if there is no explanation, then I can't absolve you from costs. And so I distributed costs, half the costs equally among 16 people. And regrettably, I granted leave to appeal, but the city funded the application for leave to appeal. The net result of that judgment is that we have the city paying double costs and the officials are absolved. We don't know what happened, and it's not the first case of its kind.
Thank you very much. What do you say to those who feel that this intervention by the courts may have unintended consequences. Like, for instance, where officials may be afraid to take decisions for fear that they may be held personally liable at the end of the day. I'm not one of those, but I'm just raising it. Thanks.
Oh, well, I think you'll find my explanation in my judgment, because that's a countervailing consideration. You don't want to. People make mistakes. I mean, we're humans. In the ISE, we've made a couple of mistakes. So the thing is to own up, give an explanation, be bona fide, and nobody's going to impose a cost. It's a very high threshold to meet to impose a cost order on a public official. We're public officials.
Thank you very much. CJ, thanks, Judge.
Thank you, Honorable Klaver. Justice Pillay, I have a few questions for you too.
Yes, Chief Justice.
I noticed when Honorable Singh asked you, flowing from the comments that he read, whether you were a friend or a close acquaintance of Mr. Haneko and Minister Godam. You said, with respect to Mr. Haneko, no, I'm not his friend. And then with regard to Minister Godam, you said, do I know Mr. Godam? Yes, I know Mr. Godam. There is no way I could not know him. It was after Mr. Honorable Malema asked you in a more pointed way, again, whether you were friends, that you admitted friendship. Let me tell you where I'm going to. During the last interviews for the Constitutional Court that you attended, and while the JSC program was running, my office got a call from the office of Minister Rabin Godam seeking an appointment with me. And I was a bit surprised. We had never met except at the meeting of the heads of the arms of the state, where he had to brief us as Minister of Finance regarding the true state of the fiscus at the time, so that we embark on the cost-cutting measures that you might be aware we tried to introduce afterwards. He came, I took a break from the JSC proceedings, and I really don't know what the purpose of the meeting was. I don't have a clear recollection. I think there was something about the tax ombuds, but what stuck to my mind and left me puzzled was the following. He asked me a question. He said, how did my friend Daya Pillay perform? And we had just caused the spokespersons to announce the results, and I told him, because it was public knowledge, that you did not make it. And the thing has stayed with me. It got renewed as Honorable Sim read the question to you, as Honorable Malema engaged you, and said, why did the Honorable Minister make an effort to meet me? We are not friends. I don't know him from anywhere except from television. Why did he make a trip, seek an audience with me, just to ask me, how did my friend Daya Pillay perform? So it is in that context that the concern regarding your relationship with Honorable Minister Godam arises, and my concern regarding your initial response, which didn't seem to admit or acknowledge friendship, arises. Now, I'll put to you what others have probably put to you, so that you can deal with it and be satisfied that you've dealt with it. It doesn't have to be a long answer. Is it potentially compromising to judicial independence and impartiality for a minister or a senior politician to be keenly interested in the upward mobility, or to look like he or she is keenly interested in the upward mobility of a judge? And let me explain, I'm raising it because you remember there was an issue about friendship between a politician and a judge not so long ago. It seems to be an issue. That's why I want you to deal with it. Just in your own words, just deal with it as briefly as you can without compromising the quality of your answer.
Chief Justice, I wasn't aware of this interaction between you and Mr. Gordon, Minister Gordon.
I believe you.
Thank you. And from what you tell me, it seems as though the decision had already been made about my...
But he wasn't aware. But he wasn't aware that it was made.
Sorry, he wasn't aware, you say?
No, he wasn't.
Yes, but so my next question for clarification, Chief Justice, from what I gather you say is that he simply asked, how did my friend do? Did he say anything like you should appoint her or anything like that?
No, he didn't.
Okay, so I would imagine that it must have been in the course of whatever else he was doing with you, it came up as casual conversation. This was the gathering in Cape Town, if I recall.
That was the gathering in Cape Town, and as soon as he asked the question, I immediately gave him a response. He didn't make it.
And then, but that was a gathering I remember where my interview was supposed to be on the Tuesday, and I was phoned on the Monday morning after having celebrated Judge Thamba Pillai's 80th birthday, and I was hoping to recover from that on Monday and make my way to Cape Town, but I was interviewed that evening, late in the evening. So, but the reason for that, I understood, was that there was a big thing going on with the Minister of Justice, with the Minister of Finance, but there was something else that had to be, that compromised the JSC hearings, and we had to shrink it into the first day. But there was some other big thing happening that time. But so I'm assuming that he must have called you about that. I don't know what he called you about. And I know that Mr. Gordon would not promote me or any of his friends precisely because of his high profile and the fact that he would be accused of this. That's the extent to which I know. Whether he's, I certainly wouldn't rely on him to promote me at all. And as far as our relationship has been, our boundaries have been strictly observed. I can only imagine that he asked you in passing in relation to the other business. And I think he was disclosing to you that he was my friend, which is no secret.
Okay. Now, the next question is yesterday, and I think it's fair that the question be put to you as well. Our colleague, Judge Kolapen, was asked, given your age, if you were to be appointed, you won't be able to serve the full term. And that applies to you too, because you're only 7 months and 20 days younger than him. You will therefore, one, if appointed, qualify for a higher salary. Two, but then not serve at the full period of a constitutional court justice and retire with a higher salary in circumstances where another candidate who would have given us the full length of the period would thereby have benefited the state for a much longer period. I know it's a difficult and unfair question to ask, but let me ask it anyway. Given the financial challenges, the budgetary constraints under which our government operates, the state operates, does it accord with cost efficiency to, or is it cost effectiveness? Sometimes English escapes me. Does it accord with the commitment to manage our resources as parsimoniously as circumstances dictate? That you appoint somebody who's not going to give you the service for the full period recommended, have the person retire and get that higher salary for the rest of the life, is his or her life, in circumstances where another candidate would have served us for the full term.
Well, Chief Justice, you know, the applications have been delayed because I applied last year. You'd have got an extra year's service if I was appointed and this process had moved on. But I retire in 2 years otherwise. And I retire with full pay, which means that I will be minding my potatoes in my backyard earning a state salary, even if it is for less than the judge's salary by about 10,000-15,000 or whatever. But that's the one thing to think about. The other is the cost of effective dispute resolution. Now, I think Dan Glodlow, our colleague, gave the best answer to that question, the age question. He says a ripe lemon is much sweeter than a sour one. And to miss out on the experience that I bring, the possibilities of scholarship and rendering decisions that have a wider acceptance. So the cost of effective dispute resolution on the one hand, and the savings that you make of 15,000 per month or whatever it is must be balanced, and that's a decision that the Commission must make.
Now, the issue about attacks, your comments on the attacks on the judges, I think we need to go through that. One, you're aware that you and I and other judges discussed the issue of attacks against the judiciary. And I remember in your own comments saying, while we were discussing it, you can only succeed in giving airtime, undeserved airtime, to this kind of remarks if you're going to comment or respond as the judiciary. So I'm raising it because I heard you raise what I thought was a concern about the need for the leadership of the judiciary to protect the judges. Do you now think that it's necessary to respond, contrary to what you had earlier said to me and to other colleagues?
Absolutely not.
When we had, all right, okay.
Absolutely not.
And of course, the issue of allegations that you are on the CR17 list, which is something that has been said of a number of other colleagues that they are on the CR17 pay list, can only be resolved if the document that allegedly contains the names of people who were paid were to be made known to us. But for as long as we don't have access to that document, there is no way in which one can be able to say, but it's a lie. Judge so-and-so is not on that list. I have seen it. As long as we don't know what is on the list and you issue a public statement, what are you going to say? Are you going to say he or she is on the list or not? We don't know.
Yeah.
Is that not so?
Absolutely. Chief Justice, just to go back to your earlier point, there was a reason why we, as a collective, took the decision not to make a statement as a judiciary at that point in time. But earlier, in response to the attacks after the warrant of arrest order, the court did make a statement. Our DJP did issue a statement. So when I say that the question was asked, what should we do? And I was saying that the leadership, the judiciary needs to defend the institution. It was an observation and it wasn't a criticism. And I stand by the decision we took, and I won't say why. We took the decision we did, that there won't be a statement issued at that time. I fully endorse it.
And of course, you're aware that when judges in provincial divisions or specialist courts are attacked, it becomes the responsibility of the leader of that court to liaise with the spokesperson for the judiciary to craft the statement that could then be issued on behalf of the division, rather than the Chief Justice trying to get involved in everything as if there are no leaders, as if there are no competent leaders to handle such matters.
Well, that was exactly what was done. The DJP issued a statement.
Yes. Thank you very much, Justice Pillay.
Thank you very much, Chief Justice, Commissioners.
Again, I apologize to you that you are leaving much later than we had promised.
Oops, no chance of catching that flight, I suppose. Thank you very much.
Thank you. Thank you. Colleagues, while we are waiting, are we going to go through all the remaining candidates before we can break? Or is there another suggestion of a break before we complete their interviews?
A break if we may, please.
For how long? 10 minutes?
10, yeah. Yeah,
All
we
right.
need to walk around.
Say, Chief
Heavy
Justice.
things now.
Oh, no,
Yes.
No, it's fine. I forgot that we have company here. Well,
okay.
Yes, I'll
All
speak to Sil now.
Okay, thank
you.
you.
Chief Justice, the candidate is ready.
Thank you, JP. Good evening, Judge Unterhalter.
Good evening, Chief Justice.
I apologize to you that we kept you waiting until now. We're really sorry.
No, not at all.
Thank you. Are you well?
Yes, I'm very well. Thank you. Thank you very much.
All right. I have been giving almost all candidates, a long time to just brag. I won't be doing that to you and the next candidate. I'm going to try and shorten the interview without compromising the quality. And that is because of the threat of load shedding that is coming. Now, you studied at one of the finest universities in the world, am I wrong?
Yes, I did.
And you were a professor of law at Wits and a visiting professor at a number of prestigious universities around the world.
Yes, I was.
Please combine that with your well-known practice at the bar as junior counsel, as self who appeared regularly before the Constitutional Court and other courts, and your 3-year, just over 3-year experience as a judge of the High Court, but who has also acted at the Supreme Court of Appeal to make a case for your appointability to the Constitutional Court.
Yes, thank you, Chief Justice.
In other words, just brag. Feel free to brag.
Well, I'll try and be brief. I started at the bar in 1990, which was at the very outset of our constitutional odyssey through to a democratic and free society. And early on in my practice, constitutional law became an important part of my practice. And so I've had the privilege of practicing in the Constitutional Court really from the earliest part of this court's development. And I have appeared and been lucky enough to appear in many, many cases over the years, over a 27-year period of my practice. And so I have obviously both an enormous respect and an enormous affection for the institution of the Constitutional Court. I should say that when the court came into being, there were many skeptics in the legal profession about the Constitution and about the Constitutional Court. And I think one of the things that marks out the success of the court is that that skepticism is now entirely absent. The Constitution is a living document. It is our basic social compact. Its values are foundational, and it infuses every part of the legal system. And that in no small part is due to the leadership of the Constitutional Court. I think the Constitutional Court, therefore, is a crucial body within our legal system. It's an apex court not simply because of the position it occupies in the court hierarchy, but because of the authority with which it speaks. And that is the important part of what I would want to make a contribution to. So the first thing is that I have had long experience as an advocate in the court in its various developments over many, many years. The second thing I would want to say about my practice at the bar is that it varied over quite large ranges of law. I have practiced in public law, in constitutional law, in commercial law, in specialized regulatory areas of law, as well as in international trade. And although no one can know the full range of the law because it is so expansive, I've certainly had a good deal of experience in many areas of the law. I would just also want to emphasize one other feature of my practice at the bar, and then I'll come on to my time on the bench. And that is that I have, from the very start, considered that it's both the duty and gift of practitioners to be able to act pro bono in matters of public interest that are of importance. And the model for me of how law can make a difference in the society was one that I grew up with. My father was an advocate at the bar at the height of apartheid. And it was during those times when relatively few practitioners devoted time and attention to what could be done, sometimes modest as it was, for the dispossessed during apartheid times. And so I've always considered that one must look to law as a means not just of having a good profession and an interesting and varied one, but one that can serve important principles and redeem the constitutional values that are embedded in our Constitution. And so during the 90s, for example, I was involved in a number of pro bono cases where we used the mechanisms of, funnily enough, company law and the unbundling of GenCore and KWV to use these mechanisms to explain that there were liabilities to workers in respect of asbestosis and other liabilities of this kind. And we secured very, very large settlements running into hundreds of millions of rand, which at the time was an enormous sum of money. And that was part of the process of, as it were, giving back. I have always, throughout my career, sought to give back. I've done it through academia. I've sought to do it in public interest work, pro bono, through the courts. That is something I spent a good deal of time on in the last 10 years before I went to the bench, when various critical aspects of the rule of law were being litigated through the courts. And so I do consider that law has a value for the purposes of redeeming the important principles and compact which constitutes our founding document, the Constitution. And I do think that public service is a vitally important aspect of that. I decided after a long period at the bar and much time spent there, obviously, to have a change of direction and think about public service in a different way. And it's then that I came and offered myself for judicial appointment, and the JSC was good enough to consider me qualified to do so. And I have now spent something over 3 years on the bench. During that time, I've had a very full exposure to all the work that is done in the High Court. It's, again, very varied and important learning experiences are to be had there. I've also had the privilege of acting in an acting capacity in the Competition Appeal Court, as also now for my third term, and again I will do so for a further term, in the Supreme Court of Appeal. There's much to learn, and I have learned much during that period. And I would hope to bring that cumulative professional experience at the bar, as also the time that I've now spent on the bench, to account. I should just mention one last thing, which is that in the course of my time in the law, I was also very fortunate to be nominated by South Africa to be a candidate for consideration on the appellate body of the World Trade Organization, which is a world court that deals with international trade. And I served there for nearly 8 years and served as 2 years as the head of that court. And that's a court that is an appellate court that deals with large trade disputes between countries, member countries of the WTO. And so I do feel that I have had a fairly large exposure to appellate processes in different courts. And it's for this reason that I would see whether I can be of value in the Constitutional Court, a court which, as I've explained, is a court that I have a very special tie to, and something where ultimately that court renews in every single period what the Constitution means, what its values are, and how they should be put into practice in terms of the kinds of legal challenges that we face. I think it's a court we must feel extremely ambitious about as to what it can achieve and the repute that it has. It is, I think, a court that is very well regarded internationally. It has commanded great respect within the country, and it's that tradition of respect and authority that I should want to make a contribution to, if I possibly can.
Thank you very much. And if anybody were to seek to on the basis court, what additional input would you make in response to that question?
Chief Justice, I'm sorry we're having problems. We can hardly hear you.
What else would you want to raise to counter?
Chief Justice, we can't hear you at
Yes, sir. You can't hear me?
I'm sorry, Chief Justice. No, the connection, I'm afraid, is not very clear.
Even now?
Yes, it's much better. I'm afraid I didn't hear the question at all.
I'll repeat the question. If anybody were to seek to criticize or to attack your suitability for elevation to the Constitutional Court, based purely on the fact that you've been a High Court judge for 3 years, what additional response do you think would you want to make over and above what you have said already to address that challenge?
Yes, I would only emphasize this, that although I've been a High Court judge for 3 years, although nearly one of those years has been spent acting in Supreme Court of Appeal, I was sitting on an appellate court for some nearly 8 years. And I think cumulatively, if you take that together, it's a fairly long judicial career with significant exposure to appellate work. And although I haven't had the privilege of acting in the Constitutional Court, I think cumulatively I'm reasonably well positioned to have had a breadth of experience, both in law more generally, but in appellate work in particular, that I might be able to be of some value to the Constitutional Court.
Thank you. Colleagues, any names?
Sigogo.
Akwanisha.
Lamola.
Tepe.
Schlemmer.
Matonsela. Pofu.
Matolo Dlepo.
Malema. Malema.
Aba.
Deputy President Pets.
I'm not coping. I'm not coping. After Minister, it's Commissioner Tsepe, okay. No, please. I'm not coping now.
Chief Justice, we're back to square one. Yes, we can hardly hear you now. It's better now.
Yeah. All right. After the minister is Commissioner Tsepe, Prof. Commissioner Madonsela. I have DP Pete. Who else?
Nyambi. Chief Justice. CJ, can you hear us?
I can.
Yes.
Very clear.
I came after Madonsela.
Okay.
Then Nyambi after Mpofu. And then Nyambi, yeah.
CJ, Matolo Dlepo, I don't think you captured that.
I had not, but I remember you indicated yes. Okay.
Breitenbach, Chief Justice.
I have you, Honorable Breitenbach.
Thank you, sir.
And then in now.
Who else? Sorry, who else? Malema. Honorable Malema, are you there too?
Limuimang, Chief Justice.
Thank you.
Deputy President Petse.
I've got you here, DP.
Thank you, Chief Justice.
Thank you.
Do you have my name, Chief Justice Kaba?
Okay, okay. I didn't have your name on the report. Thank you. Commissioner Sigogo?
Thank you, Chief Justice. Good evening, Judge Aoyo.
Good evening.
There are comments from law bodies, and I'm quite sure that you saw the comment from the Black Lives Association.
Yes, I did.
And in response to that, you withdrew or you resigned
Yes.
from the South African Board of Deputies.
Yes.
So, but the comment of the Black Lives Association in that regard went further and indicated that his affiliation as defined above might even go as far as to put into question his sense of justice.
Yes.
I want you to talk to that, taking into account the views we have as the country in respect of the relationship between Palestine and Israel.
Yes, well, let me firstly explain what the Jewish Board of Deputies is, and then I'll explain why I resigned responsively to what the Black Lawyers Association had to say. I was asked in the course of last year, when we were in the middle of a pandemic, to come onto the board. You should understand that the Jewish Board of Deputies is concerned with the welfare of the Jewish community. And by welfare, it is concerned with old age homes, burial societies. It's concerned with people who've fallen on hard times more generally, but particularly now in the pandemic, and assisting other communities where there is need and hardship. So the Jewish Board of Deputies is a community organization concerned with Jewish welfare and the welfare of other communities within the country. And its other concern is about anti-Semitism and preventing anti-Semitism. It is not a body that is concerned to promote Zionism. The Jewish Board of Deputies is a body that has existed for well in excess of 100 years, and indeed its precursor organizations for many, many decades before that. And so I went on to it because it seemed to me to be about assisting, to the extent I could, with welfare issues for communities in sometimes very dire need. And I don't therefore think that it is concerned with to promote Zionism. There are other organizations that do so, but I have no affiliation or connection to them. But I did think that when the Black Lawyers Association raised the point, they'd raised an issue which I did need to think about, and it's this, that from time to time, the Jewish Board of Deputies engages in litigation against hate speech concerning anti-Semitism. And on occasion, those matters have even gone to the Constitutional Court. And it did seem to me that in those circumstances, if I was going to offer myself as a candidate for judicial office in the Constitutional Court, it would be appropriate to step away from that organization because it does have this role. And whatever I might have been able to do by way of assisting welfare efforts in a time of great need must perhaps yield to the perception that one shouldn't be connected to a body that is engaged in litigation. So I did step down, and I've circulated my letter of resignation, but I don't think that my connection in accepting a position with the Jewish Board of Deputies is one that impacts and is connected to Israel and the Palestinian and Israeli conflict, which is an entirely separate matter.
If that is the position, why then did you resign before you could hear the outcome of these interviews? Because if it is a welfare organization and which you resigned because you don't want to be sitting at the Constitutional Court if and when they litigate, why wouldn't you wait for your appointment and do that? And if the concerns of BLA were of no concern to you regarding Zionism?
Well, As I say, I don't say that the BLA's concerns were of no concern to me. They were concerned to me for a reason different from the one that the BLA raised. And I did so in stepping down because it seemed to me that whether I'm ultimately recommended for office in the Constitutional Court or not, the question of a body that does litigate over questions of anti-Semitism and hate speech and the like, perhaps it would be better for a judge not to be part of that organization, whether on the Constitutional Court or otherwise. I mean, obviously, one could always recuse oneself and the like, but perceptions sometimes matter. And I think once the issue was raised, I gave it thought, and that seemed to me to be ultimately the wisest position to take.
CJ, if you may allow me, when CJ indicated to you that you may indicate where you come from, including bragging, one of the things that you said and agreed with the CJ is that you went to one of the finest universities in the world.
Yes.
I want you to assure us if that does not go with white privilege, that you are able to be in that position, and how will that assist the communities that you are going to adjudicate if you go to the Constitutional Court?
I think it's indisputable that I had privilege and that was connected to a state of affairs in this country where white people were advantaged at the great expense of the great majority of people without any question whatsoever. I think the fundamental issue is, what do you do with the privileges that you've had? Do you seek to give back? Do you seek to use such advantages as you've had to try and build a better society than the one that certainly I grew up in? Or do you simply luxuriate in your privilege and simply parade it to no advantage other than your own? I take the former position, and that's what I've tried to do.
Finally,
Commissioner, you remember we have the power outage challenge and to speak to questions.
Yeah, CJ, I can forego this. I believe other commissioners will cover it. Thank you.
Thank you, sir. Thank you very much. Honorable Magwanisha.
Thank you very much, CJ, and good evening, Judge. In the interest of time, I only have one question. How many African lawyers and women in particular did you empower in the area of trade law when you were still practicing as an advocate, especially as a senior counsel? And in what specific way did you empower them?
Well, I can't say that in respect of trade law, I did terribly much by way of practice in South Africa. Most of my work in international trade was done outside of the country. But I certainly can say with absolute assurance that in my practice as a whole, I have worked extensively with Black counsel and with women. And there are many leading Black counsel today who were juniors with me over many, many years. And it's a source of great pride that I have, that we work together in such a collaborative way that I have made some contribution to the development of their practices. So trade law is not an area that I have done much practice in. I can say, however, though, that throughout my period of time in practice, I taught at first at the University of the Witwatersrand and thereafter at the University of Cape Town. And there are generations of students who passed through my classes, both in competition law and trade law, significant numbers of whom are black and women, and some of whom have gone on to significant achievements in the field.
Judge, you did receive quite a few cases from the Department of Trade and Industry on
Yes.
the area. That is why I'm asking this specific question.
Yes. I think that's absolutely correct. That there were, I think I got really my first break in trade law, frankly, when an assistant to the Director General briefed me in quite a big case called Brenco. And my junior in that case was a woman, Janet Kentridge, who no longer practices in South Africa. But we worked together on that case, and that was my first introduction to trade law. Thereafter, I worked not terribly much with juniors, but certainly with attorneys, where black people, black lawyers constituted part of the team. And we worked very closely together. So although it's true that the greater amount of my work in trade law was probably done outside of the country rather than in it, even the work that I did do here had significant involvements of black lawyers with me.
Thank you very much, Chief Justice, and thank you, Judge.
Thank you, Honorable Magwanishe. Honorable Minister.
Yeah, thank you very much, CJ and Judge. On this question from Councillor Skogo, don't you think that your affiliation or being a former or ex-leader of the Jewish Board of Deputies may raise these possibilities of bias when issues related to the state of Israel or Palestine arise in our court?
Minister, I don't think so. And I don't think so for the reason I've already given, which is that the Jewish community, which has been long established in this country for centuries in different forms, it's made up of people with very, very different attitudes to the state of Israel and indeed to the state of the conflict between Israel and Palestine. So there's nothing about being on the Jewish Board of Deputies which would lead, in my view, to a perception that I would have any bias in favor of Israel in respect of a legal issue that might arise in a case that somehow trenched upon the conflict that exists in that part of the world. But if a case were brought and it could be shown that somehow or another my position for, I don't know what it has been, 9 months, I suppose, on the Jewish Board of Deputies somehow or another is implicated in the litigation, then as with any other case, I would look at the merits and have to decide whether I should recuse myself. But I can't see, given what the Jewish Board of Deputies does and what its constitution requires it to do, that there is any linkage to the Israeli-Palestinian conflict.
Yeah. On your role, Judge, as in the appellate body of the World Trade Organization,
yes,
are you able to tell us judgments that you believe contributed in terms of developing for the developing world, given the situation we currently face in the world, where we're speaking about the vaccine nationalism and the role of that body for the distribution of the vaccine and various medication and IPs? Do you think that experience, or there's any role you think you played in that court, or that experience will be helpful for you in our court?
I do think so. One of the key features of the WTO system.
Yeah, maybe on the same question will be, last one on that one will be, do you also think that we may need the same kind of arrangement, given that we now have the Africa Free Trade Agreement?
Yes.
Yeah.
Well, let me answer both questions in one go. The key feature of the World Trade Organization is that it is an organization of rules. And the importance of those rules means that smaller countries, mid-sized economies and smaller, can have the benefit of those rules, which are of general application to all members. It's a feature of international rule of law, which can be extremely advantageous to developing countries because they have remedies in their trade relationships with much larger economies that allow for outcomes that can be highly advantageous to their ability to engage in trade across the world. And among the happy features of what I observed when I was deciding cases with colleagues on the appellate body is the effectiveness of many developing countries in utilizing the WTO system to their economic advantage. So countries, for example, like Brazil and countries like Mexico and China used the system in order to pursue their trade interests through a body of rules that was enforceable at an international level with sanctions that could follow upon breaches of the rules. So I think that I not only learned the value of a rule-based order, which sometimes can exist nationally, but in this instance existed and exists supranationally, but also the opportunities that it entails for developing countries in seeking to pursue their interests through bodies like the WTO. To come to your second question, one of the features that I would suggest is that there is a very close relationship between the building of an African trade community, which is a great and important experiment that we are about to begin that journey in Africa. Because one of the key features of many of our economic relationships is that they still bear the imprint of colonial trade relationships. Many African economies have stronger economic relationships with their erstwhile colonial masters than they do as far as intercontinental trade is concerned, and that needs to be redressed. And that's partly what building the African community is intended to do. It's an ambitious and hugely important project, but it needs to fit together with a global system as well. Because although it can facilitate trade as between members within Africa, African countries, our own included, have very important trade connections which remain with the rest of the world as well. And so it doesn't suffice to simply improve trade across the continent between African countries. One needs to get access across the world. And these two things are interconnected. They're not either or situations. And just to touch on lastly, the question of what vaccine nationalism illustrates for us. It shows how in situations of emergency, countries often go back to their national interest for perhaps understandable reasons. But it pinpoints the fact that at so many levels, interconnection between countries matters critically to advancing their economic and social, and indeed in this case, health interests. And sometimes that requires cooperation, and sometimes it requires even litigation around, for example, intellectual property rights, and where there may or may not need to be waivers under the relevant trade agreements that exist. So these interests are critical, they impact on countries, and I think my short answer, Minister, is to say we need to be an important player both in the African community but also in the global community.
With your indulgence, CJ, I request to ask one last question.
Go ahead, Minister.
Yeah, given the wide privilege you spoke about earlier, that indeed you have been privileged in this country, do you think it will be fair to appoint you to the Court when you have never acted in that court? And there are Black practitioners who have been judges of the Supreme Court of Appeal for many years than you, and also the High Court, and some of them have also acted at the Concord. And most of it was almost a sacrifice. Will it be fair that you were still busy with practice, and I would assume you'll have also made lots of money through your practice?
Well, I think it's less a question of fairness and more a question for this body to work out how I might be of assistance in serving the Constitutional Court. People come to sit in the position I do here before you through different pathways. Not everyone pursues them in exactly the same way. I, of course, accept that it would be useful to have acted in the Constitutional Court, but one can't do absolutely everything in every dimension over one lifetime and still say that you tick every single box for every single purpose. As I sought to indicate, I didn't just spend time at the bar having a lucrative career. I devoted time and attention to other things that I think gave back. And as I say, I spent 8 years on the appellate body, which is in service to, I think, a concept of the international rule of law. And so I accept that, you know, I could have gone a different route. I could have gone to the bench earlier, perhaps, and not gone to the WTO. And that might have put me in a position to have had the privilege of acting in the Constitutional Court. As I say, I think ultimately it's for you to decide whether the experience that I've had and the attributes that you may think that I can lend to the efforts of the court are ones that are useful to the court. I don't think it's simply a question of who has gone through a singular set of experiences to be of greatest help in constituting the court. And I would just make one last observation, which is that the strongest courts are courts that harness the best talents of the country. At the end of the day, as I've sought to indicate, we want to be ambitious about the Constitutional Court. We want it not just to reflect the country, which the Constitution requires, but also to harness the talents and energies of our best lawyers so that it can be an authoritative court of great repute. If I can be of some assistance in that project, that's the only basis I offer myself to you.
Thank you, CJ.
Thank you, Minister. Commissioner Tsepe.
Thank you, CJ. I have two questions for Justice Unterhalter. Good evening, Justice Unterhalter.
Good evening.
Welcome. Justice Unterhalter, as you know, the Constitution requires courts when interpreting any legislation, when developing the common law and customary law, to promote the spirit, purport, and object of the Bill of Rights. What has been your experience in specialist courts or when dealing with commercial matters to the observance by judges of this constitutional obligation? And if you could point to cases that you wrote that reflects your observance of this important constitutional obligation.
Yes, I think that by and large, it is well appreciated in the courts that the supremacy of the Constitution requires that it's the rights that are recognized under the Constitution and ultimately its values are the bedrock of our legal system and are pervasive. How that then works in terms of interpretive problems that come before the courts can play itself out in different ways. But I do think that it's clear that courts understand this question of supremacy, and they do understand that although many lawyers schooled in the common law as it has existed pre the Constitution need to think again about how the common law is to be understood and conceptualized in the light of the clear constitutional injunction that takes place. Now, that is a process of steady development. It's not something that is just announced overnight, but I do think that in all courts, there is a very clear recognition of this. Let me illustrate a case that I was involved in where I paid particular attention to this problem. There was a case that was brought by an applicant who came to court to say that certain banks had been involved in collusive trading on certain commodity exchanges in Chicago in the United States. And they had been sanctioned by the authorities in the United States. And the contention that was made in that case, I've cited it for you, called a SHUCO, was whether that did not infringe the right to food security in South Africa, because some of these future transactions in commodities, including maize, which is a staple product, could impact upon food security in South Africa. And the first question that arose in that case was, did a South African court have any jurisdiction over a regulatory violation that had occurred in the United States in respect of trading on the Chicago futures exchanges? And in the case, you'll see that I took the view that if it is the case that a wrong that is committed outside of the country, which has effects in the country that are potential violations of the Constitution, then that is jurisdictionally competent for a South African court to entertain. And in taking that objective conception of jurisdiction, I did so under the guidance of the reach that our Constitution is meant to have. I could have taken a different view, a much more restrictive view, and said, that's for America. The US courts and regulatory authorities have determined that matter. We shouldn't go anywhere near this case. But I allowed for the possibility that we could. I found ultimately on the facts that there wasn't an effect of the kind that was complained about, but the jurisdictional perspective was an expansive one, guided by the values of the Constitution.
Thank you, Justice Unterholter. Just to my second question. The Constitutional Court has, in a number of its cases, in my view, competently dealt with matters of international trade and competition law, which are some of the areas in which you have expertise. Should the Commission view your expertise in these areas as a distinct advantage in considering your application in view of its competence in dealing with some of these matters, or how it has dealt with these matters in the past?
Well, it does appear to be the case that a not insignificant number of competition law cases are finding their way to the Constitutional Court from the Competition Appeal Court. And for that reason, I think it might be advantageous to have on the Constitutional Court someone who has spent a lot of time in the field. The Constitutional Court has dealt with these cases, and some of them are I think, difficult cases. But I think it might be of some assistance to allow a judge who has had some background in this area to be on the court. And similarly with international trade, these are relatively abstruse areas, perhaps not so much competition law nowadays, but certainly international trade. And international economic law as a more general area is one that I would certainly have some experience in, and it could be of some assistance to enrich the court. As I've said already, the importance of the court is that it harnesses many talents from many quarters. No one has a monopoly on all of those talents. There are some things that I hope I could bring to some advantage for the assistance of the court, if I were appointed.
Thank you, Chief Justice. Thank you, Judge Unterholt.
Thank you, Commissioner Tsepe. Thank you, Prof.
Thank you, Chief Justice. Good evening,
Good evening.
Judge Unterhalter. I must perhaps say that I know Judge Unterhalter. We've worked together at WITS in international trade law. He sometimes gives guest lectures also to the students still. Judge Unterhalter, what I would like to know from you is, as academics, we've noted over the many years that the depth of judgments, the scholarliness of judgments have kind of deteriorated. And in a system of law which is uncodified, this is quite alarming. What is your take on the matter?
Well, I think one has to understand how judgments come about. Almost every court is under huge pressure, and not every case can result in an account of the law that certainly from the perspective of academics would be thought of as rigorous in every single way. Speaking for myself, what I like to do is to look when there's a case that seems to have specific novelty or complexity, to take the time to research the sources, look carefully at the arguments that have been made. One does that in every case, but to try to invest the judgment with, perhaps you might not say scholarly insights, but at least with a consciousness of the gravity and complexity sometimes that cases throw up. So I think the criticism is in part correct and in part not correct. The part that I think one needs to understand and give some latitude about is that the system just doesn't permit every judgment to be scholarly in its approach, but it must be effective, it must be well reasoned, and it must speak to the parties and the issues that they've brought. But there are occasions where we do want our case law to be reflective of judgments which, from an academic perspective, it causes academics to say this is a judgment of great interest. Whether they agree with it or not is a separate question. I think we still produce those judgments. I think the only issue we may have is whether we produce enough of them. And I think that is partly a function of the volume of cases and the pressure of judgment, of getting out judgments. It's a huge priority that the litigants who bring the cases are entitled to not just a well-reasoned and carefully thought through judgment, but to an answer that comes relatively quickly. And one has to balance these things up. So I think your point is well made, but I have obviously a huge respect and regard for academia and the academy and what it does. I just hope that the diet is not too thin for the academic endeavors that academic lawyers engage in. I don't think it is, but perhaps it could be a little richer.
Thank you, CJ.
Thank you, Prof. Commissioner Madonsela.
Thank you, Chief Justice. Good evening, Judge Unterhalter.
Good evening.
The first question that I would like to ask you has a premise, and please, when you answer the question, correct me if I'm wrong in the premise upon which I based my question. I understand the role of a appellate court, amongst other things, to be to afford litigants a broad spectrum of minds to consider the matter brought before it from a lower court, so that litigants have a benefit of many people thinking about the matter and making a decision on the matter over and above the decision of a lower court or lower courts. Now, from that premise, it seems to me that the idea of a specialized judge who knows a particular aspect of the law and does not have a particular age or particular knowledge or experience in another field of law may have an effect of depriving litigants of the many minds that are required in an apex code. I make this proposition to you because it seems to me that you do not have an experience in criminal law, amongst other things. And the tendency is that in the appellate court, we'll have specialized judges in a particular field. And what will happen in practice is that when a matter of, in your case, international trade comes to a court, the other judges are simply going to dump it on the judge who has got a specialized knowledge. And the litigants don't have the benefit of all the other judges exercising their mind in that particular field of law. Isn't that problematic with the application in the sense that you do not have that broad experience in particular, as you may have confessed, in criminal law?
Well, let me say firstly that I agree with the premise of your question. I do think, as I've already sought to stress, that appellate courts, and particularly the Constitutional Court, needs to draw on many talents to constitute it as a court of authority and one that is widely respected. Where we may part company is that I don't think it follows from the fact that some people appointed to an appellate court have had deeper experiences in some areas than in others, that there's any kind of deference in the appellate court that is shown in terms of how to decide a case and what the right answer to a case is. Obviously, there is some guidance to be had because the experience of someone who has a deep knowledge of one area of the law can be of assistance to colleagues in thinking about the problem. But ultimately, if you have, as you do, independently minded, robust, extremely talented lawyers who constitute an appellate court, then they're applying their minds, and all that having people with some specialized experience in certain areas does is that it can enrich the dialogue that takes place in those areas. So I'm not certain that you get any kind of deference that is shown. It's simply a question of the mix of attributes and how that can enrich the thinking of the court and the way it goes about its business. As to my own experience, I don't believe that there is any candidate who has come before you in the last 2 days who is deeply experienced in every single area of the law.
There is.
Well, then I've mistaken who they are. The fact of the matter is that people have come through to the courts in different ways, and their experience in practice and thereafter on the bench will be varied as to what they've experienced and where their competence lies in respect of particular areas. So I would acknowledge to you that my practice at the bar didn't involve much by way of criminal law. That's absolutely true. It did involve quite significant areas of public law and private law and regulatory law in different permutations. And obviously those are things that I will bring to bear. So I think that's the best way I think I can explain to you how both appellate jurisdictions work and appellate courts work and should work, and my sense as to the kinds of different contributions that different lawyers can make as judges and as appellate judges.
Yes. Focusing on the area of public law and constitutional law for a moment, is it not correct that in the past 25 years, 26 years, since the new constitution or democracy, the advent of democracy in the country was had, the constitutional courts in different eras has produced a body of jurisprudence that it has somewhat stabilized the legal principles applicable in established some concrete principles of constitutionalism from which future courts can look at and draw wisdom from. Now, I want to ask you a question from that premise, that am I correct in saying that is it your view that future constitutional courts will be bound by the principle of stare decisis, doctrine of precedent, in the sense that they will be bound by the decisions that have been made by the courts before it? Or are you of the view that the future constitutional courts have a free hand to depart from the precedent that has already been established by previous courts and develop new principles and deviate from the rules and principles that have been established thus far? I ask this because in the context of this fact, you have appeared in that court in a manner that I would say you have actually dominated appearances in the Constitutional Court. You have had so many. I couldn't count on how many cases you have appeared in that court. And are you of the view that there are any matters that the Constitutional Court have not traversed yet, which remain open questions, which might require some form of development? Or some of the submissions that you have made in your arguments which were not embraced by the previous courts, which you think should be revisited in future courts? I want to hear on those matters.
Yes. Well, let me respond in with a few points. The first is that, of course, every court stands on the shoulders of those who've come before. And in the case of the Constitutional Court, we have been enormously fortunate that we have had some giants in that court. The court has generated a jurisprudence of very significant both breadth and depth. I don't think, though, that the question of how our constitutional law develops is one where one says, well, in the first 25 years, you get all the big and important principles settled, and thereafter, courts that follow just fill in the fine details. It's a feature of significant constitutional courts across the world that every single court is faced with remarkably important and often novel points that arise for determination. And this body is facing in the course of this year 4-5 appointments to the court, which will have hugely significant impacts upon who will constitute the Constitutional Court for the next 10 years and more. So I think that it's not a question of simply, as it were, taking settled principles and simply applying them in a fine-grained way. And that might be illustrated, for example, in relation to the debates that have opened up around how the Constitution should be understood in relation to the law of contract. What is the role of freedom of contract, which was the value that so dominated pre-constitutional thinking around contract, and how are constitutionally based doctrines of fairness and the like going to figure in the development of contract law? Now, we've had some recent cases from the Constitutional Court, but I don't suppose for a minute that that jurisprudence is finalized and settled at all. In fact, the debate is just opening up, and I suspect we're going to have many, many cases which seek to develop that area of law. And I could talk about others where I think the field is very much open. Let me answer your question on stare decisis. In US law, it is sometimes said that there's something called a super precedent. And then there are apparently other kinds of precedents. And I don't happen to believe in a hierarchy of precedents at all. The Constitutional Court, however, is uniquely positioned because unlike lower courts within the hierarchy that are bound by the decisions of the Constitutional Court. The Constitutional Court can, like every apex court in every legal system that follows stare decisis, consider revision of its decisions. But it does so with enormous care and only usually in the face of clear error. What happens more frequently, I think, if one looks at jurisprudential history, is that very few apex courts announce a complete revision. Usually it is done by stages and degrees, but it has to be recognized that, like every doctrine, stare decisis, at least in the Constitutional Court, is a constitutional doctrine that goes to the nature of that court and its powers. And that power does include the power to change its mind. It should be exercised very carefully and very cautiously, because people look to the definitive decisions of the Constitutional Court and rely upon them for ordering their affairs. But it is possible. And that's partly why sometimes the threads of authority that you see in concurring judgments and the like have different emphasis. And sometimes one thread turns out to be more important than another.
I wish I could ask you some questions, but I think we've got limits of time.
Indeed.
Unless if the Chief Justice.
Commissioner Madonsela, at the rate we are going, we are unlikely to interview the next candidate. At the rate we are going.
No,
Commissioner Mpofu.
Thank you, Chief Justice. Good evening.
Good evening.
David. Sorry.
Good
Judge.
evening, Commissioner.
Sorry. Yes, because of time, I'll try. I know you'll be capable of doing what I'm about to ask you. I'm going to fuse my question into one statement, but to which I'd like you to react, and then I'll go to the next one. The first issue is about this. I think there are two issues that have been raised with you where I'd like you to give more clarity. The one is the issue of the South African Jewish Board of Deputies. Now, like Commissioner Sigogo, when I read the evolution of the BLA complaint and your resignation and so on, I was left with the question of, well, if there was nothing wrong with this, then why did you resign? And you've answered that question. My issue with this is that it's more a question of principle, which has to do with the connection. I don't know if you accept, you may or may not accept that there's a connection, at least there's a connection that is made between Zionism and apartheid in many contexts, both as forms of nationalism and so on. You know, I'm sure you're familiar with that debate here. Now, the question really is whether the impression that I have that the Jewish Board of Deputies might not be, by definition, a Zionist organization. I don't know if it is, but that it's not against Zionism, or there's some affinity or close relationship between the two organizations. And if that is so, if that premise is correct, and you'll tell me if it is not, then my view would be that just as anybody who has any association with apartheid cannot at the same time believe in a constitution that espouses equality, that's obvious. So if that connection is therefore correct, can the same be said about an organization that has some relationship with Zionism being, by definition, inherently irreconcilable with the notion of equality between people? You understand the question?
I understand the question completely, yes. I would simply answer on that score that I never went on to the Jewish Board of Deputies in any understanding that it was connected to Zionism or an advocate for it. The Jewish community, like many communities, is made up of people with radically different views about Israel and the Israeli-Palestinian debate, and indeed whether there is, as you know, a great debate about Zionism and the Israeli state being an agent of something akin to apartheid. I mean, that's a debate.
Yeah.
Because members of the Jewish community are so varied in their views across the board on this point, I would have been very uncomfortable to be in an organization that took some particular position on that issue. And so I was invited to join, as I've said, at a time of some crisis for many communities. And my role, as I understood it, was to see if I could help in any way with the basic role that the Jewish board plays, which is to look after the wealthy of people who've lost sometimes their lives and sometimes their livelihoods, and the connection that it has to other communities where similar problems arise. I saw it as being able to do something for welfare. And I just, as I say, that the Jewish Board of Deputies has a history that goes back. The current board, as I recall, goes back to about 1913 or 1912. But the members that constituted at a national level after union go back probably a century before, long before Israel was even conceived of as a country. So I think it has a limited focus, and it was with that in mind that I accepted the position that I did.
Okay, thanks. Yeah, well, for the record, yeah, I mean, I'm not one of those people who equate Jewishness per se with Zionism, because I think that in itself is a form of discrimination. It's like stereotyping people, which is unfair. But my focus is really on the organization, because
Yes,
I
I
think there's
understand.
an organizational link between the Jewish Board of Deputies and their views in general. But anyway, let's put that aside. The second issue that has been raised with you, and I'm sure it's one that you were expecting, particularly because for the new commissioners, you know that when we last had you here, one of the issues we raised was whether you're not coming to get an interview just as a conduit to greater heights, so to speak. And because you have now applied after 3 years of appointment to the Constitutional Court, I think it's only fair that you have to answer that question, whether that doesn't confirm that view or suspicion at that time, and so that that can be put to bed. Now, that's tied to the question of you accept, you know, you were asked about white privilege and you spoke about it in the past. You do accept, I know you do, that those issues, white privilege, apartheid, and racism are not things of the past. They are things that are still with us. Now, given all those the privilege that you had, and it's not through a fault of your own, you are a white male privileged previously and currently person. You have the issue of having been only on the bench for 3 years. You've never acted in the Constitutional Court and so on. Now, and you know this is a competition in the end.
Of course.
If then we have to balance the virtues that the Chief Justice asked you about, which you would bring to the Constitutional Court, versus these other disadvantages. And if I said to you, okay, now I've got you and these other candidates, I really have to choose one, what would you say in your favor to convince me that I should overlook the appearances of these factors weighing against you?
Yes, so as I've already indicated, there are only so many things you can do in a lifetime.
Yeah.
It's a difficult thing to say, well, of course you've got the attribute of X because you've spent a lot of time, for example, sitting on the appellate body of the World Trade Organization, but you haven't yet sat in the Constitutional Court. One could reverse that and say, well, yes, that may be true, but what one is looking for at the end of the day, I think, is not a sort of checklist where you can say, well, you've got to have done that, or if you don't pass through that, if you can't tick that box, then you can't go any further. It's not my understanding that, as I think your question indicates, that's not really the issues that you have before you. I think the issue that you have before you is, let me look at what attributes different candidates have. People, you've heard now for a long time, all the things that people can bring to the table before you. You will need and want to think about how are those talents which you've had extensively explored before you, and you will still, perhaps tonight, perhaps tomorrow, how can those talents best be applied to the betterment of the institution, which is the Constitutional Court? I'm afraid I can't give you a metric as to how to do that. I think every candidate has strengths, and every candidate has some things that are, if they're not weaknesses, they're things that they haven't got to for whatever reason. I think at the end of the day, this is about public service. It's about, I will continue to serve in whatever role I can. If it were to be on the Constitutional Court, ultimately, it would be an enormous privilege for me to do so. But if you don't think collectively, ultimately, that that's where I can best be of service, well, that will be your fair consideration. I'm not sure I can take it further than that. There isn't some fine metric where I can say to you, well, it was those last 5 years at the bar that made up for the fact that I didn't have a term in the Constitutional Court. Because when you put those in the balance, the 50 cases that were argued over that period of time weigh more heavily than the term in the... That's not a balance I think anyone can make. One just stands back from it and says, well, let me look at this overall. Let me see how I think this court can be benefited. And then I'm afraid that's your difficult task, not mine.
No, thanks. I appreciate that. And is in part of the answer the fact that we have to look at the package of what we want to achieve in the Constitutional Court, rather than maybe just looking at you as an individual who might have these other disadvantages. In other words, as part of a whole, in a kind of dynamic sense, rather than just, because if you look at individually and you put these factors, then obviously the disadvantages, in my view, would outweigh, particularly compared to the other candidates. Yeah.
I would respectfully completely agree with you. It's an aggregative question as to harnessing the talents that we have available to make this court
itself,
to make the court the best court it can possibly be. And as I've said, I think that we must have great ambitions about this court.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner Mpofu. Deputy President.
Thank you, Chief Justice. Good evening, my brother on the halter.
Good evening, Deputy President.
Due to the lateness of the hour, I'll be shorter than brevity. I've one observation to make, Judge Unterholter. During your interview in October 2017, one of the commissioners described you as an eminent counsel. And speaking for myself, your record speaks for itself. Your scholarship, forensic skills, and how well you articulate your views during deliberations are attributes, or some of the attributes that I experienced firsthand in the various cases that I sat together with you in the SCA. Would you care perhaps to comment on that if you so wish?
Yes, thank you, Deputy President. I have had enormous benefit from the time that I've spent in the Supreme Court of Appeal. Admittedly, it's been a time when we have had to operate entirely virtually, and so some of the collegial relationships that one would ordinarily wish for are not capable of realization in the standard way. But I have learned an enormous amount about how appellate work is done. And in that respect, I've found that there has been enormous assistance that I have received, amongst others, from yourself in showing me the ropes, allowing me to develop within that court. And it is a very demanding court, which pursues its work with great industry, with great acuity, and with very, very speedy results. And all of that is a highly pressured but extremely valuable experience that I have learned an enormous amount from. And it is the way in which colleagues prepare for the cases they hear, the way in which the proceedings are conducted with, for the most part, great economy, but incisiveness in getting to the answers that matter for the purposes of resolving the dispute. And then the interplay between colleagues, firstly in conference in trying to get to where everyone stands on a problem and the robustness of those engagements, but also the discussion that takes place. And one of the signal features I have found is that sometimes the debate is robust, but everyone's desire is to get to a judgment, which is the best possible articulation of the answer that the court believes in. And sometimes there's a dissent, but whatever, it's to try and make sure that that judgment is fashioned out of the assembled abilities that are brought to bear together. And in that, I have learnt a great amount, and for which I am enormously grateful.
Thank you. The other two questions I had for you are about why you considered it necessary to resign from the Jewish Board of Deputies, and why, when you had acted in the SCA for 2 terms and you're still there, you chose to apply for a position in the Constitutional Court where there are 2 vacancies as against 5 vacancies at the SCA. I'm satisfied with the answer that you gave when you were in response to question put, I think, by Commissioner Gogo, and what you said during your introduction. Thank you very much,
Thank you,
Judge
Deputy President.
Underholder. Thanks very much, Chief Justice.
Thank you, Deputy President. Honorable Breitenbach.
Thank you very much, Chief Justice. I'm covered. Thank you.
Thank you. Honorable Nyambi.
Good evening, Judge.
Good evening.
Part of my question were covered by Commissioner Lamula and Commissioner Mpofu. I'll just ask one. We've asked others that are of your age. If we are spoiled for choice in terms of people that are meeting you in terms of qualifications and everything, and what they can bring at that court, then we happen to have the other candidate that can give us the 12 years. But looking at your situation, is going to be half of that. What will be your comment on that?
Well, I suppose I would say two things. The first of them is that one gets to a certain age and hopefully one has accumulated certain experiences over that period that sometimes have material differences to others who have had less experience in some areas rather than others. So I think that will be for you to assess, which is, yes, I am older than some candidates. The question is, what did I do with the time? And are there things about my experience that would be of value to the court? And that will be for you to determine. There are trade-offs, as in everything in this world, and experience is one of the things in particular areas that can be advantageous, and no two candidates absolutely square up on every attribute that you're looking for. You'll make an assessment. The second is that I think I would have, if 70 is the retirement age, I would have 8 years on the court, perhaps slightly less. I think sometimes there are, as I understand it, but I may be wrong, some extensions of time that can take place for judges such as myself who start late, because I've only been on the bench for just in excess of 3 years. But I'm not certain whether those extensions are possible. I think they may be, in which event I would be able to serve and would be willing to and desiring of serving for as long as I possibly could. I think lastly, to say that the question over is this: over whatever period, whether it's the 8 years or whether it's a longer period, can one make an impact on that court that is going to be of value to the institution? And if you think that I can, I would be honored to try and offer myself for that purpose.
Thank you, Judge. Thank you, CJ.
Thank you, Honorable Nyambi. Commissioner Makelo Debu.
Thank you, CJ, and good evening, Judge.
Good evening.
I see that you have been conferred silk 30 years ago.
I think
Am I right?
I think nearly 30 years ago. In 2002. So not 30, but
Somewhere.
But yes, 20, coming up for 20.
Because I see from the comments of the Bar Council, they actually meant 30 years ago.
I think maybe their arithmetic isn't all it should be.
Yes. So what I want to find out from you, you have been privileged, that we accept, and you have been very active in the Bar Council.
Yes.
And having been in the Legal Practice Council now, and looking back, especially to the advocate's profession, it's one of the professions which is least transformed. And I'm asking myself that, was it not maybe better with your privileged background and access to state work to able to upskill some of the advocates, and how many have you done, have you trained? I'm asking this because we are told that silk don't take pupils. So obviously 20 years of your life, you never took people's. So for me, you haven't contributed to any transformation of the profession. So what can you convince me? How can you convince me that you have contributed? And why are the demographics of the advocate profession still so low when, if I have to entrust you with the Constitution, you haven't done much, according to me?
Well, let me see if I can persuade you otherwise, because I took the question of transformation at the bar very seriously, and let me try and indicate how I did so. The first was that I had extensive use of Black counsel and women counsel in the work that I did. And I've done, and if you wish, you can go and look at the reported judgments of mine, which are obviously just a subset of all the work that I did. And you'll see that there are very large numbers of Black counsel and women counsel who figured in the teams of counsel that I worked with over many years that I was a silk. So that's the first thing I would say. The second thing I would say is that I have a very, very long-standing and ongoing commitment to training within the bar, and I maintain that link even now that I'm on the bench. And to my mind, training young advocates and ensuring that they have the best opportunities to flourish within the profession is one of the absolutely key ingredients. It's one of the things that you can see makes an immeasurable difference to the way in which people progress within the profession. The third thing I would say to you is that within the professional relationships that were fostered through having Black juniors and women juniors as part of the cases that I prepared and argued, there was a mentoring role that took place. Everybody needs someone who believes in them and can help them to reach their potential. And I think that was one of the other jobs that I did within the bar. And then lastly, I should say to you that I did, for a period of time, have a leadership position within the group that I was a member of. And in that capacity, together with other members of the group, we made a complete change to the way in which people were admitted to membership in that group. And if you look in that group at those people below 10 years core, you will see how many Black advocates were recruited to that group. And that came about not by chance, it came about by design. And how to support people who came into the group and how to give them a foundation from which to flourish was one of the things that I sought to do. And so I count among people who are both friends and erstwhile close colleagues, many Black practitioners who today have careers of great distinction. And to the extent that I played some part along that way, I think that is what practical transformation is about. That's what I've done personally. As to the profession at large, I agree that there are huge obstacles to people pursuing their careers at the bar. And there are many ways in which that needs to be greatly improved. I could talk about that if you wanted to, but I think the gist of your question was to say, what did you do? And I've tried to give you an answer to that question.
Thank you. A follow-up question. As you know, the Legal Practice Act, one of its mandates is to ensure access to the profession.
Yes.
What will you say if we train advocates as the council, as the Legal Practice Council? And the challenge that we are having is that the Johannesburg Society of Advocates actually want to exclude the advocates who don't belong to the bar. And for me, the bar is very exclusionary. You can only train about 20, 30, but there are 110, 1,000 kids out there who need to be trained. So what is your view there? Because for me, I mean, this led to the resignation of Advocate Semenya. I mean, for me, it's still a sore, I don't know how to call it, but how do you think we should take this forward? Because obviously the bar councils are refusing to transform. And what influence can you have, because you still have contact with them?
Yeah, I'm not alive to all the debates that have taken place, and so I probably don't have the most nuanced understanding of all of this. Certainly, when I was at the bar, the Johannesburg bar, I think the figures of the number of pupils who came in, and this is just from recollection, but were around perhaps 100 or more, but. I know that Commissioner Mpofu may have more direct information, and there are bars across the country. But I take your point, which is that what the bars will do is that they will take in a more limited number of people and probably give them a more intensive form of training. I don't know whether that's true or not, because I don't know how far the council has the same resources to devote to training over a period of pupillage. So it's possible that the bars are offering more intensive training to a smaller number of people versus a model which would say we can actually get by with perhaps less intensive training for more people. That seems to me to be a policy choice. I take very seriously the fact that people who wish to come to the bar face enormous financial hurdles in doing so. And one of the things that I think needs to be thought through very, very carefully is something that's done in other jurisdictions, which is to help to fund people, particularly over the period of their pupillage and possibly in their first year or two, to try and give them some financial security to make this transition. We don't want the bar to be a place where you have to come from a privileged background in order to get to the bar and then to flourish at the bar. Too many people are disadvantaged in exactly that way. And this is the problem. You lose people of potentially enormous talent and promise because your pool gets too small and it is skewed towards those who can afford to do it. So I entirely understand what you're saying. I think it is, as with all things, a question partly of resources, but partly, as I think you're pointing out, partly of flexibility and a will to change how people get access to the profession and make sure that people who are poor do not face insuperable barriers to being able to come to the bar and flourish at the bar with the kinds of support that I'm talking about. That would seem to me to be a key priority.
Thank you, CJ. I had other questions, but I'll leave it here.
Thank you, Commissioner. Honorable Malema.
Thank you, CJ. Judge, I take it that you support transformation.
I do.
And when you genuinely look at the list of the people who are coming here, who have not had a privilege like you did, and you know that some of them are so well capacitated, they may not have the same education as you, but even with such a poor education that was given to them by the apartheid government, they managed to rise through those difficult situations. And as a supporter of transformation, why don't you just say, guys, let me pull back and allow my brothers and sisters who have worked so hard to be where they are to rise, and perhaps in the second round or so, I may try my luck, because we shouldn't support, and you agree with me, transformation when it doesn't involve us directly. But when it is us who are now involved directly and we stand a chance of going through, we now want to apply the issue of transformation from a theoretical point of view, not because we believe in it since we are involved directly. So I thought someone who support transformation will look at the list we have and say, you know, there are a lot of potentials here. We know we've got that duty, we'll choose the best ourselves. But as an activist and as a supporter of the transformation in the judiciary, you also have a duty to say, thank you very much, I applied, I'm here. But I think that given my background and looking at the list we have here, let me step back and allow my brothers and sisters to emerge. And in that way, you don't have to give this body a difficult job of having to choose between you and those who are less privileged.
You know, I agree entirely that that people who come before you who have had hugely disadvantaged backgrounds and have got to the level of that they have with the achievements that they have is astonishingly wonderful to see. I mean, you know, we celebrate people who can achieve things from disadvantage. And you're correct. I have certain achievements, but I certainly had many advantages in getting there. And you could say, well, that should end the debate. And I take your point also that one mustn't be theoretical about transformation. It's you know, it mustn't be it's fine until it affects you, and then it doesn't. Then it's no, you know, then it's put to one side. I agree. I think though that one does have to give some thought, I do, to what transformation means in its different parts. Certainly one part of it is that our courts must look like South Africa. And that's a key feature of what happens. And I think we've made some progress as far as that's concerned. I think the second thing is that transformation is also about harnessing all the talents of our people and making sure that they are represented in, amongst other places, our courts. But I do also think that transformation is about, it's a quality of your mind as to how you think about the world. And I think there are ways in which transformation works through the kind of chemistry of what you want to do together. And that is not just about saying, well, we must necessarily prefer X over Y. It's about saying, I want to constitute, for example, the Constitutional Court in a way where the larger constitutional project of transformation is best likely to be achieved. I can only say to you, as far as that's concerned, that I see this through the lens of service. You may reach the conclusion that ultimately I can best serve in another role, and I will understand that position. And that may mean I should step back in your judgment. But I think there is also a way in which one can think about constituting a court where the attitudes of mind and the desire to make this court something special is one where I could still be of some service. And it's only in that sense that I would ask you to think about my role.
Judge, let me try to persuade you once more. You see, you come in for 3 years. You find senior judges there who have gone through difficult processes for them to be there. If this is not classical case of privilege, then I don't know what it means. You sit there with the beautiful education you got from a privileged point of view. In 3 years' time, you come and pass all these villagers. You come and pass all these people who have gone through poverty, who have gone to be where they are. You pass them and you go to the highest court and still come back to us and say, you know, privilege is not right. We want empowerment, want transformation, and we must still listen to that. when you couldn't on your own, right conscience, say, there are so many people that I found here who are well qualified. They may not have the same education I have because of the background of where we come from. But these guys have been here. These guys have worked hard for them to be here. And they are not as privileged as I am, because we are going to be heavily criticized to choose a white male against a black African female who has gone through the ranks, who has interviewed so well, but she doesn't have what you have for obvious reasons. She's not from all these things that you are speaking about. They come as a result of the privilege you had. She doesn't have all of that. And in your right state of mind, you say, consider all of this and leave her. And you put us in that predicament instead of saying to us, you know what? I appreciate, and now that you have put this to me, my journey to this, at least for now, ends here. I don't think I must still be considered.
Yes. I think there are two points I would make, and I understand the position that you have. The first of them is, as some questions have already been raised, you can't do everything in a lifetime. And at a certain point you reach an age and there isn't an endless runway before you to say, well, you can come back at another point, because at a certain point you can't. I mean, we all get older, and that's one of the things. So it's not one of these points where if I were coming to you at the age of 50 and saying, I want some preferment now, I could understand that. One can only do so many things in a lifetime. So that's one point. The second is just this: I would never see it really as passing anybody. It's more a question of looking at what I may have to offer in terms of the things that I've done and the things that possibly I can contribute to this court, and saying, some of the candidates who have come before you and have got huge promise and ability will also, in their way and in their time, be able to make the contribution. And you will decide. You might say, well, we want younger candidates who've come from disadvantaged backgrounds to go forward and go forward first. And maybe you will never go forward. And I will appreciate that and understand that that's a judgment that can be made. But I think there's another way of looking at it as well, which is to say, there are some candidates who come, they have some attributes and things to offer. We may want that because transformation is ultimately an inclusive doctrine about how we constitute institutions and how they can operate. And as I've said, we want to have ambitions about the court. We want it to be the crucible of talents. And I would love to give you an easy time in terms of making your choices simpler, but I feel that the nature of your task is the difficult one of trying to work out how that is best done.
Now, Judge, on a different point, do you think that judges being involved in business and having shares in big companies helps to build confidence of the judiciary and enhance its good image? And I'm talking about business and shares.
Yes.
Not bank accounts, like some senior judges were distorting us and not knowing the difference between shares and bank accounts. And coming from senior judges is so disappointing.
Yeah.
And people who are deliberately distorting us and sending us to jail out of deliberate distortion and misinterpretation of what you said. So we're talking shares and business interests, not bank accounts. There's no way a judge can have money in a house. And I would never suggest such a thing as a leader of a political party.
Yes.
So I don't want to go to that level of degeneration. So I'm just asking, at the level of shareholding and judges participating in business, does that help to enhance the confidence and the good image of the judiciary?
Yes, I heard the question that you posed to another candidate, and I've been thinking about it since you raised the question. I think firstly, there's a difference between holding shares and participating in a business. I don't think that judges must do judging. They mustn't be running businesses on the side. But that's not answering your main point, which is the fact that judges hold shares a problem? I think the difficulty that we have, and I'm sorry, I won't have a very clear answer for you, is just this, that almost everybody who belongs to a pension fund indirectly owns shares in businesses. Some people own them directly, and some own them through retirement annuities, and some own them by being members of a pension. You get a stake in companies. So I just don't know what the answer is, because I think judges, like everyone, have got an entitlement to save for retirement and have some security in retirement. But I'm wondering whether there's a way we should think more carefully, following what you've said, about, as happens in other jurisdictions sometimes, that they're put in what are called blind trusts. In other words, you say, here are the assets, I will have no connection to them. A trustee is appointed for the period of my office as a judge. They will do with them whatever they do, good, bad, or indifferent. And when I finally retire, I can either take them out of the trust or become involved in it. When I heard your question, that was the first thought that I had, which maybe that would be a separation of a kind that would lead the person in a village saying, well, I don't want them to have direct interest in shares where maybe that company is then a litigant in court. I don't know if that helps.
I'm happy that there are still judges who hear when we speak. Thank you.
Honorable Moyman.
Thank you, Chief Justice. Just one question from my side, which obviously was prompted by your resignation from the Jewish Board of Deputies. It prompted me to want to get a sense in terms of your views on a two-state solution as a solution to the Palestinian-Israeli conflict. You remember that in 1993, PLO and the Israeli government entered into an agreement to implement the Oslo Accord. So, not much more concerned about your resignation or your membership. That to me is not an issue. The issue is because as a country, in terms of how we relate to our neighbors or to the international global community, our entry point is Africa, and obviously, AU has a position on the conflicts. What's your view on the two-state solution?
Yes, my position on that is that I consider that a two-state solution, although it is now unfortunately one that seems to enjoy much less currency than it did in decades gone by, remains the only solution that I think is both feasible but just in what is a hugely complicated and difficult conflict that exists. So I take the view that there must be a two-state solution, and that people of goodwill should try to find each other to bring that about in a fair way.
Thank you, Justice. Thank you, Chief Justice.
Thank you, Honorable Moyman. Honorable Kaba.
Thank you very much, Chief Justice. Good evening.
Good evening.
Judge. Thanks. You know, Judge, I feel that you just I felt I should just ask this question because it troubles me. Since we have started the interviews, what troubles me is the length of years that the judges spend in their positions. I mean, for example, you were appointed in 2018, and 3 years later, less than 3 years later, you avail yourself for a promotion for another position. Let me not say a promotion, but for another position. And you're not the first one. I think a number of judges that we have interviewed today are in a similar position. It leaves me with a question. If I knew at the time when I was interviewing this candidate that he would not last for longer than 3 years in the position, would I really appoint him over those who commit that they will stay longer in the position? The question is, what is longer? I consider sitting where I'm sitting 5 years to be a minimum period for a candidate to stay in a position. Why I'm saying this, Judge, it's that when we sit here, we appoint people. One, it has to do with the succession plan in the division or in any court. Two, it has to do with strengthening of the court and so on. And then the next person leaves for another position. And then you'll have people coming in and going out, coming in and going out all the time. Does that not affect stability in the division? I don't know, but the heads of the courts happen to be around. How does this not impact negatively on the institution itself? I don't know. You'll be asking on behalf of not yourself, but even the others that have come before us. Thank you so much. Thank you very much, CJ. Thank you so much, Judge.
Thank you, Honorable Kaba. Judge Junta Holter, you want to comment on that?
Well, if I may just comment very, very briefly. I mean, I understand entirely that, rapid turnover of judges who have, an important role to play may not always seem to be in the absolute best interests of the institutions and particular courts. I mean, and your role on the commission is to create the best set of institutions that are possible. That's your mandate. I would just say, as far as my personal position is concerned, that yes, it's true that I've had 3 years on the High Court, with some time spent in the Competition Appeal Court and now in the Supreme Court of Appeal. But I do want to bring to the reckoning the fact that I did spend nearly 8 years in an appellate court. And so I think one needs to, at least in my case, at least consider that I'm not a candidate who's, simply seeking to revolve through the door as quickly as possible. There's the factors I've already mentioned that, had I started a judicial career earlier, yes, I might well be able to progress, if progression is possible, in a slower way. But one has less time, and that's just the concrete position that I can draw to your attention. I should just make one last observation, which is that, of course, to some degree, this body has the power to decide whether people revolve through the door, whether they stay where they are, because on some computation you think that that might be the better place for the courts. So in a sense, you have the remedy in your own hands.
No, you are right, Judge. You see, maybe when we meet on our own, we must really look at this. And I wouldn't mind going to an extent of actually saying whoever we appoint will remain in the job at least for a minimum of 5 years, and still utilize him or her in other courts on an acting basis.
Yes, I understand.
And in that way, you are not losing these fellows' capacity on either side of the on either court. You know, he's in the High Court. You can utilize him in the SCA or Constitutional Court, as it were. No, thank you very much for that. Thank you very much, Chief Justice.
Thank you, thank you very much, Judge Ntahota, again. I apologize for the delay.
Sorry, Chief Justice, I just have one follow-up before he leaves.
Okay.
Sorry for that.
Yes,
Judge,
Commissioner Notice.
Judge, they have greeted you on my behalf. Just one thing that troubles me. Advocate Gcina Malindi, who was once interviewed after he resigned from the ANC as a member, and his resignation was within a year. In this board, he was asked, it was asked if he cannot take a cool off after this resignation. I'm bringing this because you only resigned from the Jewish board last week or today, I'm not too sure.
Well, a little while ago, yeah.
Yes. Would you accept, if in its wisdom, this body, because it's troubling everybody that you only resign now for purpose of this interview, that at least you are allowed a cool off? It's just that it's something that I will argue, but there's no way that I have to give you that, at least to
No,
hear.
indeed. I think there is an important difference because, as I say, I don't think there is any conflict that arises from the membership that I had of the Jewish Board of Deputies. The only reason, as I've tried to explain, that I've resigned is because there could be some perception in respect of litigation that is done that it would be inappropriate for me to be a member. I could just recuse myself, of course, but it seemed to me that there could be some perception that I shouldn't be on a board which is litigating in courts on certain issues. And I don't, with respect, see that a cooling off is going to achieve anything in this regard, because there is no conflict, and therefore I'm not certain that I see the analogy with Advocate Malindi's position.
Thank you very much, CJ. Though that this Jewish board is a sister organization to Helen Suzman, I know majority of those are part of this.
No, there's no connection between the two.
Thank you, Judge Ntahota. Your excuse, sir.
Thank you, Chief Justice.
Thank you. Colleagues, we have Judge Valley waiting. The likelihood is we may not be able to finalize his interview as a result of reported power outage challenges that seem to be looming in the horizon. I don't know if everybody would remain connected until we are finished. I know I'll be connected up to the end. Is there any of us who would be disconnected at some stage?
CJ, can we check if there is generator here?
Okay, what
we're
about
we're
Honorable
fine.
Breitenbach?
Chief Justice, I'll be disconnected at 10 o'clock.
Oh, good, then we can proceed. There's a generator there, Mr. Chilwan, is it not? Is it not so?
Chief Justice, there is a generator here, but load shedding, according to the schedule, is going to be only at midnight this side.
Good, all right. Now then bring the next candidate, colleagues.
Yes.
Without compromising on quality, please allow me to be as strict as I used to be. Some of us overindulge in preambles. Can we cut down on that? Just put your question. You don't have to give a long context. Just put your question. Let the person answer. Let's move on, please.
Chief Justice.
Let's seize this opportunity to finish.
Chief Justice.
Yes, sir.
Yeah, no, I just want to say you are also to blame. I think you're getting soft in your old age. You used to control us. Yeah.
Yeah.
I agree.
Yeah, no, I was overly soft. And I think I just wanted to make sure that the Constitutional Court people get as much time as possible. They are grilled as much as possible. It's an apex court.
Yeah.
With your permission, I'll be tighter starting from tomorrow.
Good. Thank
you. Please allow me to caution you. Don't take offense. No preamble unless it's unavoidable. Stick to two questions and seek permission if you have to go over. Let us just try to be more disciplined, please.
Thank you. Thank you.
You mean for the 23 of us, CJ?
Are you including me?
I was just asking.
No, I'm in charge, man. You can't.
I'm in charge.
I withdraw. I withdraw unreservedly.
I think I must recuse myself for that. Chief Justice, I was to suggest that in most of the time, if through you, we are using a position to cover most of our questions in our introduction, then that may limit us asking even some questions we may even pass. If you cover, because you see the general trend of the key questions on this. I'm just asking if you can't utilize that as well yourself.
Yeah, no, I'll try. But I think it would be good training for all of us just to learn to be direct for today so that come tomorrow we are as direct as we should be. I'll try. I'm not going to keep Judge Valley long. I'll be very brief with him, and I'll plead with him to be very brief as well.
Thank you.
Good evening, Judge Valley.
Good evening, Chief Justice.
Are you well, sir?
I'm still settling in, Chief Justice.
All right. As you are settling in, please accept my apology for keeping you waiting until this late hour.
It's understandable, Chief Justice. You have a job to do. And I appreciate it.
Thank you. Thank you, sir. Why do you want to be a constitutional court judge, and how has your experience, as briefly as you can without compromising on the need to articulate your position, how has your High Court and Competition Appeal Court experience prepared you for this position that you are applying for?
Thank you, Chief Justice. I'm going to try and be brief, and I'm going to have to try and truncate my response. I probably had a slightly prepared response with regard to my biographical details, which I'll try to refrain from speaking about.
But briefly, I was born in Johannesburg in CBD in 1959. I lived there too long, and I then had to move out, and was brought up in Lenasia, and then I went to Wits University. I studied sociology, BCom there, hoping to become an accountant or business person. And then I moved on, I did sociology, and then I moved on, I did other things. I then eventually became a trade unionist, and then I moved on, went back to sociology, and then I decided I had enough and I became a lawyer. So I came a bit late to law. That is a very, very truncated account of my journey. Why do I want to become a constitutional court justice? Let's be direct and brief about that. To start with, Chief Justice, I think I have the academic qualifications that span a few disciplines. I mean, I have a BCom, a BA Honours in Industrial Sociology, a Master's in Sociology, a LLB, a LLM, before I got an LLB, by the way. I did my LLM first. A LLM and then an LLB. So I think I've got the academic qualifications. I gained a good grounding in commerce, but not just in business, largely in economics. I learned economic theory, and I wanted to know economic theory for various reasons because I thought it had an important role. It was important to understand it in order to be able to understand why some people are poor and why some people are rich, why societies develop the way they develop. And I think over the years I've got a very good understanding of that. And that showed in my early writings, not in law, and it came through in my legal work. I also learned a lot in sociology about society. So yeah, I learned to understand how society operates at various levels, how individuals operate in society. And then and then I came to law, and I realized that in law, the skills and knowledge that I've acquired in those two disciplines were invaluable to me. I must say up front that from the very beginning, I was an activist. I was very involved in what we used to then call struggle-related issues and struggle-related work. It's not referred to that way anymore. And so these things were always close to me. I also realized after I became an advocate, that I did work in many areas of law, not so much as an advocate, but more so as a judge. In fact, if you look at the judgments that I've included in my pack, so to say, you'd find that, I would have done work in admin law, tax law, customary, international law, environmental law, insurance law, contract law, delict, competition law, insolvency law, criminal law, estates, law of evidence, in almost every area of law. And I've found that I've made or issued judgments that were quite in depth and that were dense. And I feel that I think I'm now ready for an apex court, having had the grounding in all these areas of law, and also my background in those other disciplines, including my background, including my experience and my involvement in practical issues or practical battles that I was part of in the early years. I think I understand our society fairly well. I think I understand our society understand the dynamics, racial, gender, class. I understand how our political economy works. And I think I could bring that to bear to a court which is going to deal with many of these issues. So I think I'm about ready. I'm also at the age where I think I can now make that contribution. I think I'm matured enough now. So yes, I would say that is what made me or inspired me to apply. I was also prompted to apply by some of the people that have nominated me. and have asked me to make myself available. That would explain in very brief, CJ, why I think I would be an appropriate candidate to be considered for the Apex Court.
Any reason why you didn't consider the Supreme Court of Appeal?
The Supreme Court, for a start, the Supreme Court of Appeal's advertisement wasn't out when I had actually applied for the Constitutional Court. I think that would be the short answer. Because I don't know, or may be wrong, I don't know if there was any advertisements for the Supreme Court of Appeal. Remember, I've applied for the first vacancy and the second vacancy. So I was already shortlisted for the first vacancy. And I'm not sure, but if I am, I may be, when I stand to be corrected, CJ, on that question. And having been shortlisted for that first vacancy, I think it just, which we were then supposed to have interviews, I think, about a year ago.
Yes.
Yes, and I think it then just took its own life. You know, we just went on.
Which judgment or judgments, without going into detail, would you say are demonstrative of your suitability for the Constitutional Court vacancy?
Did you say judgment? Did you say only judgment?
Judgment or judgments? Which ones would you say stand out and they show that you belong there?
The Silicosis judgment, which I penned together with Deputy Judge President Mujapelo. Atlantis, which talks about contracts and constitutional law and the interplay between them. The law of evidence, which talks about expert evidence. In fact, that particular judgment received approvals in the Supreme Court of Appeal. The tax judgment, which talks about international tax treaties, that particular judgment, I must say, has been, and I've said this in my previous interview, with Judge Davis being present when he was one of the parties, he was aware of it because he was in the seminar. That judgment was a source of seminars held in certain international tax conferences, and he was at those conferences. In fact, he's now told me that he uses that judgment as a specific topic for his lectures on tax. So yeah, those are four. There's a lot more I can say, but those four I think are are quite detailed, and I'm more than willing and happy to discuss them in detail. At least if I have them with me here somewhere.
Yes. Colleagues, any questions to Judge Valley?
Yes, Chief Justice Jenny Kane.
Ingela Schlemmer.
Who else? Which other colleagues have questions?
Lamula suggests.
Mpofu.
Lucas.
Tepe.
Thank you.
I might have jumped someone. After Commissioner Singh, Mpofu and Tepe, did I skip a colleague?
Lamola.
You can come before the minister.
And Lucas.
Any other?
I don't know whether you got Schlemmer.
Okay, thank you. All right.
Deputy President,
if you heard me, Lucas.
I've got you, Honorable Lucas. I've got you, DP. Commissioner Kane. Commissioner Kane.
Yes, Chief Justice. Good evening, Judge. I, as you know, represent the Advocates Profession on this commission, and so I must put to you some comments.
Sorry, I couldn't hear you. Sorry, I couldn't hear you. You represent?
I represent the advocates on this commission,
Oh, yes.
and together with Commissioner Mpofu. Therefore, I'm duty bound to put to you some of the adverse comments that arose in the GCB's review. In particular, I'm sure you would have seen them. That apparently a number of negative comments were received in relation to your unwillingness to deal with the substance of matters, your propensity to postpone opposed matters and to seek avoiding dealing with them. There's an allegation you tend to be abrupt with counsel and that you can be discourteous. Would you please deal with those comments?
Ms. Kane, firstly, it's very disappointing that it comes from a body like that, a body that supposedly prides itself on transparency, openness, and a body that believes in audio alterum partem, or supposedly does. I don't know. None of that was given to me. I still don't know who made those comments and why they made them, what circumstances, what context they made those comments. So it's very difficult to respond to a bland accusation of that nature. But to say that, I certainly must put it up front, that they are untrue. You cannot write the kinds of judgments and the amount of judgments that I've written and say that that person is lazy and has not been working in the last 8 or 9 years on that bench. I have my judge president here. I've never heard him ever once call me and say, you've not dealt with certain matters, you are avoiding matters. He's probably done that. And he always raises it in meetings. He's never ever once called me that. I've never had anybody say, you've not dealt with a matter. Stop. Does that mean I've never postponed a matter? Absolutely not. Have I postponed? Yes, but never without good reason. Some of your colleagues, Ms. Kane, with greatest of respect, don't show respect to the court all the time and don't come prepared all the time. And you know you're going to agree with me on that. And if they don't do that, then their matter can't be heard properly, cannot be ventilated properly, then I will have to postpone them. But a matter that's ready and ripe to be heard, I will most certainly do so. Ms. Kane, I must also ask you to have a look at the judgment I've given in my pack called Moropa versus CINPF, in which I make comments. I think that comment probably applies to the chairperson of the GCB. So in the paragraphs 1 and 2, it's called preface to the judgment. And it talks about conduct of counsel. And I hope you've read it and you can see what I had to go through. Not me alone, many of my colleagues have to go through that kind of stuff. To say that I've run away from work is completely untrue. To say that I've been discourteous, I don't know when they say that and what they mean by that. I can certainly be tough in court. I can tell you up front, Ms. Kane, my court is most certainly an intellectually challenging place to visit. You need to come there prepared, and you need to come there knowing your stuff. I certainly will challenge you. And sometimes people think they senior counsel, sometimes it's even junior counsel. They can too. They can be obstreperous. They can be difficult. And you need to sometimes control your court. You need to take a firm hand. Let me also say this. Sometimes they bring their own clashes between each other into your court, and they don't allow your court to run properly, and you can't allow that to happen. You can't allow them to interrupt when their opponent is speaking. You can't allow them to be disrespectful and discourteous to their opponents, and not necessarily discourteous during the proceedings, but discourteous even before the proceedings, as is referred to in their judgment. So I'll ask you to look at it, and I certainly say to you, Ms. Kane, with the greatest of respect, that that is just not true, and I would appreciate it. I must also tell you that Group 16 advocates have sent a letter. I don't know if you've seen it. I've got a copy of it. It was not put before the JSC, so an oversight on my part. I should have responded, and I should have included that response. But I tell you what they say. They say that, and this is the entire group, they say that their experience with me is completely the opposite to what has been said in that comment, and they dissociated themselves from it. This letter was actually addressed to this commission, but it should have been brought to this commission by myself. I didn't do so. There's a letter by Philip Mukwena, SC, who also is quite strong about it, And then there was supposed to be a letter but hasn't come through by Mr. William Mokadi SC. So there are some people that don't agree with what the GCB says. On whose behalf the GCB has spoken or who told them those things, I don't know. I can simply say to you, it's untrue. I can't take it any further than that, Muscaine. And I would, if you want me to, I would appreciate it if you can help me out with some of those things. Some of my concerns that I've just put before you, Muscaine.
Thank you, Judge. The purpose of putting the comments to you was to give you the opportunity to comment on them. I don't have any further information which I can put to you. Thank you, CJ.
Thank you, Advocate Kane. Honorable Minister.
Thank you, CJ, and good evening, Judge.
Good evening, Honorable Minister.
Yes, I see here the judgment you have delivered on the Mugabe matter, the Grace Mugabe.
Oh, the customary international law matter.
The Democratic Alliance versus Minister of International Relations with regards to immunity and issues of their diplomatic immunity and so forth.
Yes.
My question is it your view that issues of diplomatic immunity and extraditions are polycentric and political issues that should be handled at with the level of political sensitivity that the executive has access to in most instances?
Thank you, Minister, for that question. I'm going to give you a direct answer, but I also can, if you want me, time is not on our side, but I'd like to even talk a bit more about polycentric issues, because I've been involved in cases representing government where that was fundamentally a concern of government, and I'll talk about that in a second. Was that particular issue one that was polycentric? No, it was not. And if it was, I would without hesitation say so and say this is not a matter for courts. This is a matter for the executive and the legislature. It is important that the courts don't usurp the powers of the legislature and the executive. I believe that. I also believe that courts must show due deference to those two arms of government. But that doesn't mean that when parties come to the courts and say rights have been violated, that we mustn't, by the executive or even in some cases by the legislature, that we mustn't adjudicate. What we must do is make sure that we remain within the constitutional mandate that is given to courts. And in that case, the person who happened to have been allegedly assaulted felt that she wasn't given justice, and she was then represented by a group of people who may have their own reasons for representing her. I don't know, and it's not for me to get involved in that. And they felt that she was denied justice. And then the Minister of International Relations, I can't remember which minister it was asked to explain how and why she should not be brought, or how and why she should not be brought before our courts, and whether the diplomatic immunity complied with our constitutional precepts. I found that in terms of the law, the diplomatic immunity did not avail the wife of a president for the misconduct or for the misconduct or criminal conduct that she was accused of. And I gave my reasons very carefully. And I was hoping they'd apply for leave to appeal, but they chose not to. And it's a pity. I mean, if I was wrong there, that was one of the cases I would most certainly have granted leave to appeal. But I don't believe it was a polycentric issue. It was not an issue that the executive has special information and has special role to play in, which courts are completely incapable of doing. The executive was accused of not performing its duties and of not providing good grounds for taking the action it took. And unfortunately, while we have the separation of powers, Our constitution has mandated the courts to look into that kind of conduct or any complaints that come up. And that's all we do, or that's all we should do. There are allegations that we do go beyond that. And if a question comes to that with specific examples, I'll deal with them. But no, all I did was applied the customary international law, which the very minister claimed she was applying. And her interpretation, she placed it before court and said, this is why it is what it is. And I said, no, but it's not right. And we looked at the law and she's accepted. I don't believe it was in any way interfering with or stepping on the shoes of the executive in that matter.
Thank you.
Thank you, Mr. Lamola, Minister Lamola.
Honorable Singh.
Thank you very much, Chief Justice, and good evening, Judge Valley.
Oh, good evening,
Good evening, Chief.
Commissioner
Yeah,
Singh.
I'm on virtual, yeah. For my own sake, in my basket of attributes, when one is appointing a judge at whatever level, and more especially at the Constitutional Court level, is a question of experience at that level.
Yes.
Now, I think you might have read what the BLA, Black Lawyers Association, have said.
Yes.
They refer to your mark of diligence, which is great, but they also say
I don't want to disrupt your thought, and that is very contrary to what the GCB says and what every other person has said. But thank you for pointing that out to me.
Yeah. Okay. They refer to your mark of diligence, but they go on to say that you have not acted in the Constitutional Court.
Correct.
And you should be first given an opportunity to do so.
Correct.
How would you mitigate those comments in respect of the
how would you
appointment
respond?
you are seeking?
I think that's a very fair comment. I think the PLA has my best interest at heart when they make a comment to that effect. I know people in the BLA. I know what they're interested in, and I know that they are concerned about these, about transformation and about giving people opportunities. But I also know that the BLA for a long time have taken the attitude, and rightfully so, that sometimes people are not been lucky enough to get the opportunities they should have been given, but that does not in any way disqualify them. And in this sense, the PLA took a different view. I understand it, I appreciate it, but I have to slightly disagree with them for a number of reasons. One, if I have to wait for acting, I've been now a judge for 9 years. I've been involved in all kinds of issues. I came to law a bit late, but I chose to be an activist. I chose to do other things before I come here. And unfortunately, that has impacted on me. Those are choices I made. I don't regret them. And if I wait any longer, then the Constitutional Court will certainly not, will no longer be available to me. I think I'm 62, I'm turning 62 in a month's time. So if I have to wait another year or 2 years, I mean, by then I'll have very little years to give to the Constitutional Court. It's unfortunate I didn't act there. It's unfortunate I didn't even act in the SCA. I'm 9 years on the bench. I didn't do that. It's unfortunate. It just didn't happen for me. It's one of those things in life. I've moved, I've accepted it, and I wasn't able to get the acting experience. Now here comes the nub, the final point I want to make. The question to be asked, and which I ask this body to look at carefully, is, am I capable and competent to operate in that court despite the fact that I was not able to act either in that court or in the Supreme Court of Appeal? I sit in the Competition Appeal Court. I preside in 3 bench appeals in our court every term. Maybe not every term, but most terms. My judge president is present, who allocates those work to me. So I sit in complicated matters. I've delivered judgments